Hearing of the Senate Economics References Committee into micro competition opportunities in e-conveyancing. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present, and I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via teleconference and in person. I believe we have Senator Matt Canavan on the line. We also have Senator Dave Sharma. Dave, are you there?
Yes, I'm here, Chair. Thank you.
Terrific. And I think we have Senator O'Neill, who is also going to join us, but she may be on the line already. I think she may be joining us in person. We also have Senator Lisa Darmanin, who is the Deputy Chair of the committee, and Senator Dean Smith joining me. My name is Senator Jane Hume. These are public proceedings being audio streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It's also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. The Senate has resolved that an officer of a department or of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind senators of their obligation under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. And I now welcome representatives from PEXA. We might ask you to come up to the desk. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. Before we begin, and I ask you to state your names, I should, for the record, so there is no perception of a conflict of interest, state that a former staff member of mine from the last Parliament now works for PEXA, but I was pretty mean to him during the last sitting of Parliament, and I don't see why that should change now. No one got that joke other than him. For the Hansard record, will you please state your full names and the capacity in which you appear? We might start down with you, Ms. Camilleri.
Kate Camilleri, General Manager, Industry, Strategy and Delivery.
Claire Gill, Chief Regulatory and Corporate Affairs Officer.
Hi, I'm Russell Cohen, CEO and Group Managing Director of PEXA.
Hi, I'm Liz Worrell, I'm the Acting CFO.
And Eglantine Etienne, I'm the Group Chief Technology Officer.
Thank you all very much. And I invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions. Just before you start your opening statements, I did hear someone else come on to the line. Can I ask who else is with us? We already have Senator Canavan and Senator Sharma.
Hello, Chair. It's Senator O'Neill. I'm just caught in traffic. I'll be there shortly.
Fantastic. Thank you, Senator O'Neill.
Thank you.
Who from PEXA would like to make an opening statement? Mr. Cohen.
I'll be doing that. Thank you. Thank you all for the opportunity to appear before you today. As I mentioned earlier, my name is Russell Cohen and I am the CEO and Group Managing Director of PEXA. Joining me today, I'll just recap, is Liz Worrell, our Acting Chief Financial Officer, Eglantine Etienne, PEXA's Chief Technology Officer, Claire Gill, our Chief Regulatory and Corporate Affairs Officer, and Kate Camilleri, the General Manager of Industry, Strategy and Delivery. PEXA started as a cross-government initiative before the decision was made by state governments to sell the business and its valuable intellectual property to new private owners. All of the original investors, notably the state governments of Victoria, New South Wales, Western Australia and Queensland, benefited substantially in the form of excellent returns on this initial investment. In 2021, PEXA was then listed on the Australian Stock Exchange. PEXA's success is based on a unique world-first innovation where we digitised the paper settlement and lodgement process for property. PEXA's solution introduced greater efficiency, security and usability into property settlements and has been taken up by financial institutions and more than 11,000 conveyancers and lawyers throughout Australia. and delivers a customer satisfaction rating that consistently sits at around 90%. Since its inception, PEXA has been heavily regulated. It is important to recognise that the architects of electronic conveyancing at the origination put customers at the centre when designing this regulatory framework. The rules ensure operators in the market are price regulated and service level regulated and have a structurally constrained business model. This is a significant regulatory environment for a market worth around $330 million, far more heavily regulated than other companies with comparable market shares in far larger markets. I table a copy of PEXA's statement on e-conveyancing misinformation for the committee's reference at this point. Today we employ more than 900 people across Australia and the UK, and since inception have processed more than $5 trillion worth
Just
of...
before you continue, Mr. Cohen, is the committee happy to accept that document? Do you want to have a look, Leslie?
Is that last night? Was this the one that was emailed last night? Or is this that's correct.
Yeah. That should be fine. Thank you.
Thank you. Today we employ more than 900 people across Australia and the UK, and since its inception, PEXA have processed $5 trillion worth of Australian property. All Australians should be proud of the fact that we have built in this country a world-first and leading digital property settlement and lodgement platform. We are proud of the PEXA e-conveyancing platform in Australia. We've maintained strong cybersecurity, successfully defending the platform and its users against more than 6.5 million intrusion attempts in the last financial year alone. We operate under a robust regulatory and pricing oversight regime through ARNIC. We are highly reliable, minimising any service disruptions. We have kept costs low for our users, with our fee representing just $140 of the typical $40,000 transaction costs of a home sale. We continuously innovate to enhance user experience. And with regard to reliance, PEXA is classed by the banks in Australia as a materials supplier, and hence is reviewed under APRA's Prudential Standard CPS 230 in line with each bank's respective governance and compliance program. The technology underpinning the PEXA exchange is a highly available infrastructure designed to ensure PEXA can exceed the model operating rules as defined by ARNIC. And it's related to business continuity and disaster recovery, with enhancements coming into play this month that will enable the system to be restored to service availability within 4 hours in the event of a disaster. Looking ahead, it's crucial that any changes to our sector build upon rather than diminish what has been achieved. The PEXA platform represents Australian innovation at its finest, creating jobs in Australia, generating wealth in Australia, and servicing the public interest with distinction. My observation, after 6 months in this position, is that the commentary on PEXA's regulatory and competitive environment is, on the whole, not related to how we operate or serve our customers, but rather on how we were privatised. I am concerned that often these issues are conflated. PEXA was sold to the market with valuable intellectual property and has built a system that serves Australians exceptionally well. To conclude, I want to emphasise that PEXA's success is Australia's success. The digital transformation that has been achieved in e-conveyancing showcases our national capability to lead in technology innovation. We support competition that is focused on the customer and supports investment and innovation and does not encroach on PEXA's intellectual property. The dedication and commitment of each person at PEXA to our customers and our world-class network gives me absolute confidence that Australia can continue to lead the world in this space. We would now be happy to take your questions.
Thank you, Mr. Cohen. I'm going to allow for 10 minutes to each senator to ask questions, but we're going to start with Senator Smith.
Thank you very much, and thank you for your participation and your submission. Just for the sake of the committee's work, can you explain to the committee how PEXA is supporting the 2 projects that are underway currently by ARNIC? The first is the review of the functionality requirements for interoperability, and secondly, the updating of the cost-benefit analysis.
Yeah, thank you. So we've participated in both of those. We've met with the representatives as assigned by ARNIC on both those projects. The functional review workshops were held together with PEXA, I believe, last month, and we have fully participated in those. And with respect to the cost-benefit analysis, we participated and engaged with the consultants assigned by ARNIC just last week.
And when do you expect those 2 reports to be available to ARNIC?
Well, I believe ARNIC is generating the report and they've targeted October as the timeframe.
Right. And will PEXA cooperate with the recommendations of those 2 reports?
We'll have to read the reports, obviously, before we can give a definitive answer. I'd like to share that we've cooperated at every step of the way with interoperability. We've met all of the deadlines as asked by ARNEC. We've committed significant resources and cost over the last 4 or 5 years of the interoperability program. We spent over $20 million just internally with PEXA on the interoperability regime. So, yeah, we have always been willing to cooperate, and we will do so in this cycle as well.
In its submission, the Australian Institute of Conveyancers proposed a possible way forward, and the first recommendation in that way forward was to mandate interoperability. Does PEXA agree with the Australian Institute of Conveyancers?
I will ask Claire Gill, our Chief Regulatory Officer, to answer that question.
Sorry, I just had a look at that one last night because it was just posted. So in relation to what the recommendations are, we're going to have to look at them as a whole. We're not agreeing to anything at the moment until we actually see all the details, what comes out of the ARNEC review as well, because that might be different. So at the moment, we're not committing to any path forward until we actually see and have a look at the implications on our business.
Thank you. Perhaps you might want to review the submission and provide any additional information to the committee on notice. At page 3 of your submission, it says PEXA remains open to other measures that might promote competition in e-conveyancing. What are those other measures?
Would you like to say that?
Yeah. Pardon me. Well, we're having a look at, we're internally going through the process at the moment, having a look at the other measures that have been proposed through the cost-benefit analysis, although there aren't a lot of detail, so we'll be seeking more detail on that. There has been a proposed, we're having a look at the practitioner first model, what that means, and trying to understand it, and we will be moving forward and engaging with simply in relation to that, but we're working through a process there. We're also having a look at some other models that have been proposed, so we haven't actually definitively landed on something because all these new proposals have just come through the cost-benefit analysis, but we are looking at what might be able to be worked through because we have committed to interoperability. Unfortunately, it hasn't evolved as the way that we understood it to be, and there have been issues with it. So we haven't closed the door to anything, but we are actually looking at anything, but we can't definitively settle on anything yet.
So what is the misunderstanding between what people thought interoperability would deliver and what PEXA is expecting it to deliver?
Yeah.
What is that gap?
Yeah, so interoperability at its origination really spoke about two networks sitting side by side and being interoperability on the lodgement stage of e-conveyancing. Over time, the scope dramatically expanded to include other components of e-conveyancing today, notably the settlements piece. So if you imagine the PEXA transaction, typically today on the purchase and sale of a property in Australia includes both the settlement piece, which is the financial piece, the routing of funds between the buyer and seller and their banks through the Reserve Bank of Australia, and then the lodgement piece in each state and territory with the relevant land title office. It also includes integrations with the State Revenue Office for the remittance of stamp duty. So there's quite a complicated set of interfaces and transactions there. The initial interoperability scope was focused on lodgement, which is ARNEC's domain. Where the scope has gone is to encompass the whole thing, and that is precisely where it has become increasingly complicated. A lot of the settlement-related features, so on the financial flows, is the intellectual property that PEXA has built over the years to service financial institutions, and that is the challenge with interoperability.
Could you characterise that as a regulatory gap?
I'm unsure if I'd characterise it as a regulatory gap, but it's definitely a gap between the scope of the project and how holistically e-conveyancing has evolved over the last 10 plus years.
And why would PEXA object to the financial settlement gap being closed?
We wouldn't object to it being closed in the case of a other network, a second network, a third network, building similar functionality to serve their customers, in this case the financial institutions. But a lot of those functions and features and interfaces are the result of PEXA's intellectual property, building that software and that code and those interfaces over many years. It's not part of the regulatory domain, but it's required to successfully settle and lodge a property in Australia. And so our objection is really on encroaching on that intellectual property, which our shareholders paid handsomely for at the time of IPO. And so that's really, our feedback on the scope over time has morphed from just lodgement through to this large encompassing thing.
At page 19 of PEXA's submission, it identifies customer innovations under three categories. First category is for better experience and greater efficiency. The second category is features to improve security. And the third category is tailored operational information. On a scale of 1 to 10, can you characterise for me whether the auto balance, limited settlements, ready to book, mobile signing, PEXA projects or complex settlement support, which are the innovations you've identified in your submission, on a scale of 1 to 10, 10 being world-class, out of this world, really high value innovation, and 1 being innovation that would be the normal course of enterprise product development, having some value, but not necessarily patent-worthy or innovation. And then, of course, in the second category, you identified 2, PEXA key, solicitor mortgage, dislodge authority. And in the third category, you identified PEXA planner and PEXA transfer. Now, I'm going to ask other witnesses the same question.
Sure.
So perhaps at a high level, you might just, for myself and other senators, give us a sense of the innovative value of those and perhaps on notice provide more detailed information. Is that suitable, Mr. Cohen?
Yeah, that's suitable.
Great, yeah.
So I'll give you my initial view and then we'll provide some
please,
thoughts on notice. So with respect to how innovative they are, certainly for our customers in Australia, that we have collaborated to meet their requirements and built these solutions and to enhance the success around settlements and lodgement so that they can happen on time and on the day, I regard them as very innovative. On a scale to your question of 1 to 10, it's very, very hard to judge because to our customers, they meet their requirements, they do so successfully and securely and reliably. And so for me, that is a definition of very good product development. So that's how I view them. We can take your question on notice to give specific feedback, but many of those are very specific to e-conveyancing in Australia, and so I regard them as highly innovative in the regulatory regime within which we operate.
So are they patentable?
I have to take that on notice. Yeah.
Can anyone at the table?
We don't have a patent at the moment, but as you would...
But a patent would demonstrate great innovation, great value of the innovation, would it not?
There are many ways to value innovation. We have a lot of intangibles on the books because the intellectual property was sold to the market, so it is valued when it was privatised. So it doesn't necessarily have to have a patent to be protected and be recognised as innovative. But yes, patents are one way.
Are they the sorts of innovations that you would export to other markets?
In some cases, yes. We think where e-conveyancing or where conveyancing goes through a digitisation journey, a number of those innovations would be relevant. But it would depend on the regulatory environment, the financial services flows and how the property system was set up.
In June 2024, ARNEC announced that the interoperability program would be paused because the banking industry had raised issues in relation to the interoperability program that were beyond the remit of states and territories to address effectively. What were those issues?
I might ask Claire Gill to take that question.
My understanding, you'll have to ask the banks in detail, but the banks had concerns with the functionality in relation to what they wanted was that the functions that they integrate into the PEXA, they wanted any other LNO to have functionally equivalent status, and that's where we've opened up some of the concerns.
So how was PEXA cooperating with the interoperability program?
So PEXA's cooperated extensively. We've met every milestone. We've attended, it would be dozens, if not hundreds of workshops. over a number of years. So the full cooperation has been there since the beginning of the program.
Did PEXA interfere with the bank's ability to engage with ARNEC over that interoperability program?
No, I think that's possibly a mischaracterisation of the way in which PEXA had asked the banks where there was specific information related to functionality that existed between banks and PEXA that PEXA had built, that the banks direct ARNEC to PEXA to answer those questions.
And how did PEXA communicate that with the banks?
I believe via written correspondence.
Can you table that correspondence for the committee?
We've already sent it through to the
Great.
committee with the redacted details of the person it's sent to.
Thank you very much. Okay, yep.
Thank you. You have talked a little bit about this in your written submission, but I just wondered if you could, perhaps for the purpose of putting on transcript, just talk a bit about how you think having almost a monopoly on this service serves consumers, particularly with respect to costs and service choice.
Yeah, so I think it's worth sharing a bit about the regulatory environment within which PEXA operates, because I think that might go to the heart of your question. So PEXA today exists with a number of very strong consumer protections. So PEXA is price regulated, and our fees, which are determined and approved by ARNEC as our regulator, are only permitted to rise by CPI each year, which means in real terms, PEXA's fees have not increased more than inflation in over 10 years, Senator. Secondly, there are service level obligations, so by which when the technology needs to be available, and reports on that availability and reports on incidents around the availability. We also have a series of customer service obligations in New South Wales in relation to answering calls and call handling time and certain metrics like that. With respect to the settlement of funds that I spoke of earlier, because that flows through national payment rails and the Reserve Bank of Australia infrastructure, we also have certain obligations and a regulatory framework there around payments. And PEXA is also classed as national critical infrastructure by the Department of Home Affairs, and we have certain obligations there around the maintenance of our system and also in relation to cybersecurity. So I think the regulatory environment is quite robust and serves the consumer interest in Australia quite well.
In terms of the regulatory environment and all of the detail you just provided, if you don't meet those obligations, what happens and who are you accountable to in terms of enforcing them?
Yeah, so there's a variety of people. I mean, so first of all, there's ARNEC as our regulator. So the model operating rules lay out the certain service level obligations, the certain ways in which the platform needs to perform, and there are a range of penalties that may be applied to PEXA should they not meet those obligations.
I'll answer that a bit further. So in relation to the model operating rules, if we don't meet a certain service obligation, they can give us remedial direction to improve upon that. In relation to having a look at our compliance, we submit a report every year, and then we're given a letter back in relation to whether they believe we're complied or not. They do have the power to not approve our continued operating licence, but also in relation to New South Wales, they have enforceability in relation to fines as well.
In New South Wales only?
Yep.
What about other states?
No, not under the model operating rules.
Okay.
Have you been in fines?
No.
And what enforcement action's been taken?
We have received a potential non-compliance notice, but not actually given a full non-compliance. We're currently in discussion in relation to whether that was considered non-compliance or not.
Thanks. The New South Wales Productivity Commission has raised some concerns about the transparency of your pricing. I know you've talked about that they haven't changed and that you've got a strict cap, so to speak, but the Productivity Commission in New South Wales did question whether the banks are charged less than conveyancers. So can you confirm whether all participants are charged the same fees for the same services?
Yeah, we can confirm that. All participants on the PEXA platform across Australia are charged exactly the same fees and services, regardless of where they're based or the size of their volume of their transactions on PEXA today.
Okay, thank you. In terms of the operability questions, so in your submission, you've talked about there being significant technical, legal and commercial obstacles to interoperability.
in your statements earlier, you talked about the concerns, particularly around settlement and the financial technology and the IP related to that. My understanding is that interoperability operates successfully in sectors, particularly that's relevant here in banking. So can you just explain why is it different in this circumstance that interoperability is an IP issue for you in terms of financial settlements when it operates in the banking system? And why should e-conveyancing be treated differently?
Yeah, so I'll start and perhaps Claire can add. So interoperability conceptually speaks of more than one network talking to another network. Interoperability, however, as conceived in the program specifically here in e-conveyancing in Australia, was not designed as such. It was designed with what was called a responsible ELNO and a participating ELNO, which effectively fused a smaller network to a bigger network, which meant that the smaller network was reliant on functions and features that the bigger network had provided or had built out. So the situation we have in Australia right now is we don't have a set of equivalent pieces of infrastructure with the same product definitions, the same geographic scope. And so it has made the two networks dependent upon each other and one reliant on the other, and hence that is the intellectual property that we believe is being encroached upon in the design as contemplated.
So, okay, so is it the financial, like the systems one, can you just kind of go into a bit more detail in terms of the financial, the ELNO and the other systems that you're talking about? Is it that they're not equivalent size, in which case you can't?
Yeah. So on the lodgement side, there is an equivalent product coverage on a jurisdictional basis in Australia. So if you imagine in each state, PEXA has digitised the available property instruments in each state and territory well above 90%. So what was ever available in paper is now available in digital, way above 90% in terms of product availability. That is not the case in Simply. So on the lodgement side, Simply is reliant upon upon leveraging PEXA's digitisation, let's say, with each land registry. If we move over to the settlement side, it's earlier the point I made specifically with our intellectual property. All the financial integrations with the banks that PEXA has built over many years is PEXA's intellectual property, we believe. Now, Simply has its own integration with banks, but the banks had said we'd like each customer that's settling a property to have an equivalent experience regardless of which ELNO. And that's where PEXA had felt that they would need to share intellectual property to make that available. And that's the objection we have.
When that decision was made?
Sorry?
Well, when was that part of the interoperability program? When was that introduced?
When the scope started moving to away from just the lodgement, this was a few years back that we realised when the banks actually said we want it to be equivalent, that's where we've said, well, those workflows that, so say for example, auto balance, that's our innovation with our intellectual property.
So what year did that sort of mission creep occur? Yes, could you please?
Senator, 2023, we did two pilot transactions with two of the major banks, sort of so they could see how it would operate. And in 2023, one of the outcomes from that was the bank's view that functional equivalence would be needed to be able to transact in an interoperable environment at scale.
So I suppose what I'm trying to clarify, I'm sorry to interrupt you, Senator Darman, and you should continue, is that the mission creep of the interoperability program began after your listing, not before, because the interoperability program was happening already when you were listing. So it shouldn't have been a surprise to your shareholders that this program was going on. They should have understood at the time that they purchased shares in PEXA from state governments who owned it that there was a potential risk of this occurring. But you're saying that the interoperability program expanded and mission creeped, if you like, later on.
That's correct.
Is that right?
That's correct.
Thank you. Sorry, Senator Darman.
No, that's okay. I'm interested if you have a comment about the public interest question, which is probably, not quite within your, direct domain. But if effective competition is not achieved, PEXA will effectively control data on property ownership, transaction values, mortgages and settlements nationwide. Do you have a view on, the public interest having best served by one single private company that holds this level of market-sensitive data?
Yeah, perhaps Claire Gill could share PEXA's view.
So, sorry, my understanding is that the data is held by the Land Registry's office, etc. We do hold some data, and it's very strictly under all the cybersecurity, etc., and strictly regulated. In relation to whether that's appropriate or not, that really is a question for when we were privatised. Our constraints are around how we were privatised in relation to the intellectual property that was sold to the market, how we were formed. So we've actually got constraints in relation to operating within that environment. That in relation to public interest, we understand that that is something for policymakers, and we make sure that we actually address what our customers need, what our stakeholders need. But in relation to whether that's appropriate or not, that really is a question for policymakers. All we say is that we believe we're a responsible custodian of the data we hold, but also there's a lot of data that's held that is held by the Land Registry officers that sometimes is perceived that we hold it, but we don't.
And Claire, if I can add in there, of course, we also aren't allowed to use that data in any way to monetise it. So we can't, sell that data on, if you like, to make additional profits.
And so in terms of, there's been reference to the CPS 230 obligations that you are under, what's been your engagement with APRA in terms of your approach to this obligation? How have you seen the kind of risks change over, say, the last couple of years in terms of securing data and information and managing the risks?
Yeah, so I think questions on data and risk could be handled well by our CTO, Eglinton.
Yes, thank you very much. So yes, we have seen the risk increasing, and Russell was commenting earlier that last year only we had to stop 6.5 million intrusion attempts. This is very consistent with the pressure we are seeing both on financial market and particularly in Australia. So if you will, we are in the eye of the storm. In the past year only, we've been spending almost 10 million on cybersecurity. This is growing year on year. So we have a series of not only on certification and compliance that we are monitoring, of course, very, very carefully, but we are having quite sophisticated approaches in terms of encryption, segregation of data, classification of our data, etc. So we are still leading that conversation. And now, when it comes to the conversation and the engagement in CPS 230, there is really two things that we have been looking at. So the clarity and the demonstration that our data are well and safely guarded, but as well, how do we recover from the platform from a disaster recovery? So that's the two main things we've been proactively engaging with the bank, making sure that we would reach their own criteria.
Thank you. And just final question. Mr. Cohen, I think you mentioned that you've spent $20 million so far on this project, if we'll call it that. How much of that is, what proportion of that is on legal advice and I guess interactions around your intellectual property concerns?
Yeah, so our total spending on interoperability exceeds $20 million. On the specific amount related to let's say, legal fees or intellectual property, I'll have to take on notice and get back to you. What I can say today is the vast majority of that spending was built on the technology component, the actual workshops and the software development, the code writing, the testing and the pilot transactions that Ms Camilleri mentioned. So the vast majority was spent on the technical feasibility of the interoperability regime.
Thank you.
I have one quick question, which is about the number of outages that have occurred and how each of those outages, which ones you were responsible for, and if you weren't responsible, then who was? So obviously they can be bank systems, registry officers, title officers. There were 90-something or other outages. Can you give me a breakdown of who was responsible for which ones?
Yeah, so I'll start and then perhaps Eglinton can finish. So there's service interruptions. An outage has not occurred, a full system outage in relation to the one what you're describing. You're right, the PEXA network is connected to many, many parties across Australia. Obviously the banks, the land title officers, state revenue officers, the ATO, the RBA. There's a number of interfaces that have a variety of let's say, service quality, standards. About 75% of the service interruptions over the last financial year have occurred outside of PEXA's network. With that, I'll let Eglinton add on some specificity on the data so you can get a sense for the impact on customers.
Yes, so a couple of things regarding the impact. So as Russell was mentioning, 77 are caused by another party in the network. It can be the bank, the land registry, state revenue office. And we probably have, if you want the decomposition, about 50% are related to financial institution and the rest will make, so 25% PEXA, 50% of financial institution, and the rest would be across state revenue office, land registry. Out of that, though, what's important to understand is you were mentioning that there's been 93 different service disruption. What's important to understand is a service disruption can be a couple of minutes and can be a couple of days, including we had one that was going up to 8 days. They don't necessarily have a significant impact. So if I take the example of the service disruption that went for 8 days, which was caused by one of our financial institution partner, 0 settlement was affected by that. 0 transaction could not proceed out of that. So if you will, even if we had 93 different service disruption, out of the 1,200,000 settlement that we're running every year, less than 0.05% are postponed to the next day or impacted by that.
And is it within 24 hours? Is that the maximum disruption that has ever taken place?
We've had service disruption that went on for 8 days, but that still didn't impact settlements because it could be that it's on a small part of a network of one of our partners. And even though there might be an inconvenience, you can still continue to transact and proceed, which was the case in this example.
So nobody has been financially out of pocket because of these disruptions?
Yes.
No one disrupted?
Yes, sorry, can I just say, out of the 576, they probably rolled to the next day. We can't confirm that no one has been not financially affected. We have paid out compensation. Over 10, last financial was over 10 incidents, and that equated to $13,000.
Right, and that was financial compensation paid to people for disruptions for which you were responsible, not for which other organisations or institutions were responsible.
I can't go into, I don't have exact detail of them, but my understanding is it goes to our customer and then they deal with their customer if there was a disruption.
Would having an alternative competitor in the market reduce the chances of those disruptions?
So if there was a parallel network that offered full features and that the customer, in this case the lawyer or the conveyancer or the financial institution was connected to, that transaction was running on, that could have provided a different level of resiliency, but that's not what the interoperability regime or how it was designed. Under the interoperability regime that we've been working on for 5 years, those incidents and those service disruptions that you ask of would have had exactly the same customer impact, given the way that the networks were fused together.
Okay, thank you. I know Senator O'Neill has some questions, and I have also Senator Canavan has a question on the line too. Senator O'Neill?
Thank you very much. One of my questions was along the line that the Chair's just asked, so perhaps on notice, because one of the very loud objections to PEXA is critically the outage issue. So could I ask on notice if it was possible for you to give an idea of how many outages between, say, 2020 to 2025, how long they've been, from the longest to the shortest, who the failure entity was, so we actually get a more clear picture of that, and if it necessary, perhaps provide that in confidence, because we wouldn't want to expose heightened risk to entities such as the registries or the state revenue officers, just to give us a clear picture of what's going on and how this system's working.
We'd be happy to provide that on.
I think that'd give us a better idea about what's going on. With regard to regulation, I heard in your responses to Senator Smith's questions on the way in some evidence that we've acquired just in the last couple of days from the Australian Institute of Conveyancers. They indicate that they're giving a balanced and independent perspective. They continue to argue that interoperability needs to occur, but that there are challenges, and they they set those out later in their submission. So could I ask you on notice to give a detailed response to that particular submission? Because I think everything in it is probably worth responding to, particularly the regulatory design. We're going to hear from ARNEC, and we're hearing that the current governance under ARNEC is fragmented, state-based and under-resourced. This does seem to be a very fragmented system. What is your view about ARNEC as a regulator? You indicated, Ms Gill, that there have been no actions taken by ARNEC, and that is one of the criticisms, that this is a fundamental piece of critical infrastructure that is not properly regulated. What is your view?
In relation, we would say that ARNEC, it would be great if ARNEC was better resourced because it has got a very small secretariat staff. But I'd say behind that, the regulators with the actual regulation, or the enforcement and regulation powers, actually have, you know, a lot of staff behind them. So ARNEC is a council of regulators, so you do have staff behind that, and we do deal with them individually on a state-based approach. The fact that conveyancing is a state-based I suppose responsibility is challenging in relation that we have to deal individually with each jurisdiction, so it does actually make coordinating that difficult. But ARNEC is the body that does that, and to some extent, under the model operating rules, there is some uniformity. We would love, you know, that national consistency to be baked into the rules further, so that we can have certainty around that, because different jurisdictions do take different decisions.
Thank you. I've got quite a few questions. I'll probably put some on notice. One of them is regarding the openness to the access model, or the price regulation model that's throughout all of the submissions, as a different way of talking about interoperability. Why should those alternatives be preferred over interoperability in your view?
I have to take that on notice, Senator. I'm not familiar with that model.
Sorry, can I just clarify? Are you talking about the access regime, the practitioner first model?
Yes.
Yeah. Okay, yes. So I'm happy to respond to that. Yeah. We're trying to understand it in relation to how it operates, as opposed to a practice management software that integrates into it. Information is coming to light in relation to understanding it. So we still don't have a handle on how that may be different from a practice management software that actually integrates directly into our system. Do you want to add to that?
Senator, so the model you described, sorry, I wasn't aware of the name.
Yeah.
It sounds like it's got a few names. It might still be under construction.
Yeah, I think so. And so that's my assessment as well. It's still pretty embryonic. So today, PEXA connects with a number of legal software providers on an API basis. Those are standard machine-to-machine communication, so that PEXA information can populate various legal software packages or conveyancing packages around Australia. That, for me, is largely consistent with this practitioner-first model. The practitioner-first model goes a bit further, as our competitor has proposed it, and in my sense seeks to further entrench or give their own legal software an advantage over other packages, and I think I would have concerns about that if I was another legal software provider. We would rather have consistent access available to all legal software providers in Australia at the same terms and conditions, which is the way the model works today.
Okay.
Just, Senator, I've got two more questions. I'm just conscious of time.
Thank you. So if you could just take on notice, you'd be aware of the work by Catherine Fitzpatrick around safety by design. We looked at financial abuse as a committee through the Corporations Committee last year, and we saw a lot of abuse of different systems. Have you tested your system for that? Are you looking at that?
Sure.
Could you take on notice a question about Queensland? I know there are particular rules that could lead to increased loss of deposit if the transaction doesn't occur in a timely way. I'd like to know from your data if any of those occasions have happened.
We'll take that on notice.
I'm looking at your letter, Arnold Block-Liebler, page 2, 19th of December 2023, where you talk about what you conceive of the interoperability requirement. Is it your view, Mr. Cohen, and PEXA's view, that the agreement that was struck with the establishment of PEXA should not be subject to any further change, despite changes that might happen to the e-sector?
Look, I think I think the regulatory regime around PEXA should continually be reviewed and make sure it's fit for purpose and it's serving the Australian people well. The interoperability regime specifically, and I'm not very familiar with the letter that you speak of because it's before my time in the role. The interoperability...
It's before mine too, but I read it.
Yeah.
We were only aware it was tabled last night.
Yeah.
Oh, okay, this is fresh.
This is
okay.
yes, very
Yeah, this
fresh.
is fresh. So,
Okay.
so apologies, Senator.
It's your
But
letter though, isn't it?
Yes.
yes, sorry. So I was just mentioning the interoperability regime, as proposed, has evolved and changed form multiple times over multiple years, and that is the reason why we don't believe it's fit for purpose today. But with respect to your letter, we'll take it on notice and provide our viewpoint again.
Great. At 6.4 in your submission, you talk about the overall cost benefits of interoperability, and one of the things that I've noted in my reading of the submissions is that there's a articulation that there's the ideal and a pure competition policy, but then the reality of making these things stand up and integrating in a way with the complexity of the system at the back end, separate from, I think you gave Senator Smith, I'm just looking for my notes, comments about how it was designed just for lodgement. Sorry, I was just going to say documents, but lodgement initially. I wanted to give you the opportunity to speak to what the reality of the interoperability dimension is. And finally, and you may need to provide a bit more on notice, is to talk to the PEXA Key app. How much did that cost, and what does that do in terms of cyber risk? Because that seemed to be a pretty interesting innovation to me.
Yeah. So I'll talk about Key first, because I can answer that quite quickly. PEXA Key is a simple consumer-facing app in Australia that enables buyers and sellers of homes to securely communicate with their lawyer, conveyancer, their bank account details.
So they can't get emails that are phishing.
Correct. So it was specifically designed to address that specific type of fraud where people intercept emails or change bank account details or bank account names. So PEXA Key is a secure way to communicate with your lawyer, conveyancer, your bank account details. That's it. It's not to facilitate financial flows. It doesn't facilitate title transfer. It's fundamentally to enable the secure sending of information around your bank account details so your lawyer, conveyancer can prepare the settlement in advance inside the PEXA system. So
Is that something that you wouldn't want to share because you've got IP?
Yeah, it's something
Okay,
we've built.
all right.
I mean, there
That
are a
makes
number.
sense.
There are a number of apps that do the same. That's our version of it.
Okay.
It's a pretty competitive marketplace for secure data apps, but that was our way of meeting our customers' needs.
Okay, thank you.
With respect to interoperability and the business case or the cost benefit that you mentioned, Senator, the reality is that I'm relatively new in the role and I've gone back through a lot of the information. In my view, there was never really a clear business case around interoperability, and I think it was grossly underestimated how complicated it would be and how long it would take. There was a sense that this could be completed by December 2025, and I think that was largely unrealistic once the scope had shifted dramatically and the feedback had come in from a number of parties. We had consistently, as PEXA, consistently raised concerns to ARNEC and various governments around the shifting scope and the shifting kind of management of the program. And so, I think the interoperability regime, which started as a well-meaning intention to enable two networks to sit side by side and share lodgement functionality, has expanded to such a point and such cost complexity and such cybersecurity risk that the cost benefits do not stack up.
So your argument is interoperability at lodgement is the only successful path forward, and the other parts need to remain separate for what security reasons, cost, investment? What's the reason why you think everything else other than lodgement should remain with you in a way that's described as monopoly?
Yeah, so it's not so much that lodgement, it should be the only functionality. It's that the two networks should be comparable in their functions and features across both lodgement and settlement, and then can agree on which information to exchange. Right now, that's not the case. We have a much smaller network with significantly constrained product development and product reach from a territorial perspective. It's not available in every jurisdiction. And then you have PEXA, which is available in 6 states and 2 territories with full functionality. Fusing those two networks together, making one reliant on the other for the full completion of a transaction is our objection, and why we think the cost-benefit analysis doesn't make sense.
Thank you. Thank you, Chair.
Senator Canavan, you have a question.
Yes, you Chair. Clarify, I thought I heard you say earlier you don't sell property data. Is that right?
From the PEXA exchange, we do not sell property data. That is correct. We have two separate businesses that deal specifically in property insights. They do not use PEXA data. They do not access the PEXA data. They do not monetize it anyway. They're completely standalone and separate.
So none of the information you get from any aspect of your transactions is used by those subsidiaries?
That is correct.
Right. So what information do they provide?
One business is called .id that provides population and geospatial analytics to local governments and big retailers. They have their own databases, they have their own data collection sources. A second business is called Value Australia. These are two businesses where we have majority stakes. The second business, Value Australia, provides what's called an automated valuation model. That's an AI-driven model to predict the value of property. Both of those businesses operate completely separately. They do not use any data inside the PEXA exchange or in relation to settlements or lodgements in Australia.
If I may add, Senator, just to clarify, so they use data from the ABS, they use commercially available data. None of it's from the PEXA exchange.
So you don't use, so for example, a valuation, you don't use the price information you'd almost certainly have access to at settlement to help?
No, it's prohibited under the model operating rules.
Right. Okay. All right. Thank you.
Senator Sharma, you have a question.
Thanks so much, Chair. Just a quick one. I think you mentioned that in your submission, in your oral evidence, that 1 in 2,000 transactions do not proceed on the day of settlement because of system outages. Is that correct?
Eglantine, do you want to take that?
Yes, no, that is not correct. So it can happen. So to be completely clear, it can happen that transactions do not happen on the planned day. Actually, it's the case in 25%, but that's not related to any sort of system issue. It can be that one of the participants is not ready. So the buyer, the seller is not ready on that time, and the transaction doesn't settle on the day where it was planned to settle. The number of transactions that didn't settle in the last financial year due to a system challenge, whether it was a service disruption, whether PEXA or some of the network, is the number we gave you earlier. It's 0.05%. So out of over 1,200,000 settlements, 576 didn't settle on the planned date. So that's far less than 1 out of 2,000.
Okay, I thought you said the figure was 0.05%, which is 1 in 2,000, isn't it? Have I got that wrong?
It was 1 in 20,000 we put in our submission.
1 in 20,000, okay. All right, thank you for clearing that up. And then, look, just finally, you talk in your submission about being open to other measures that might promote competition. This is suggesting interoperability is not the one. And you mentioned a ladder of investment approach. What are you open to in terms of other measures that might promote competition in this sector?
Senator, as I said before, we are actually evaluating them because we've only recently been provided with the cost-benefit analysis paper from ARNEC that's actually looking at other models, so we're evaluating them at the moment.
Okay, I think I'm reading from your submission from March, so that's 6 months ago. You're still evaluating it?
Oh, Senator, for me...
You mentioned then that you're open to other measures that might promote competition, so you must have some idea of what those are.
Senator, ARNEC has only recently issued a paper that actually has proposed other models. It was only probably about 4 weeks back where this paper was proposed.
Okay. Can you just elaborate that? I mean, you mentioned in your own paper the ladder of investment approach. What does that entail?
Senator, the ladder of investment approach is not an approach that PEXA is still pursuing. It's something from a number of years ago that spoke to, I think, in a different regulatory environment and certainly in a different cybersecurity threat environment. So it's no longer a model that we are advocating.
Okay. So are there any particular models that you're advocating that would promote competition in the sector?
Yeah. So Senator, I think the best form of competition is when 2 companies or more than 2 companies go out there and compete for customers by offering their own version of a better product and service. which would mean that we need to see a competitor invest at the same rate as PEXA to offer similar functionality, offer their own innovative take on how to settle a lodged property, rather than fusing their network to PEXA and then calling that competition. We think that's the flawed premise behind interoperability as it currently stands. And so a network of similar size and scale and functionality in PEXA where we could agree on what information to exchange would be a good starting point.
Okay. Thank you. Thanks, Chair. I'm mindful of the time, so I'm happy to proceed now.
Thank you, Senator Sharma. Senator Smith has one follow-up question. We're running very behind.
On notice, if you could provide some additional information about the ACCC engagement that you have had. So the e-conveyancing publication talks about some engagement or investigation is too strong a word, but some information that the ACCC has been gathering in regards to the issue, and it also talks about some considerations around national competition policy reforms. If you could provide some information on notice. Also on notice, I'm interested in the ecosystem, the broad experience that sits around outages. So the disruption that a consumer, in the broadest sense, experiences when there is an outage. And of course that outage, that disruption is not necessarily restricted to financial. That's correct, isn't it? I can see witnesses nodding.
Yes, so we will address that. With respect to the information earlier that Senator O'Neill requested as to the length and the quantity of service interruptions, we will annotate on that the anticipated or our historical view on the consumer impact, where there was one or not. Like Ms. Etemble mentioned, in the vast majority of cases there is no interruption. People move into their house on the day, they settle on the day. PEXA has built a number of workarounds around this, but we'll share more with the committee on how that works.
The ACCC chairman has made it very, very clear that the regulatory framework on which the PEXA business is built is flawed. So, Mr. Cohen, is not the commerciality of PEXA built on a regulatory gap supported by an inadequately resourced regulator, and that sits at the core of PEXA's commercial opportunities?
So I think on the resourcing of our regulator, I would concur. I would like ARNEC to be better regulated, particularly on areas.
Be better regulated.
Sorry, to be better resourced. To be better resourced,
and
to be
a
clear.
Regulator. Yeah.
We have many complicated technical matters to talk about with ARNEC around cybersecurity and functionality. We'd like them to be better resourced to deal with those questions and the velocity with which we need to move to keep the platform up to date. With respect to the regulatory gap, I don't have a firm opinion on that. I think the consumer in Australia is well served by the regulations today, as evidenced by the fact that the price of a settlement on PEXA has not changed in real terms over more than 10 years. It's a fraction of the total transaction costs of buying and selling a home. There are other services involved and features involved in buying and selling a home, real estate commissions, real estate listing fees on online portals that have increased dramatically, significantly higher at higher rates of PEXA. There's a whole suite of service obligations that PEXA must meet, and we do. So I think broadly the consumer is very well served by the current regulatory regime. But my one request today, my message today, is that I would like ARNEC, our regulator, to be better resourced so we can work with them in a more holistic capacity.
Any regulatory gaps that should be filled to support e-conveyancing more generally across the Australian economy? We talked earlier about financial settlements.
That's a question that you're talking about from a competition point of view. In relation to the consumer and the long-term interest of the end user, the price is protected, the service levels are protected. So we believe that the consumer is well served by the current regulatory framework.
Senator O'Neill has another follow-up question.
So as you become more efficient between 2014 and 2024, there's been no drop in price. Have you proposed a drop in price, if you want to take that on notice and consider the pricing structure? Any discussions about that? And secondly, with regard to cybersecurity standards, are there any particular cybersecurity standards or certifications that PEXA adheres to? Is that directed by APRA? What are they? How have you gone with that? And finally, has PEXA undergone any independent security audits And where are those results made available either to regulators or to the public? I guess from a consumer point of view, how quickly do you redress concerns raised by users of your system?
Sure. So we'll take several of those on notice, and we'll provide those responses to you. Thank you.
All right, we might have to let you go, I'm afraid. Thank you very much for appearing today.
Thank you.
If you took questions on notice, which you clearly did, the committee asks that those responses are provided to the committee by close of business on Tuesday, the 16th of September. Thank you very much. We will let you go. And I now welcome representatives from Simply.
Thank you.
Thank you.
Poorly designed regulatory.
Yes, terrible.
And erecting total race on.
Yeah.
Absolutely. The commercial being.
That's right. Good morning, Mr. Joyce. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate committee has been provided to you for the Hansard record. Would you please state your full name and the capacity in which you appear?
I'm Philip Joyce, the CEO of Simply.
Thank you very much, Mr. Joyce. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you, Senators, for the opportunity to talk today. My first question is, why should you care about property settlement networks? Isn't this a state issue with no risks or benefits? Well, the truth is every Australian should care because there are three significant issues. Issue number one, the PEXA monopoly means Australia has a massive single point of failure risk in property settlements, an industry that supports every home buyer and seller in the country, $1 trillion settled a year across 4 million transactions. Issue number two, the PEXA monopoly means competition issues, which deny genuine choice to small businesses and blocks tens of millions of dollars of benefits to consumers every year. And number three, there are regulatory and policy failures which has allowed PEXA, the monopoly, and the major banks to block much-needed competition and resilience reform for nearly a decade. To bring these issues to life, I'll summarise how the market works today. All parties to a house sale, which is normally two banks, two conveyancers, they have to be on the same network, be it PEXA or Simply. That is like needing a mobile phone to talk to everyone on Telstra and have a separate mobile phone to talk to people on Optus and Vodafone and so on. That would be madness, wouldn't it? And it would be very costly and complex for customers. But it's actually worse than that. Even if a conveyancer wanted to use Simply today, they couldn't. They couldn't use it for house sales because it is blocked by the banks. To extend the analogy, banks won't accept calls from Vodafone. That's why in 2019, the ACCC concluded that network interoperability in this market was the most effective way to introduce competition. When delivered, it will mean anyone can choose their network and be confident that a transaction will be successful. Telstra phones will answer calls from Optus and Vodafone. That's why in 2022, state legislation was introduced nationally to compel PEXA and Simply to interoperate. However, we sit here in late 2025, no closer to a competitive, resilient market because PEXA and the banks are blocking this reform. In our view, this inquiry is about the role of federal government to better manage an entrenched national monopoly in PEXA, to hold national banks to account, and to mitigate a national trillion-dollar single point of failure risk. Whilst the reforms will be implemented by the states, there are issues here of national significance impacting all Australians. National problems need national solutions. We need action from the federal government to hold PEXA and the banks to account. So, as discussed in the earlier session, what is the impact of a single point of failure? If there was a multi-day outage on the PEXA monopoly today, every single property settlement in Australia would stop. That would mean very real financial and emotional distress and cost to everyday Australians. Without government action, the question is not if a CrowdStrike type multi-day issue occurs, it's when it occurs. At Simply, we are proud to have built a full national network with its own infrastructure and connections to land registries, revenue offices, the RBA and the major banks. We've used modern, secure, world-class technology. Once interoperability is live, if PEXA were to go down, Simply could step in, and vice versa. Simply is a viable solution here, but we are blocked by PEXA and the banks. So why is having an additional secure and viable network important? Well, the Australian government's own Cyber Security Centre clearly states that the concentration on market reliance on a single provider increases cyber risks. Using two networks, decentralising, diversifying, we will deliver more controls, we will deliver more reliability, and will make this trillion-dollar market less vulnerable to cyber and fraud risks. When Optus had their big outage last year, they lost hundreds of thousands of customers who switched to rival networks. They were fined tens of millions of dollars. Those consequences don't exist in our market. To quote the Telegraph article the committee has, an 80-year-old couple were left stranded by a PEXA settlement failure. They said, PEXA don't pay attention to outages because they don't have to worry about anyone taking their business. PEXA customers have no choice despite continued outages. They must remain on the PEXA network. So what does competition look like and why are banks so important? Well, competition means choice. It means lower prices, greater innovation, and importantly, more reliability. It's clear that the banks are failing consumers and small businesses today. They need to play their part in delivering competition and reliability. APRA's CPS 230 standard requires banks to provide continuity of service throughout disruption to their critical operations. It's not clear how they can be meeting this standard with their reliance on processing every single property settlement through the PEXA monopoly. Not only does this present a major risk to the economy, inaction by banks also denies choice to tens of thousands of small legal businesses. ARNEC themselves detail the limitations of their powers to control PEXA and the banks. Unfortunately, we seem to be stuck in a situation where federal agencies say this is a state issue, despite all the evidence and clear requests from the states that federal action is required. The only winner in the status quo is PEXA. The losers are everyday Australians and small business owners. Without government action, this market will be left with a massive single point of failure risk and no competitive benefit or choice for hundreds of thousands of Australians. In conclusion, I would urge the committee to use this inquiry and its report to, number one, acknowledge that the PEXA monopoly is a massive national single point of failure risk. Number two, acknowledge the responsibility of banks and their regulators to support interoperability and in doing so, resolve both the resiliency and competition issue. And number three, recommend federal action to support ARNEC in delivering interoperability, a nationally important competition and resiliency reform. Thank you.
Thank you, Mr. Joyce. I'm going to throw to Senator Smith first, but I just want to ask a couple of questions. The first was one that replicates one that I asked PEXA, which was about at which point the interoperability project had experienced mission creep. It had been up and running since 2021?
Actually, the original idea, yes, I'll comment on that, Senator. We have a very different view from what you heard from PEXA, and it will be a good question for ARNEC, who are talking later. From its inception, the scope of interoperability has always considered financial settlement. The scope has been determined and settled a number of times to include all the data that needs to be exchanged between parties. However,
Settled by whom? Sorry, Chair.
well, it was settled by the regulator, by ARNEC.
Okay, thanks. Okay.
And please ask them in their session later. So we do disagree with PEXA's statements. What does interoperability, may I go into this, Senator? Interoperability at its heart is exchanging data between parties to a transaction. That's it. We're not asking for complicated integration expertise that PEXA provide to the banks. Far from that. We're asking what happens in lots of industries like payments, that the right data is exchanged between parties such that a transaction can happen. E-conveyancing really extends what happened in the paper days. The data points are known. Interoperability really is about allowing that data to be exchanged between networks. So we don't believe there's been any mission creep. But we do know what we've seen is the monopoly really acting in their interest. I think the ACCC have said it a number of times. There is no incentive for them to voluntarily implement interoperability. That's why we're here. We need action.
Thank you. Senator Smith.
Thank you for your evidence, Mr. Joyce. Just some questions I asked PEXA, and you might choose to take them on notice. At page 19 of PEXA's submission, they identify a variety of innovations under 3 categories: innovations for better experience and greater efficiency, innovations for as features to improve security, and innovations which are tailored for operation and my handwriting functionality. On notice, could you have a look at those various innovations and score them between 1 and 10, 10 being highly innovative, world-class, and provide some information on notice in regards to that? Secondly, will simply cooperate and agree to the outcomes of the various ARNEC reports that are currently being prepared, the first being the review of the functionality requirements for interoperability, the second being an updated cost-benefit analysis?
Yes, let me answer the second part first in terms of the reviews, and I'll come back to the innovations if that's okay, and we'll take it on notice. In terms of the ARNEC reviews, we will cooperate and have cooperated in our fulsome way. We will support the recommendations. We are confident that this will be yet another review that concludes and concurs with the ACCC, ARNEC and the New South Wales Productivity Commission's previous reviews that state network interoperability is the way to introduce competition. We propose, I suppose one way I summarise it, Senator, is the pathway here is really clear. I think we're confident on the basis of these reviews, the relevant state ministers will have the right information to empower them to proceed with implementation. But the reason we're here is that needs to be augmented. ARNEC need help. They need help with regulating an entrenched monopoly, and they need help holding the banks to account. I'll come back to your first question. We will respond. A few of the features that were detailed by PEXA, some of those I think are completely, as remarked by the PEXA team, competitive in nature. They don't require the exchange of information between networks. PEXA Key is a good example. But the heart of interoperability, further to my earlier question, is that is blocked unless networks exchange information. And I should say this information is well known and well established. There is no intellectual property here. Simply have never received an intellectual property claim from PEXA. We haven't received it because these are well-established data points and processes, and we have built those features on our platform. They mention a few items that are fundamental to the conveyancing process, such as the use of trust accounts. Our view, which is backed by legal experts and ARNEC, is that interoperability will not require the disclosure of IP. To your point, Senator, we are confident that the ARNEC review will again confirm that. The key issue we're facing here is there's no incentive of the incumbent to design for this. That's why agencies like the ACCC would be important. Again, to reiterate, we've never received any IP claims, but unless we act, we'll continue to see these delay tactics. I think the intent, quite clear from our perspective, is to starve us out of the market. And if that happens, we'll be left with a single point of failure risk and no choice and no competitive advantages.
For an incumbent player, delay is commercial opportunity, isn't it?
Yeah, absolutely. I think we've
and
seen
commercial cost for, well, in this case, someone like Simply.
It is. I mean, in our submission, we detail a catalogue of tactics. I won't draw on those because I'm sure the senators have seen those. In terms of revenue, a simple point to make is every day of delay for PEXA means $1 million of uncontested revenue. We've seen numerous examples in workshops withdrawing from those or giving information late. Unless there's some additional regulatory support, we'll continue to see these tactics. And I need to say, actually, and add to that, interoperability has been endorsed as the correct model. ACCC, ARNEC, New South Wales Productivity Commission. We've actually also had live transactions that have tested the validity of the model. What we need to do now is execute it.
In their submission, you may not have seen it yet, but the Australian, well, it was published last night, the Australian Institute of Conveyancers identified the mandating of interoperability as part of a suite of reforms as their number one or priority consideration. The mandating of interoperability is something that Simply would support?
Absolutely. But the good news, I suppose, for this committee is it's already been legislated. So LNOs have a legislated obligation to interoperate. That was enacted, as I mentioned in my remarks, in 2022. That model has been reviewed and determined a number of times. So why are we here? We're here because there is no credible sanction on the monopoly incumbent to voluntarily come and design for this. So that's why we're here, Senator. And I would agree, and a number of parties also agree in their submission. The Law Council likewise. So it's no surprise that the customers of this market want real choice, which they do not have today.
And part of the regulatory failure is ARNEC is a unsuitable, incompetent enforcer?
I think ARNEC is a very credible regulator, but if you look at the teeth that they have, it's not sufficient enough. It was remarked in the last session, but let me reiterate. The most credible, well, the only sanction that ARNEC have at a national level is suspending a network. That is like self-inducing an outage. It's not going to happen. It's not a credible threat. Now, New South Wales do have powers, and I note the New South Wales Registrar will be talking to you later. A great question for her will be, why haven't you used your powers? But they need some competitive regulatory assistance. In our submission, we detail, we think there's a need for ACCC support in this. Otherwise, we'll continue to see the behaviour from the incumbent that we've seen.
In June 2024, this is a similar question I put to PEXA. In June 2024, ARNEC announced that the interoperability program would be paused because the banking industry had raised issues in relation to the interoperability program that were beyond the remit of states and territories to address effectively. What's Simply's interpretation of what happened there?
Whilst ARNEC enacted the pause, the real root cause was PEXA's letter to the banks. That's a matter on the record for the committee. Simply put, no pun intended, simply put, they said to the banks, number one, don't talk about this ecosystem. It's our IP, unsubstantiated IP, I might add to my earlier remark. And secondly, they clearly said to the banks, we are going to deteriorate your service in a competitive market. Now, I've spent a lot of my career in banks. We all know how important mortgage processing is. That scared the banks. The problem we have in this reform is that we've seen no specifics. There is every opportunity to design for this. So the banks raised a number of concerns, again unspecified. So that was really the root cause, Senator, of the pause. And I think ARNEC had to acknowledge the role of the banks in this reform. So again, why are we here? The banks have a really important role to play, but ARNEC have no compulsion over the banks. They need assistance. But without the bank's support, as I detailed in my remarks, there is no choice for conveyancers, and we're left with that single point of failure risk.
Could the banks have pushed back on PEXA when PEXA made that approach to them?
Great question for the bank session later. Our view, absolutely. They are a material supplier. They should have pushed back harder. Now, some would argue these letters were a convenient excuse to down tools. I hope that the banks use the session later to commit to interoperability. There is a pathway here that delivers not only choice, but delivers resilience. We need the banks to play their part.
Can you just explain to the committee the importance of the APRA CPS 230?
Yes, I can. And again, I would recommend the committee ask the banks this. It says that the CPS 230 standard says that banks should have continuity of service in their critical operations. In practical terms, that means if there is an outage, a disruption, they have a credible, tested opportunity to continue those services in another way. You note a lot of banks deploy multiple credit card providers as a good example. In this instance, I fail to see how they meet that standard with putting every single settlement through the PEXA platform. I also fail to see how PEXA articulating they could bring their system up in 4 hours. Again, we've got so many examples over the last year, Optus, CrowdStrike, and others, where big networks are brought down for a number of reasons. The important part of this reform is not just competition, it's about a viable second network that can offer resiliency such that all the consumer impacts that you were probing earlier, they don't eventuate. We don't want that to happen, but they could. They could unless we deliver interoperability.
Item 20 of that APRA standard says, and I'm quoting, the board of an APRA-regulated entity is ultimately accountable for oversight of an entity's operational risk management. This includes business continuity and the management of service provider arrangements. Do you think that boards of banks are properly considering the risks around single point of failure and an over-reliance on PEXA?
That would be a good question for the banks. I'll offer my perspective. I don't think that the single point of failure risk has been fully appreciated because we see the evidence, don't we? We haven't seen the push on either adopting us at a great scale by the banks or the full support of interoperability. So I'd let the banks comment on their own governance processes, but the evidence in front of us, I think the only inference from that is a full appreciation of the risk has not been made.
Thank you.
We are going to continue on until quarter to 11, if that's all right with the rest of the committee. Senator Darman, and I'll go to you.
Thank you. Can you talk about whether you're aware of examples of interoperability working overseas? Like, is this a uniquely Australian problem? It would be useful to understand how things operate elsewhere, and if there are some good examples, what lessons we can draw from those experiences.
Thank you. Insightful question. Yes, there are lots of industries that fundamentally rely on networks sharing information between them. I've used the telecoms example a number of times, but that is very much the same.
What about in property transactions in particular?
Well, actually, you could argue that we have a form of that already today. As you've heard from PEXA and myself, we're connected to other parts of the industry through banks, land registries and revenue offices using the very same technology we would use to interoperate. We send information between parties. So in our own industry, we already use it. What we're talking about is two networks securely talking to each other. So we use it in our industry today. So it's proven already. Other industries, in property industries globally, there isn't a good case study. But again, I draw on energy, I would draw on mobile, I draw on payments in this market as well. That's all based upon networks talking and sharing information securely. Now, I spent a lot of my career in payments, so I'll give you an example which might bring this to life. I worked for Westpac, and our biggest customer was the New South Wales government. Now, today, the New South Wales government has every bank on the panel, but Westpac still remain their main bank. Is that because they have access to different payments? Is it because the payment standards have changed? No. Is that they've offered, at the customer end, they've offered innovation and integration. And they've managed to do that successfully to offer value to the customer. What we see in this market is very similar. We're talking about putting a standard in place to let two networks talk, but let innovation flourish for the customer. So when I heard the PEXA team talk about the work they're doing with the banks, I think what they're obscuring is have your integrations, go for it. If that adds value for the banks, we welcome that. But you cannot block the standards on which the network relies upon. And so to your question, Senator, I think a good example is the payment industry. Standards that mean security, reliability and consistency, and innovation at the customer end.
Mm-hmm. In terms of models, your submission notes that you'd support a practitioner-first interoperability model. Can you talk a bit about what that is and how it would work in practice, and whether the discussions that we're having today and the challenges would be, how would some of those things be addressed by your suggestion here?
Thank you for the opportunity. Yes, practitioner first in simple terms, says, acknowledges a couple of the issues that the ABA and the banks have raised and PEXA themselves raised, which is we want to keep the settlement, particularly the settlement experience for banks, the same. We want to reduce the change for banks in the near term. What Practitioner First really talks to is offering choice to the legal and practitioner market. So, the example I gave earlier, if 2 banks and 2 conveyancers were supporting a house sale, today they all have to be on one network. With a Practitioner First release, it means one or both of the practitioners would be on the Simply browser, entering their details, and that information would be passed into the PEXA network, and the banks would remain on PEXA. It's that simple. To counterpoint it today, where a conveyancer would log on to PEXA to enter their details, tomorrow they would have the choice. Do I log on to PEXA? Do I log on to Simply? So that really backs up the assertions that the PEXA team made earlier, that then we would really be fighting for customers with value, wouldn't we? How can we give you a better experience? How can we save you time? How can we be more reliable? We think it's a really pragmatic stepping stone that could be made to assure the banks that their experience stays the same. Now, they would need to be held to account, as would PEXA, to do that. That would offer some resiliency to the market, even in that form, because whilst PEXA would still be settling the transactions, were they to have issue at the settlement stage, because of our infrastructure, we could settle those. But we need to build the standards to support that. That's what's blocked today, Senator. We need help for ARNIC to ensure those standards are built. So we would love the opportunity to progress Practitioner First, because we think it addresses the bank's concerns. I'd love that question to go to the banks later. We think it's a great step forward for the industry for choice and competitive benefits and resiliency. But I also need to be clear, that's not where this industry needs to stop. We need it then to progress to full interoperability, 2 scale networks both settling. I hope that explains it.
So, well, kind of, but I mean, isn't that, it's still relying on the PEXA technology, if you like, in terms of the financial settlement side. So doesn't that go to their major concern around the IP that they say they hold in exactly that point of the transaction? So am I wrong in understanding what you just described?
Let me bring it to life. The concept of interoperability is always considered one ELNO does the final settlement component. So that there's been no scope creep. That's always been the context. So this is consistent with that. One ELNO will settle. In this instance, it's PEXA. As I said earlier, we're not infringing on any intellectual property. We've never received any IP claims. It is about defining the standard that allows choice of a practitioner. But it goes to some of the questions the banks have had around, we want our experience to stay the same whilst we get more and more certainty on the settlement components.
Okay. And in that model, how much of that component then provides additional competition and choice for consumers, and the capacity for prices, for example, to drop? Because it seems to me that a pretty fundamental part of that still relies on the one bit of the market that we need to do some more work on.
Let me give an example of the competitive benefit of that model in terms of prices. Our prices are visible on our website. So if we were to support a house sale today, the price for all parties to that would be $373. That's $30 cheaper than PEXA, so in total. So in isolation, that doesn't seem very big, does it? Particularly when compared to real estate fees and so forth. But it's, I suppose, the paradox of comparison. Let's extend the example. If our pricing was applied to every transaction in the market would save $23 million. That would flow through to consumers. Also, and I think this was a question from one of the senators earlier, in the last 2 years, without any competitive pressure on prices, PEXA have increased their prices by a total of $25 million. So in aggregate, there are really strong competitive benefits, but there are, to your point, there are no downward pressure on prices. What Practitioner First would do would make a more competitive market for conveyancers, and the flow through fees, lower fees, and choice would flow through to consumers.
Okay. Just one final question from me. You talked in the beginning about, the states wanting PEXA and the banks to deliver on this project, and that it was in fact a direction, I think you called it. So what are the impediments, in your view, in the states being able to follow through on their direction?
It's a matter of, I think most submission note that ARNEC does not have any regulatory oversight on the banks. So the banks, as I noted in my remarks, play a really important role in this reform. So I think that's to use the Senator's remark, that's a regulatory gap number one. So the banks need to play their part. Again, we've talked about APRA CPS 230 standards. I'm sure the RBA and ASIC would have a view on a single point of failure risk also. So ARNEC have no regulatory compulsion over the banks. That's number one. Number two, as we've detailed earlier, ARNEC's sanction over an entrenched monopoly is weak today. They will not suspend a licence nationally. New South Wales at this point have not used their enforcement powers, so we think there's certainly a role for a more experienced competitive regulator, because there is in effect an incumbent monopoly here. So those are the two areas which adding expertise and action would help ARNEC deliver this reform.
Thank you. Thanks.
Thank you.
Senator Sharma has a question over the machine.
Thanks. Thanks, Chair. Just a quick one, if I might. PEXA put to us before that they have intellectual property rights, if you like, in, I know this has been part of their argument in both the settlement process and the payments process. I think all the registration process and the payments process. How do you respond to that? Would you say that they don't have intellectual property rights, or interoperability wouldn't infringe upon those IP rights? What's your response to that claim?
My clear response is let me start by saying we've never received any IP claims from PEXA. The e-conveyancing industry is based upon exchange of data between parties. The features that PEXA detail are not unique. We have built them on our platform. They are fundamental to the industry and predate digitisation. The use of trust accounts is a great example of that. Again, our view, which is backed by legal experts and ARNEC, is that interoperability does not require the disclosure of intellectual property. We're confident that the current ARNEC review will confirm that. I come back to the issue at hand. The issue at hand is noted by the ACCC. You have a monopoly who has absolutely no incentive to voluntarily come to the table to implement these standards. So unless we get credible support from a federal agency, these delay tactics will continue. And again, we've not received any IP claims because the claims aren't credible. Okay, thank you. And just in terms of existing competition and viability of competitors, so Simply would be the only competitor to PEXA at the moment in this industry, in the e-conveyancing industry?
We're the only current competitor, Elno. There was a third entrant in the market, Lextech, who withdrew. If I look forward, Senator, because I suppose the corollary question to that is, would this entrench a duopoly? Is that really competition? I think, firstly, we need to acknowledge there's a monopoly today. There's that single point of failure risk. There's no choice or competitive benefits. Once interoperability is live, I think that and other parts of the market could see a flourishing competitive market. That would give other providers more confidence to enter. At the moment, why on earth would they have any confidence whatsoever? They see PEXA have effectively 100% of the applicable market. So that's why federal action is required. Unless we have that action to support ARNEC in delivering interoperability, we may not even have ourselves in the market for longer, let alone new entrants.
Yeah, I was actually going to ask that. So if you don't get interoperability, I presume simply at some point we'll decide that this is not commercially viable and we'll withdraw from the market and we'll be left with a monopoly where I presume new entrants wouldn't even consider consider the market because of simply their own experience?
I think that's a very fair assumption. And we entered the market because we were kept being told by customers that there were real problems to solve. We keep being told today by conveyancers and lawyers that we can speed up their work, we can help them and their end customers. So if we weren't being told this, we probably would have exited a long time ago. But because PEXA were mandated, because as the ACCC note, there are such high barriers to entry, ARNET need help. If that help is not forthcoming, I think you're right, Senator. I think the market will be left with a monopoly. And then I think there'll be a high cost of regulation, but more importantly, as I mentioned, facing a massive risk. And if that were to occur, I think we'll all be sitting here going, why didn't we do something sooner?
Okay. Thank you very much. Thanks, Chair.
Senator O'Neill.
Sorry, I just kicked my microphone away. Thank you. If I could go to the submission from the Australian Institute of Conveyancers. Have you had a chance to see that?
I have had a quick look, yes.
Okay. So they say they want to provide a balanced and independent perspective. With regard to interoperability, they caution against identifying interoperability as a panacea to the challenges in the sector. And they identify costs as a significant implementation barrier, innovation constraints, and practical resilience. They also point out that for consumers, that competition in this sector doesn't automatically equate to lower costs, and they note that already 2 additional fees have been introduced for every transaction: a fee for the establishment and maintenance of the database, and secondly, an additional fee payable to the responsible ELNO. So while competition has its great lure in terms of the matters that have been raised here by both yourself and representatives of PEXA, can you guarantee that there will be a reduction in costs if interoperability of the kind that you are suggesting is actually delivered?
I'm going to comment specifically on a couple of the remarks they put in their submission. The database cost and the RELNO fee that the AIC detail, those will not be passed through to consumers. Actually, in the MOR, which we're subject to, the RELNO fee cannot be passed on. The access fee is a fee. Ironically, it's a fee we used to pay PEXA. It now goes to an independent entity. So that's factually inaccurate. But I suppose the broader theme is, will competition bring lower fees? I think I've given the example earlier. Our fees are lower. They will deliver tens of millions of dollars of benefit. The majority of the costs for implementing interoperability are borne by the networks. So the majority of our cost goes into 2 things: designing our platform securely and designing it in a way that can be accessed and give value to customers. So our commitment to this market, we would not win a single customer if we couldn't deliver value. All customers are on the monopoly today. We have to demonstrate value, and one of the key ways we demonstrate value is lower cost. So that's my response to that.
So if I was thinking about your analogy of the Telstra and Vodafone, I guess the argument from PEXA is that, you know, it's the Telstra phone's the only one that's going to work, and that Vodafone, which is you, haven't actually created their own product. They just want to take the Telstra phone and use it and make money. Is that it in a nutshell?
That might be PEXA's argument, but it's not ours. I think at its heart, and we use it because it's illustrative, we want customers to be able to use whatever phone they want and the phone call to work.
Yeah.
What instead we're seeing is, in this instance, PEXA being Telstra saying, well, no, let's use text messages as a great example. Oh, we'll support text messages across networks, but we'll only let you send half the characters we allow on our own network.
And maybe a better comparison is, iOS and Apple technologies. There's investment in both of those. What's the scale of investment relative to PEXA? Like, is there a public document that you're aware of? I mean, they're an IPO, they're a company that's listed on the ASX. What's their investment in their technology, and what's your investment in your technology, Mr. Joyce?
I won't comment on PEXA's investment because, as you say, that's their disclosure. From
Maybe
our
I can
side.
put that on notice for PEXA.
From our side, we've invested approximately $160 million into our platform, and our intent, very much as you've seen in our submission, is to offer, and we have, a viable national network with the features that customers want, but we are blocked from getting to the market because we don't have the standard to allow networks to talk to each other.
So at
That's
160 million, what's your market capture? Is it 1%? Did I read that?
It's actually less than 1% today.
Okay.
For the reasons we described, until we get interoperability, we cannot service the vast majority of the market.
So if I can go back to the Australian Institute of Conveyancers, they go on to indicate that costs will be borne by subscribers and that further costs associated with interoperability and compliance are likely to follow through, though the full extent of that remains undetermined. They think that competition may discipline pricing over time, but in the short term, consumers are facing higher costs, not lower ones. Can you comment on that, Mr. Joyce? Are we absolutely certain to see a reduction in costs for consumers in Australia while not sacrificing any security measures if the changes that you're advocating come into place? Because I think you want full interoperability rather than just practitioner first.
We have a very clear view here. Interoperability, when implemented, will offer choice and a competitive market that will lower prices for conveyancers and consumers.
By how much?
For the quantum I said earlier, $23 million this year. If there's downward pressure on prices, we would have saved $25 million in PEXA price rises. But I need to say this, it's more than price. Now, if we don't have a competitive, resilient market, then the real cost borne by consumers and conveyancers is the consequence of an outage. If we don't have a scale viable network, we've got one. We've got Simply, but we are blocked from entering the market. That's why we're here. So yes, price is important. Yes, we will deliver lower cost. But importantly, if we don't consider the design and get that implemented, we are facing a huge single point of failure risk.
Can I just ask one final question with regard to Home Affairs' declaration of PEXA as critical infrastructure? And the counter-argument to what you're saying is that there has been an increase in threats and actions that you've referenced in your evidence this morning, and that having multiple points creates unnecessary competition and increases the risk for more points of interference from malign actors who would seek to exploit the largest transaction that happens in anyone's life. That the competition simply isn't worth it, and that's why the monopoly status is actually a security vehicle for Australians who are making this big transaction in their life on hopefully maybe a couple of occasions.
I'll reiterate what the Australian government's cyber security centres say. Over-reliance on a single provider in a market increases cyber risks. We need two viable networks. Decentralised, diversified model is best practice globally for reducing risk.
On notice, if you could provide any examples from another jurisdiction of similar size with a population of 27 million, with similar sort of economy to ours, where multiple entrants are operating in any way like this. Thank you.
Thank you. Can I just clarify Senator O'Neill's question, or expand on Senator O'Neill's question? You're not necessarily talking about, while you talk about alternative networks, you're still talking about the same set of rails, aren't you? It's really just that there would be more points of entry. So even though, you know, the argument is that you would reduce the points of failure, you actually are increasing the points of entry for cybersecurity risk, are you not? Because it is still the same set of rails, it's just that you're bolting on new networks.
It is true that interoperability is a set of rails that exchange information between networks. You're right. Much like payments, much like banks connecting to payment rails. I would argue that analogy plays here. I don't think we would say having only one bank in this market would be safer. So at one level, whilst you do have another browser that is accessed, that is true, Again, global best practice, we will come back, is that actually competition drives up the competition on security. It drives up the desire in investment. So I think that's what's at stake here.
Right. Okay. Thank you.
Chair, I've got one more question.
Sure.
It might need to be on notice. Your relationship with Infotrack, could you explain that, Mr. Joyce?
Sure. Yeah, Infotrack are a 50% owner in Simply.
Okay.
And the other 50% owner is the ASX?
That's correct.
Thank you.
One of the concerns raised again in the submission from the conveyancers was that there's a risk of vertical integration that could compromise the independence of the conveyancing profession, given the shape of your relationship simply with Infotrack. What do you have to say to that concern?
I think I'll have a very similar answer to PEXA, actually, that there is a separation regime in place in our industry already that foresees that and tries to safeguard that exact issue. As our network, we have no volume, less than 1% of the market. As we
that change, Mr. Joyce, it would be very tempting. We've seen terrible outcomes from vertical integration, and we had some questions of the previous witnesses about separation in their business, which is by statute that has to stay. You're not subject to that in your current corporate configuration, are you?
We are completely separate from Infotrack.
And there's no way that you would end up sharing information?
There's
nothing to prevent you sharing information, is there?
Well, the regulations are set that anyone who accesses has to access us on an equivalent basis. That would persist.
Okay, thank you.
Thank you very much, Mr. Joyce. We will let you go. The committee is now going to take a break for morning tea for 15 minutes, and we'll resume at 11 o'clock. We'll now resume, and I welcome representatives from Infotrack. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. And for the Hansard record, would you please state your full name and the capacity in which you appear today?
Thank you, Senator. My name is John Ahern. I am the CEO of Infotrack.
Thank you very much, Mr Ahern. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite senators and members of the committee to ask questions.
Good morning, Senators. We have served the legal and conveyancing industry for over 25 years. We're an Australian-owned and operated technology company. Thank you for the opportunity to appear today. I'm here for one reason. That is, I believe Australia needs competition in electronic conveyancing, and there is a real and tangible risk if we don't deliver it. It may be a surprise for you to hear that when e-conveyancing mandates came in 2017, the industry wasn't actually happy about that change. Our clients value resiliency, transparency and choice, not just for them, but for their clients, the Australian consumer. So in 2017, we took our best 12 people, we partnered with an expert in banking connections, and we started simply to build a state-of-the-art platform. More than 4 million transactions are completed on this platform per year. And we're not just talking about property sale and purchase transactions. We're talking about estate administration. We're talking about divorce and family disputes. There are 10,000 legal and conveyancing firms that rely on a single operator today, PEXA. And with one operator, there is no safety net. If it goes down, there is no backup. There is no choice. There are only costs to small businesses, to home buyers and sellers. I will give you two recent examples. Last Monday at 1:30 p.m, peak time for us, for roughly an hour, it was not possible to create a PEXA workspace transaction in any state of Australia. When that happened, lawyers and conveyancers acting for their clients had no choice but to stop. Now, how do we know that? Well, Infotrack itself was a party to 378 transactions. 150 of those were delayed. Now, PEXA don't consider those delays an issue. They say this is the new normal. But I think we can do better, because this does have real impact. There are families affected when settlements are delayed. Those families don't call the banks and PEXA when that happens. They call lawyers and conveyancers. There is a real problem. Yet, a viable alternative exists. Simply's platform is operational now. It is built and connected. The platform is ready to support competition. What's missing is the practical ability for lawyers and conveyancers to choose their platform. Now, why is that? Why can't they just choose? Well, as you've read in every submission, everyone supports choice, right? They support competition and choice, but in practice today, the banks are not accepting transfer invitations on Simply. The simplest case in point I can think of is a major bank, Westpac, have completed no Simply transactions since their initial connection. Not one. If a lawyer sends a transfer invitation to any bank on Simply today, it's simply ignored. By not accepting invitations, it's the banks that are making the choice for everyone. Yet Simply has a viable platform. The banks could support both Simply and PEXA settlements starting today. Now, Philip has articulated the single point of failure risk to the banks. But consider for a moment the lawyers and conveyancers whose primary income is property transactions. Lost time is critically important to these small businesses. But despite the risk and the availability incidents on this platform, all progress has stalled for over 18 months. Now, the ACCC has said many times, interoperability is essential to facilitating the entrance of new LNOs. And further, even if a new LNO could offer a better price and a better service, the incumbent ELNO will already have the network. And you know what, Senators? They're right. They have the network. ELNOs are already moving into a range of adjacent and related markets, and there are already potential compliance issues with existing separation and disclosure requirements. The most puzzling and recent example of this is that PEXA are working with Austrack right now to offer anti-money laundering solutions for lawyers and conveyancers and even real estate agents in Australia. Why would the Australian government actively enable PEXA to expand its monopoly and effectively bookend the property transaction? It's clearly anti-competitive and vertical integration, and it will foreclose on Australian business. Now, as we know, competition will resolve many of these issues because it forces operators to focus on delivering value to clients, and over time it reduces the network advantage. So why can't we start this right now? Well, to move forward, we need a regulator with teeth. Here's an example why. In December 2023, PEXA wrote a legal letter to the banks. They withdrew and this stalled the interoperability workshops. I would argue ARNEC did not pause the program. The actual pause occurred when the banks withdrew from those workshops. ARNEC has limited powers. Specifically, it cannot regulate on financial settlements or competition issues. With this gap, both the ACCC and ARNEC have stated that monopolistic behaviours will expand into adjacent services. So what's the action that we're proposing? I believe it should be a priority and a critical policy to act immediately to deliver competition to the e-conveyancing market by dedicating resources to close these basic regulatory gaps. And to be clear, I'm not asking for special treatment. We're simply asking for the federal government to inject resources into ARNEC so that it can subject PEXA to appropriate oversight and hold PEXA and the banks accountable to actively participating to deliver competition in a reasonable time. If we do that, Australians have choice. But more importantly, we will de-risk a market that touches life's most important stressful moments, like buying a home, managing an estate, or resolving a family matter. Inaction by government will lead to us exiting the market. PEXA and the banks will then continue as they are today. They will leave Australia with a national monopoly and for the government to regulate and the certainty, I believe, of a national failure. ARNEC know what to do. We just need to give them the teeth to do it. Thank you.
Thank you, Mr. Hand. I'm going to throw to Senator Darmanin first, but I just want to ask a couple of questions about your testimony. You said that you are simply asking for additional resources into ARNEC. What sort of resources are you talking about?
Well, ARNEC in their own submission, Senator, mentioned that they have regulatory gaps around financial settlements and competition issues. Mm-hmm. I believe they're the key areas. I mean, if you look at, and I apologise, there's a lot of terminology in the e-conveyancing market. ELNOs and RELNOs and interoperability is a word we have to say often. But if you look at the careful legal strategy that PEXA have put in place over the last many years, they've had the net effect of slowing down any progress towards interoperability. And I encourage you to ask ARNEC later today how those regulatory gaps have effectively inhibited them from driving this reform forward.
So let me just be very clear then. When you talk about resources into ARNEC, you're talking about jurisdictional resources as opposed to financial resources or human capital.
No, I think specifically around financial settlements, when you look at the claims that PEXA have made around financial settlements, resources to help fix that regulatory gap for ARNEC, I think would be appropriate, and also the anti-competitive issues. Just speaking from Infotrack's perspective, over the last 7 years, we've made 5 different submissions to the ACCC and ARNEC about anti-competitive issues, and it's very, very clear that ARNEC are not well geared as a regulator to regulate the PEXA monopoly.
Okay. I've been trying to find an analogous... Sorry?
Could we get the outcomes of those 5 submissions on notice?
Yeah,
Thank you.
Yes.
Yeah, that would be terrific.
Notice taken.
I've been trying to find an analogous example of a system to this one. And the closest I could come up with is the payment rails, particularly the new payments platform, which was put together and funded largely by the private sector, but in conjunction with federal government. They are the rails of which other organisations bolt onto. Is that the most analogous example that you can think of? Because I get a sense that what you're talking about is multiple sets of rails that we would then force the private sector to adopt.
Yes, so appreciating this is complicated, it is a good analogy. From a lawyer or conveyancer's point of view, there is only one option. They log into PEXA. We're trying to give them a second option, which is to log into Simply. Now, they can't do that today because if they do anything on Simply, they send a invitation to the banks, it will be ignored. But Simply has its own connections through to the banks and the land registries and the state revenue offices. So even before we start talking about interoperability, if the banks were willing to run with the Simply network, even before they were plugged together, we could actually transact. But right now, they don't accept the transactions, so the lawyers and conveyancers have no choice. Now, when the ACCC and ARNEC started talking about and proposing interoperability, the scope of which always, to my knowledge, included settlements, always. They saw this as the only way to offer competition because of the network effect. That the two LNOs would need to exchange information to allow one party, so one lawyer, for example, could log into Simply, and then they could transact with the other 3 parties, all operating on the PEXA network. Now, obviously, they would need to exchange data at various instances through the property transaction, and it's those APIs that we're really talking about. And so that's really the focus, is in and around those APIs that are exchanging information. So when I look at the output of the workshops and I see the work that's going in, most of the work is in and around the APIs and the work required to connect the 2 networks together. Now, what's curious to me is there's quite a lot of complexity being touted there today. There's a lot of issues with those APIs that they need to build for interoperability that both Simply and PEXA need to build for interoperability. It's curious to me because PEXA, we integrate with PEXA at Infotrack, and other large law firms that we work with, they all integrate with PEXA, and PEXA have over 60 APIs today, and 10 of those are brand new APIs. We've just signed new API agreements to get access to. So it's curious to me that the APIs that they're building to get more deeply entrenched in connecting to lawyers and conveyancers and different platforms out there are not their concern. It's just these APIs that enable competition. And that is very frustrating. It's really, that's what's been delaying us. And really, if you look at the last 18 months, since the pause on the workshops where we were interacting on those pressure points, nothing has happened. Okay. So from a shareholder point of view, nothing has happened. No forward progress has been made.
Okay. Senator Darmanin.
Thank you. Just on that point you made, are you saying that there aren't any technical or regulatory barriers in trying to make I've had trouble with that word all morning.
Yes.
Interoperability work with Simply is purely competition. There's no other barriers in terms of technical or regulatory.
We internally use the term interop to avoid. Exactly.
Okay,
Yes.
I like that.
Yes.
Yep.
There are complexities. I don't believe there are technical barriers, but I do believe that unless we can sit in a workshop and have the right intentions and the right incentives to proceed, we won't work it out. And that's really the key problem here, is that we really need PEXA and the banks to see this as critical, invest time in it and deliver interoperability. If we do that, yes, we will find a technical solution. We've proposed technical solutions. A technical solution has been proposed, agreed. That's not the issue. It's really just sitting in the rooms together talking about the implementation. And for the last 18 months... Philip would know better details. I'm happy to take that question on
And
notice.
agreed by whom, in what form?
The interoperability designs, I think were finalised in, I think it was either 2021 or 2022. But the workshops have been more focused on specific implementation approaches. And a typical example would be an argument about whether or not we need to exchange one land title reference in a settlement or all that relate to the settlement. You know, it's very, very specific details.
Okay. So, you know, we're talking a lot about interop being the only viable pathway for competition. What do you say to alternatives like the access model or price regulation as another way to deliver benefits to consumers, particularly around protection and competition?
And just for clarity, we're talking about the practitioner first approach as well? Yes. Let me provide some perspective there, because I realise this is complicated. And I'll reiterate, you know, the ACCC have said interoperability is the best model to drive competition. Why? If you're a bank and you want to use the incumbent PEXA today, you can do that, right? That's your choice. More importantly, I think for a lawyer or conveyancer on a transaction by transaction basis, they can use one platform or the other. But you know, we haven't seen any progress for quite a period of time, and we're aware of, and I heard today that PEXA had proposed an alternative model that they referred to today as the ladder of investment approach, which is no longer their proposal. It was a proposal in that legal letter in December 2024, but it's no longer considered a viable approach. But reading that approach, it looked to be that PEXA were proposing a sort of like a wholesale model, a wholesale retail model. Honestly, Senator, we would do whatever it takes to get to market. You know, at times we have thought, well, what concessions do we need to make so that we can deliver some competition to market? And that's why we started to consider a model whereby the banks who are so entrenched, who will not move, who will not accept invitations on Simply today, to stay comfortable, you know, if that's what they say they need to do, and allow us to enter the market to offer some choice for the lawyers and conveyancers. But to be clear, it's a concession. Like it's radically reducing the market size for us, and it is not delivering resilience. It's not delivering, you know, it's not delivering the entirely separate network. So you're still sitting in that model where we are today, which is if PEXA's down, the whole industry is down. Mm-hmm. But we saw it as a step forward.
Yeah. And I think if you yourself and perhaps Simply have suggested, I'm sure the questions will come to the bank in terms of, you know, what their position is around things. But in your view, what what do you understand the objection of the banks to be in terms of enabling customers to choose simply to plug into their systems?
I think it's, when you think about the history of what's happened here, in 2017, the banks were mandated. You know, the lawyers and conveyancers were mandated. There were no choices. You know, the change is not something they run towards. And in this particular case, there's no mandate. The banks don't have to do this. So they can just comfortably sit there. So if an IP claim comes across their desk and the risk people in the bank become interested in that, it's very, very convenient to say, well, okay, we'll withdraw from the workshops until that's sorted out. But they can use and can accept full-party transfer invitations from Simply today and start using it, and I think they should. But what's curious to me is it's one or the other. From a compliance requirement and a resiliency requirement, two suppliers seems necessary for a large bank especially. So in my view, it's one or the other. You either put your full weight behind interoperability and use Simply as a backup, or start to accept invitations on Simply and use both platforms.
Yeah. You talked in your opening statement about the harm that has been caused by consumers due to outages and the like. We heard this morning that I think the compensation that's been paid out from customers by PEXA was in the order of $13,000, which seems pretty unbalanced compared to your description of the harm being caused. Just wondering if you can explain, like, what's your view about the gap? Is that the harms are quite minimal, therefore, you know, the $13,000 is commensurate given, you know, it hasn't impacted people moving house on a particular day or loss of money to large sum, or is it something else? Like, because they're quite different pieces of evidence that we've heard.
Yes, I did hear that. I think it's clear that they're not valuing, first of all, they don't value the lawyer or conveyancer's time in sitting in front of screens waiting for things to happen. That the delays have become a convenient feature of an ELNO. You know, as we know, if you've ever attended a manual settlement prior to PEXA, you stood at a table and settlement happened. Humans would make that work. Settlements rarely slipped. Now, as an electronic lodgement network operator, it seems to be a feature where a lot of settlements actually slip throughout the day for convenience of the bank wasn't ready or somebody didn't have their information in time. But I can tell you that these delays are occurring, but the people that are affected, they're not calling and saying, I want my money back from PEXA, but they are affected. They're complaining to the lawyers and conveyancers, and I don't think the time of the lawyer or conveyancer is being considered here, nor do I think the time of the person, the human beings that are being affected is being considered either. In fact, I think that lawyers and conveyancers now advise their clients that settlements frequently slip since electronic lodgement has come into place, since PEXA. Lodgements slip, so be careful with your moving truck. But should those lodgements slip over a day boundary, you have a big national problem. And it hasn't happened yet. And I reference, I heard in PEXA's submission, they're working on a 4-hour resolution time. We've got that at Infotrack. I think everyone in the industry these days who has a decent platform should have that. But if that happens at the end of the day, it's still moving over a day boundary. You will have a situation where people have moved out of one house and cannot move into their next house. And that will be a big national problem.
Okay, thank you. Thanks, Chair. Senator Smith?
Thank you very much. In your opening remarks, you talked about the expansion of monopolistic behaviour by PEXA. Could you just, monopoly position, people would think that was generous enough. But if I understood your comment, what you're saying is that monopoly position could lead to further monopoly positions. Could you just expand on that?
Yes, Senator. PEXA have 100% of the market share, effectively. I mean, less than 1% of transactions are going through Simply, but make no mistake, every single lawyer or conveyancer and bank out there that is completing property transactions now has to be using PEXA. They have the network. It's an impressive network. But if you think about the conveyancing process, the electronic settlement part, the settlement part is the end of the conveyancing process, the very, very end of the settlement process. Prior to that are a series of different processes that a lawyer or conveyancer would typically undertake. You know, everything from the time you engage with a real estate agent and start to create a contract with your lawyer or ask your lawyer to create a contract, verify your identity, exchanging the contract, all the way through to settlement. Now, the submissions that I will provide on notice will show you that at various different points over the last 7 years, that PEXA has had offerings end-to-end in the conveyance at different points in the conveyancing process. So, for example, at one point they had a marketplace offering where you could get contracts and more upstream services. They've had...
You're alleging vertical integration has already occurred, despite the evidence we heard this morning.
Yes, that our submissions to the ACCC have been exactly that.
Thank you.
And there are various other examples. Famously, the most famous example I can think of was, I think it was 2017 or 2018, this is public information, PEXA started a conveyancing company. It was a process considered to help the smaller conveyancers who weren't able to get on the platform to use a platform, I think they called it at the time Settle Assist. And the industry were very upset about that, and PEXA backed away from that at the time. I believe we made a submission at that point. But the most recent one, just to get back to your question, is that, and PEXA on their website, you can see this, are proposing to provide AML solutions to industry. Now, there are about 20 different providers for AML in the industry. And really they're even talking to real estate agents. So real estate agents aren't a party to a PEXA transaction today. You've got banks, you've got lawyers, you've got conveyancers, but not real estate agents. They're proposing a solution to provide AML CTF solutions to market, which will effectively, including real estate agents, which will effectively give them the ability to onboard clients into their network earlier in the conveyancing process, much earlier. And as we know with networks, once you're on them, it's very, very convenient to stay on them. You're very unlikely to hop off them, especially if you're mandated at the end of the process to finish your transaction on PEXA.
What more can the banks be doing, and why are the banks not doing anything much at the moment?
We ask ourselves that question every day, every board meeting we have, because for the last 18 months we've been totally stalled. We have, and I've read the various submissions from the banks and the ABA. I think there's a lot of detail in between the detail that's been provided there. So I recall one bank said, we are transacting with both PEXA and Simply today. But this is the CBA submission. I think the sum total of transactions, refinance transactions, is 10. And
Simply.
That's right.
And of how many?
However many refinance transactions
CBA does.
Yes. And really, the key question, everyone uses the term transaction very vaguely, but actually we're talking about the settlement transaction, those four-party transactions. And that's why I was so curious when PEXA mentioned in their submission today that there's been a mission creep here. We would not have entered the market if this was just about lodgements. Our clients are concerned with settlement from end to end. So the main frustration for me is that the banks haven't really done anything around four-party transfers. PEXA also spoke about milestones, hitting every milestone. The truth is there's been very many milestones for interoperability. I think I recall 2021 there were milestones for interoperability, then they were pushed to 2023. The most recent milestone for interoperability, I believe, was June 2025 refinances, interoperable refinances between the banks. And then December 2025 was going to be four-party settlements. So we've missed every milestone. In my view, there is no milestone, and the major blockage is that for the last 18 months the banks have withdrawn from those workshops and no further progress has been made.
Is part of the solution putting more transparency over the bank's actions or inactions in this particular area? So you talked about regulatory support for ARNEC. Isn't part of the solution, and perhaps a big part of the solution, saying to the banks that their actions are impeding competition in the market, or inaction is impeding?
Well, it is definitely impeding progress because no lawyer or conveyancer can create a four-party transaction today and have a bank accept it. But the transparency aspect, yes, and I believe that's what ARNEC were trying to achieve by setting milestones for interoperability by certain dates. But since the pause in the workshops and their inability to regulate around these financial settlements, everything stopped.
So when PEXA sent the letter to the banks asking them not to participate in the interoperability program, the banks would have treated that as a benefit, an advantage. You don't expect that they would have objected to that. You don't think that they would have put that request through due diligence in their own organisations to test the IP qualification that PEXA was making?
It's a good question for the banks. We haven't seen, and Philip mentioned, we haven't seen a specific IP claim. We built a platform. It has IP in it too, but certainly nothing that would be exchanged in an interoperable transaction. When I read a submission last night, which was timed at exactly the same time these letters went to the banks, PEXA sent a legal letter to their own regulator. And there were some details in there. One of the IP claims was the ability to specify a lawyer's trust account as a source of funds. Right, that to me is not a legitimate IP claim, and I would hope that if the banks did ask PEXA for a list of the IP specifics, that they were able to test those and see through them.
Last question from me, Chair. Why did Simply get 10? What was it about the 10 that you got transactions via CBA? What was the character around those 10?
Yeah, so with all of the banks, all of the four major banks, we've tried to get test transactions to exercise their internal processes, their internal people. We've worked very well with NAB and ANZ on transactions there. And then we start with single party transactions, which are easy for a bank. It doesn't use the network, it's just them, and we've managed to get them to do some transactions there. And then we move them to refinance transactions and then refinance between banks. And there are certain milestones that we set for the banks or with the banks, a trial, if you like, that helps them exercise understanding of the platform. And it also gives us feedback on what doesn't work well for them, what does work well for them. And we get very pleasing feedback from that. They love our system. They can appreciate why we're different and better in some respects, and that's great. So that was we signed up for a trial with CBA. They committed to perform a certain number of transactions. We'd obviously like that to be higher, but they commit to a certain number and then they complete them.
And they completed 10?
They did.
So they were trial transactions?
They were trial, yes. Well, they were live transactions, but on a trial. That's right.
Thank you.
I'm conscious of time. We only had this witness for half an hour. Have we got another question?
Two questions.
Yes.
One, if you could provide some comparison with other trials, if you undertook
sure.
any with other banks.
Yeah.
I note your Schedule 1 of very significant proposed recommendations, which is really designed to push us from a monopoly to a duopoly. And it strikes me, what we're hearing about the need to correct the very high risk. Is a duopoly satisfactory? If we're going to talk about competition, is there a minimum number? Do we need 5? Do we need 10 for the kind of protections that you're saying we so desperately need? Could you give some thought to that? Is a duopoly actually sufficient?
Well, I think Philip mentioned no one argues we've got a monopoly today, and there are benefits to simply entering the market in providing competition, not just on price, but value.
But if it's good to have you, Mr. Ahern, wouldn't it be better to have more?
Yes, and that's precisely right. So that is the reason why interoperability has been proposed as the model to enable competition, proposed by the ACCC. As the model, because interoperability is about, it was characterised earlier as a small network on a large network. It's not that. It's not that at all. The interoperability model is the model that enables more than two. But I would also just characterise this. If we exit, there won't be another one.
Because of the $160 million already invested?
Just because I think anybody looking at the barrier to entry here and the network effect and the resources that we've expended, it would be, I would imagine good due diligence would be they would come and meet us and say, hey, what went on here? How much do you think we need to invest to make this work? I think it would be very, very difficult for them to make a decision that they could ever enter the market in a reasonable time frame.
Okay. How many would you welcome? Have a think about that. Could I just ask in terms of your comment that it advantages PEXA in some way to let settlements slip?
Well,
how's it an advantage to them to have a product that is not 100% on in an industry where, time is of the essence every day?
I think, I think it's worth saying, by the way, PEXA have a good platform. This is not a platform bashing exercise here. No, I think it's specifically that the industry is finding it convenient in an electronic settlement world to allow settlements to slip. I can provide information a little bit later as a bank because or as a representative of a bank because I'm not quite ready. It'll just slip an hour, and the other parties will be notified that there's been a new proposed settlement time, and that's just convenient.
Right. So it's a convenience platform, and it's different from what you're describing as a face-to-face over a desk, where people's real time and real presence kept the heat in the kitchen, so to speak, to make sure the transaction happened at the allocated time.
Yeah, that's right. Humans would solve the problems on
Okay,
the spot. If
so
they
the slip
needed
is not really a choice to decrease the standard. It is providing convenience, but with some impact on the ecosystem at a cost to those who are unable to transact at the time that they want, despite the convenience to the other party.
That's right.
Right.
Yeah,
Have there been any payments or discounts or return of fees for the services that people are purchasing from PEXA when they do not get the service at the time that they're supposed to get it? Like, is there a penalty embedded in the structure?
It's a good question, and I think they did answer the penalties for PEXA.
No, inside the system. I don't mean from, my question was about outside. Have they had any enforceable undertakings or paid anything? Like, if you're a user of PEXA, if you're a user of Simply, and Simply or PEXA doesn't provide the service on time in the way that you think you've purchased, what's the penalty? Do they have to pay their people back? Do you get any discount if they don't deliver on time?
No, and more importantly today, if the PEXA platform's unavailable today, they don't lose clients. They don't. If they're dissatisfied with the service or the value, there's no loss of client. They have to. There's only one platform today. There's no penalties.
And if Simply functions and you don't provide the service on time in the real way that you've promised in your contract with people who purchase your product, will you provide them with compensation for any time you're down? Is that your business model?
Is it a Infotrack business model choice today? Yes. Is it a Simply one? It's not one we've considered, but probably yes. And the reason for that is competition. When you have a problem with your platform and it really causes problems for your users and they can leave you and go somewhere else, then you do whatever it takes to hold them. And that includes refunds, that includes apologies, that includes compensation, that includes providing a better service, and that includes improving it. And that doesn't exist today.
Okay. Could I ask you to have a look at the Australian Institute of Conveyancer's submission and respond to the points that they raise in their submission to Mr. Ahern?
On notice?
Yes.
Yes. I did read that submission, but will, thank you.
Thank you, Chair.
Thank you, Senator O'Neill. Thank you very much, Mr. Ahern. We've kept you well over time. We'll let you go. And I now welcome representatives from the Australian Institute of Conveyancers. Thank you very much for joining the committee today. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. So for the Hansard record, would you please state your full names and the capacity in which you appear? We might start down this end of the table.
Shaquila McLean, a practitioner in Victoria. I'm also the AIC Victoria current chair and also here as a national councillor.
Thank you.
Angie Nguyen, I'm a AIC SA councillor. I'm also a conveyancer in South Australia and I am representing AIC National today.
Thank you.
My name's Tanya Gawley. I'm a conveyancing practitioner. I'm also the Australian Institute of Victoria's secretary and I'm also a national councillor.
Thank you very much to all of you. I invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask you questions.
Thank you, Senator. First off, I want to, for full transparency, note that in addition to my work as a conveyancer, I have previously held roles with the South Australian Registrar General's Office and also with Simply Australia. I now appear today solely in my capacity as a representative of AIC National. We represent over 2,000 conveyancers across most states and territories, but more importantly, we represent the interests of people. We serve the Australian home buyers and sellers. Buying or selling a home is the single largest financial decision most Australians will make, and the e-conveyancing system underpins that process. It must be competitive, secure, reliable and affordable. Our submission makes 4 central points today. First is choice. With e-conveyancing now mandated, Practitioners must be free to choose the platform that best aligns with their workflows. Without that choice, buyers and sellers lose the benefits that diversity brings. Greater efficiency brings higher service, quality, and genuine innovation and resilience. Our second point is that competition matters. Today, the system is dominated by a single ELNO, known as an electronic lodgement network operator. In a world where we have choice between telephone providers such as Telstra and Optus, why is there no choice in which an ELNO to use? If a company controls important infrastructure, people can end up paying more, new ideas slow down, and the whole system becomes riskier. It also means conveyancers and other providers get stuck using the same system without real alternatives. True competition in conveyancing isn't just about cheaper transactions. It means ELNOs must lift their service standards, invest in resilience and innovate. Most importantly, it stops our property system from being exposed to a single point of failure if one operator fails. Thirdly, interoperability is a step forward, but is not the finish line. Interoperability lets conveyancers use different systems. That's a good step because it provides us choice. But for it to really work, it needs to be simpler, quicker, and backed by stronger rules and regulation. When electronic settlements first became mandatory in Victoria in 2019, new ELNO transaction fees were introduced. For small conveyancing firms, these changes quickly built up and placed stress on their businesses. Many had no option but to pass the extra cost to their clients. What was promoted as progress ended up meaning higher cost to both SMEs and the consumers in short. Interoperability also requires uniformity across ELNOs, which risks reducing differentiation and slowing innovation. And banks and registries cannot easily switch between platforms, so promised resilience gains remain limited. Fourth, strong national regulation is essential. Oversight is currently fragmented and under-resourced. The pieces don't fit together and there simply aren't enough hands to put the system right. We need a federal framework with the ACCC empowered to monitor pricing, enforce transparency and prevent anti-competitive conduct. Policymakers must take a realistic view of the timelines and benefits and ensure regulation is fit for purpose. The federal government must play a stronger role by mandating progress on IOP with proper funding and support, creating a national regulatory framework instead of fragmented state oversight, creating a empowering the ACCC to enforce transparency and prevent anti-competitive conduct, supporting innovation and resilience through national standards and cybersecurity investment, aligning with the Competition and Consumer Act to ensure e-conveyancing platforms are subject to the modern digital platform rules. And let me stress, ELNOs are service providers. They are not custodians of property rights. The interfeasibility of title rests with the Torrens system and state registries. Think of ELNOs as a delivery van. The registry is the vault. Beyond interoperability, there are broader reform issues. Ageing government systems, inconsistent lender readiness, and new AML/CTF compliance pressures. It's been clear for some time ARNEC's limited independence and resourcing are struggling to provide that regulation required. Long and short-term solutions are both required. Both should be funded by the federal body, and powers to adequately enforce compliance. ARNEC needs to be provided with more resources and funding, encompassing other regulators such as the ACCC, RBA and APRA. If vertical integration continues, the conveyancing industry cannot survive. When the same entity controls both the technology platform and the delivery of services, independent practitioners are squeezed out. This removes competition, limits consumer choice, and undermines protections that come from having an open and diverse profession. We have already seen the risks in practice in 2018 when PEXA, when operating as an ELNO, registered a conveyancing company, as previously noted. The Australian Institute of Conveyancers called them out and the business was quickly deregistered. The example shows why clear boundaries are essential to protect the industry and, more importantly, the public. We urge the committee to recommend explicit safeguards. LNOs must not be permitted to expand into conveyancing services. From July 2026, conveyancers must act as financial gatekeepers, verifying clients, monitoring transactions and reporting risks to Austract under new anti-money laundering, counter-terrorism, financing, AML-CTF laws. Finally, AML-CTF obligations add complexity and cost. These reforms increase reliance on the LNOs and banks. Without safeguards, there is a risk of overreach, with LNOs or banks expanding into conveyancing workflow under the guise of compliance. And because AML-CTF obligations are federal, while LNO regulation is state-based, inconsistency is inevitable without stronger national oversight. We support competition, but the committee must see both the good and the bad of interoperability. Australians deserve an e-conveyancing system that is fair, strong and focused on people, not big players. Buying and selling a home should not mean paying too much, taking extra risks or facing delays that could be avoided. This won't solve with talk. It needs action, real competition, strong rules and protections for consumers. We therefore recommend that the committee mandate interoperability as part of a suite of reforms, strengthen regulatory oversight with a federal body incorporating RBA, APRA and ACCC, address up and downstream risks and conflicts of interest, legislate to protect the independence of the conveyancing profession, align competition oversight with ACCC and consumer protection frameworks, and ensure AML-CTF reforms complement, not compromise, competition and independence. Keep innovation, infrastructure renewal and consumer protections at the centre of reform. We thank you and we welcome your questions.
Thank you, Ms Nguyen, and thank you very much too for declaring that perceived conflict of interest, having formerly been on the board of Simply. Can I ask you first and foremost, one of the big criticisms of the interoperability program is that there's significant cost to implement it. Do you think that the lower costs for clients at the end of the day are going to be adequate enough to compensate those that are going to be subject to the higher costs to implement the interoperability?
That is a tricky question. I think in general that electronic conveyancing in its conception was perceived to make conveyancing cheaper for the end consumer. In fact, it's actually added additional fees to a consumer settlement statement that we as conveyancers provide. So I think in the short term it may not, but ultimately as we move forward and there is true competition in the market, we will ultimately see those improved fees and efficiencies brought to the market.
Has the cost of conveyancing actually increased over the last 10, 20, 30 years, or is it just that because you've got that extra set of fees now, they've become more transparent?
Well, we're always transparent. We have an obligation to be transparent on a settlement statement. So we have additional fees on the statement for obviously PEXA, PEXA fees. There are additional verification of ID fees that are required of us. I think what's also important to note is electronic conveyancing has brought efficiencies to the land registries. However, they have not reduced their registration fees. They also continue to rise every year with CPI. Where they don't examine documents manually anymore and it's all done by business rules. So those fees are not passed on to the consumer as a reduction for the efficiencies that other industries are benefiting from.
Your submission notes that ARNAC should first use all of its available powers. Now, what specific powers do you believe ARNAC still possess that it hasn't exhausted?
I think we've heard earlier that under the Moore and the New South Wales specific operating approvals, they do have an enforcement regime in New South Wales. However, if you think about it practically, there is no way that any registry is able to use those enforcement powers. They can't switch PEXA off. They can't revoke their operating licences in those jurisdictions. It would be impossible to do so. Banks and land registries would not be able to revert back to a paper settlement tomorrow if required to do so.
Okay. You recommend exploring, and I think the phrase you used was legislative alignment with the Competition and Consumer Act to ensure e-conveyancing platforms are subject to modern digital platform competition rules. So what are the most important, or most pertinent, I suppose is a better way of saying it, modern digital platform competition rules that you believe should be applying to ELNOs?
Do you have any thoughts on that, Sakila?
So I think there's a short term and there's a long term. So obviously right now, with the current format, I think ARNEC don't have enough resources in terms of what they can do, and therefore we're not sort of moving forward. And
when you say resources, are you talking legislative resources, human capital, dollars,
the legislative,
oversight?
So obviously ARNEC has got is built up of the registrars, and the registrars really their role is to protect the title, the registry. They're really not needed to be having to now take on the hat of managing of ARNEC and then trying to regulate an ELNO. So maybe it's that they need to be a steering committee or something to that effect. But that there are people that are employed to run and follow through with this. This is what we're saying. We see that the ARNEC and the registrars, they are at capacity in that realm of what they can do, and their hands are tied in terms of their role is really to protect the registry.
Could I just add to that? So I think if we step back, Shakila's quite right. ARNEC is established by the Registrar Generals, and each jurisdiction head that up. They are there to protect the integrity of the register and the administration of that, and that's what they do. They don't step outside and touch on the financial settlement process within an ELN. However, they regulate that it must be done and is mandated to settle electronically. Okay. I think the challenge also lies with the registrars, and with all due respect, they work very hard at that. But most of them are government employees who have never practiced out in industry or have the acumen for commercial understanding of how a big commercial player such as PEXA or Infotrack work. So I think sometimes a lot of the aspects are outside of their scope.
Okay. Senator Darminer.
We've heard in various submissions and read the impacts on consumers and also your members. I just wanted to know, I just wondered if you could expand on the kind of practical impacts that you see in your practice from your members in terms of consumers and also your members, and how, how prevalent are some of the problems that have been identified and what would the practical benefits of interoperability be for your members and consumers? Like, just give us a bit of a real world picture from your perspective around these things.
Sure. So cost to consumer on delayed settlements, we have, if for instance somebody's having a simultaneous settlement, so they've sold one property, buying another property, if one of the settlements falls over or is delayed, people could be having their removalist trucks waiting, which I think we've heard earlier before as well. Holding expenses, there's also the mental anguish as well, and there's also the stress that sits behind it. So conveyancers can be sitting in the background trying to draft up licence agreements, trying to report back to the client saying, we're sorry, we're doing everything that we possibly can. So that's why we're waiting sort of for the platform to be ready, or settlements to be ready. So I'm not sure, as I said, there's sort of the stress on the settlements, how that sort of goes for people.
There's also financial penalties built within contracts of sale, that should, in that example, the property not settle, then the vendors can invoke penalties for every day that the property doesn't settle. And that's an additional cost that may not, a purchaser may not have the ability to find the funds for if it delays out.
And how prevalent would you say, from your members' perspective, would these issues occur? Because, I mean, we're hearing different reports about the depth of the problem. So I'd be very interested to hear from you, you're at the front line. Yeah. Like, how common is it that you would see some sort of problem that would impact a buyer or a seller in a way that, such that would, deliver the kind of stress that we would want to see avoided?
Unfortunately, from our perspective, probably more often than you would think, but conveyancers are very good at managing those stresses behind the scenes to make it good for our clients. And
Is it a daily problem?
I think in some aspects it can be a daily problem. So we talked about earlier, and we heard earlier about settlements sort of pushing out throughout the day. That is quite right. I will say to my clients, it is booked for this particular time. However, be aware it may not settle at that time, because it can settle between 10 and 4:30 at any stage. I think it's also important to note that some of those delays and challenges can come from the sector where we could be waiting for a bank to sign off or a bank to put financial funds in. A lot of that has become digitised from behind the scenes, whereas when we talked about a paper settlement, we could ring and speak to somebody at one of the institutions to sort out a delay in settlement. Now we have to send a conversation, wait for that to be responded, which 9 times out of 10 is offshore.
And back in if I can take you all back to pre-e-conveyancing, we used to ring the banks, book in a settlement, send the cheques in, and your settlement was in for 2 o'clock. Usually you'd turn up at the settlement location and settlement would happen, banking would be done that day. However, what we've found is that now the settlements are being, everyone's accepting settlement for, say, 2 o'clock, but it's not settling till 5. So that is, and in back in the paper days, that if you didn't settle at 2 o'clock or if it just rolled over to 2:30, you'd be paying the other party a settlement rebooking fee. So now, just because it's in a platform and it just keeps rolling over, and we're just expect it to roll over.
Well, sorry, can I just clarify? In the old days when I actually used to be part of settlements, that was because you were actually using people's human time. People from banks and lawyers had to turn up to a particular place at a particular time.
So you have to
make a
rebooking
happen.
fee.
So that's why you had a pre-booking.
Yep.
If it's electronic, you're not using people's time. It can happen any time. So.
Well, it is a little bit of our time, because if the settlement hasn't happened and you've got a client ringing it, you tell your client it's going to settle between 2 and 3. And at 3:30 it hasn't settled. So you've got to log back into the system. It's still my time. I've got to log back in, check that what's happened. I might have to go back to the bank. I might have to ring the broker. There's a few things there. And then the client's going, well, hang on, I've got my removal truck at 4 o'clock. So it's still, yes, it is my time.
Okay, thank you.
And so how much of these issues would interoperability fix?
I think interoperability is once again going to give us the choice in which system we choose to operate within. It may not solve delays of the participants within the transaction, because if you've got a lender that is not ready for settlement or another conveyancer that is not necessarily ready for settlement, that's out of any LNO's capacity to control.
But it might be something that ARNET could have the powers to control, in terms of saying to the banks, well, hang on, these settlements are delayed and it's a regular occurrence with this particular lender, and why is this happening? And if they've got someone to be accountable for. But right now there are some model operating rules, and no one's really making them accountable to it. So that is somewhere that ARNET could have the powers to say, well, okay, in a week, out of 400 settlements, only 100 settled within a 2-hour period. What happened to the other 300? That's something that I think ARNEC would be able, if they had more powers, that they would definitely be able to.
I think there was, and you'd be able to contest, Shakila, that initially when PEXA came to market, there were transfer guidelines which set out the times frames and KPIs in which participants needed to complete tasks and adhere to, and I think that isn't necessarily complied with as much as they may have been initially. So that's definitely something to be readdressed.
Mm-hmm. And I think everything's all merging together. So you either talked about it or it's certainly in your submission. I'm just trying to balance up. There's commentary around, I think initially consumer costs may go up, but overall the introduction of competition will improve pricing, innovation and service reliability for customers. So can you just talk about that a bit more, because it seems like it's 6 of one, half a dozen of the other.
Yeah, I think if we look at across our sector, we use a lot of different systems and platforms every day. We have verification of ID systems, we have practice management systems that we utilise. Searching platforms and so forth. So we have the choice in why we choose to use one over the other. That also comes with those providers pushing to innovate, make their systems better, provide us as practitioners better fees and charges against that, which ultimately are passed on to our clients, you as the end consumer. So that happens in other aspects of the process in which we undertake our work. However, that doesn't happen within the ELM.
I'm not sure if you've had a chance. There was an individual submission. There are a couple, but of conveyances. I'm not sure if these people are your members or not. But there was one that took my interest, Helen Rodriguez. I don't know if you're familiar with the submission she put in. She talked about PEXA squeezing out small business, increasing fees, and selling data products to other players, including the banks, and that essentially, this monopoly was squeezing out small players. How reflective of that comment would you say it is of the experience of your members? And if you're not familiar with it, I'm happy for you to take it on notice if you want to look at the submission in more detail.
I think we do need to take that one on notice. Thank you.
Thank you. And just finally, just last one from me. In your submission, you talk about policy makers needing to adopt a realistic view of both timelines and benefits. Can you just expand on that a bit more, particularly in terms of what are the kind of key inputs to that, particularly around timelines and how do we kind of get to some kind of resolution of what appears to be a wicked problem here?
Obviously, around the timelines for delivering interoperability, we all note that timelines have been set, timelines have been missed, and there is no impact, there is no consequences to those timelines being missed. We as the end consumers are the ones that miss out on that, and all of our members, and then ultimately the consumers, because there is no additional choice there. But you also can't rush it. It needs to be done correctly, securely. The reduction on, PEXA saying they've spent $20 million, I'd really like to understand where that's been spent to deliver interoperability, because we really only have had a few handful of IOP transactions over the 4 or 5 year period. So I can't say where that is. As far as the regulation, ARNEC doesn't have the ability to keep it on track. As much as I respect what they do, they don't. If they did, we would have been much further along. They also have no ability or to bring the banks along to that conversation and to work within the IOP program. So it's either one or the other. We either all agree to move forward, or we sit stalemate and we'll have the same conversation in 2 years' time.
Thank you. Thanks, Chair.
Senator Smith.
Thank you very much. Thank you for your evidence. It's been quite revealing. So before this morning, where did you take all these grievances and aggravations and disappointments?
So look,
who's been listening to you?
Oh, conveyancers, other conveyancers.
Other conveyancers.
Other conveyancers.
It's like a conveyancing agony group. Conveyancing agony group somewhere out there.
We do. And look, there is the ability to obviously put a submission in to ARNEC. You can write into the ARNEC chair if you have any questions or concerns or things that we would like addressed. However, conveyancers are incredibly time-poor people, and to be honest, I'm not sure it actually goes anywhere. So,
well, thank you for your evidence. The vertical integration is an emerging risk. Yes.
Yes.
Great. Thank you very much. In its submission, PEXA identifies a variety of innovations under 3 headings: better experiences and greater efficiency, features to improve security, tailored operational functions. In your experience, has the PEXA system been remarkable for its level of innovation and sophistication? And
well, I mean, if you go into the system itself, you've got the documents, which is the transfer document. If you're talking about a standalone transfer between a vendor and a purchaser, the transfer document was always available to us. We used to print it off on a laser printer. I think that was a requirement back then, and it sent it out 2 copies. So if you lost one, you always had another one. So that was always there for us. The auto balances, we do them. That's just a standard general accounting term. You know, you're buying this property and these are your ancillary costs, and then you take that away from your loan, and then what you're getting, and then you say to the client, this is your balance. That's something that we conveyancers have done. It's nothing new. It's something we've always done. So the whatever PEXA is built in, it's what we've done in the paper days. It's just building on from it was something that they added well after the fact that the platform was actually working. It was a new thing that they added. I think it was around 2019. But it's something we've always done, and most of us still will cross-check on our adjustments and double-check that those figures are right. We're not relying solely on the system. So those are things that we already did in paper.
Well, perhaps I might just read them out quickly, and you can say, yes, Senator Smith, that's a particularly innovative solution. Linked settlements, ready to
paper,
ready to book.
We did that in paper.
Mobile signing.
Well, we didn't do that in paper.
PEXA projects.
I've only used it a handful of times. So.
Complex settlement support.
Complex settlements.
Support.
We always settled complex settlements in paper.
PEXA key.
Don't use it.
Don't use it.
Solicitor, mortgage, discharge authority.
We always had a discharge. When anyone was selling, they had to sign a discharge.
PEXA planner.
Don't use it.
And PEXA trader.
Don't use it.
In your remarks, you talked about, you just mentioned, I was hoping you could expand on it, inconsistent lender readiness.
Yes, that's probably a bugbear of all conveyances. In the paper world, there was a lot more accountability. In the electronic space these days, we speak to people via conversations. We don't know who we're speaking to. Most lenders don't have a phone number you can call back to their settlement team anymore to resolve or escalate issues that are of a matter of urgency. So now we send a message in the PEXA platform. They've got, a 4-hour turnaround time from the bank's KPIs, I believe. Happy to be corrected. And then we're at the mercy of, we don't know who's at the back of that conversation, and resolving it quickly in a timely manner for our clients.
Correct. If I can just add on, so if we know a particular incoming lender, we know that they're not going to be able to settle before 2 p.m. So we're explaining to the consumer, saying, I'm really sorry, we can't settle your property at 11 a.m. like you would like us to do, because we're at the mercy of the bank. We know that you're borrowing from X bank. They will not settle before 2 p.m. whatsoever. So it does make it difficult. It's very difficult to now get an 11 a.m. settlement, which used to be traditionally in a paper world, all the times that people would settle, it gave them enough time to sort of move and get removalists and things sorted. But as I said, we now know, as early as possible, as soon as we know who the incoming lender is, we will not be settling before 2 p.m. Or later.
So the window for opportunity, the window of settlement opportunity is narrower than it's ever been before.
Correct.
Because 5 o'clock is a hard marker.
Yes.
When the RBA closes.
Yes. So in the paper days, we always had to wait till after, it was about 12 o'clock, so the banks had time to print the cheques. At least there was a reason, and we knew that. And occasionally you could do an 11 a.m. settlement if you had the cheques printed the day before. However, now that window is a lot less. I had a bank sign off on a settlement yesterday at 4:58 p.m.
How does it work in WA?
I think they can only settle till about 3 o'clock.
They've only, different times.
We have other virtues in Western Australia. Thank you very much.
Thank you.
Can I just ask a question about how many conveyancing transactions in a day you were able to do when it was paper-based, by comparison to how many transactions you can do in a day now that it's digital?
From my perspective, I was also, probably should have noted, I act as the State Operations Manager for outsourced settlements in my days as well. So we could do up to 200 settlements in a day, generally between the hours of 11 and 2 p.m.
And now?
You can probably do the same. However, PEXA does have time slots and the number of transactions that can be booked in on those time slots.
Just to clarify what Ange
So
said.
time slots that mean nothing because you can't do anything till 2 o'clock. Is that what's
Yeah, because
happening?
they could roll over if maybe somebody hasn't signed off or something happens, or maybe there's a discrepancy or a dispute, or maybe the loan hasn't balanced correctly. and
So I
it's
really want to
unsigned.
understand, because like if I'm a conveyancer, I've got my own little ABN, I'm setting up and I'm doing this. How many transactions in a day can I do?
Well, you can do as many as if you want to work 24 hours and you want to settle, you want to do 300 transactions in the month, you're welcome to.
300? No, I just do a day for me. Just give me a day number. How many can I do in a day?
You can do
If I'm working really, really hard.
Well, unlimited, really.
Unlimited.
But only generally.
Yeah, between that two and well, you can book them in to settle from 11 to 5. It doesn't matter whatever time slots you've got, and if they're not hitting the quota of PEXA, which usually you'll be fine, you can settle as many as you want.
So that's the product I buy when I buy my PEXA Access, is a window of time, notionally, between 11 a.m. and 5 p.m.
Correct.
Practically, you've said nothing really kicks off till 2. Everybody's got a bit of a hangover every day by the sounds of things. So 2 o'clock it kicks off. And in that period of time, I could have lined up, as an individual practitioner, hundreds of settlements. Is
Yes.
that right?
Yes, correct.
Correct.
And that happens when you're acting for a big development in the city and you've got a high rise of 400 apartments.
And it all happens on the same
All
day.
happens. You'll probably have them all settling between 2 and 4 p.m. and everything's signed off and it just clicks over. Now, in the paper days, just going back just so everyone's clear, we could still do the same amount of settlements because we would outsource it to a settlement agent. Like Angie said in her opening speech, PEXA is really just the delivery van, and that's what the settlement agents were. We would post our packets to them, they'd pick up our checks and they would settle and do our banking. So you could still do the same amount. You could do a relatively large amount of settlements because you had someone else attending the settlement. That part of this has
So the physical impediment was overcome by employing somebody to be that person.
Correct. We never always went off to do the 100 settlements a day. We always had a settlement agent that went off and did it.
And
that's
those
really-
settlement agents were paid.
Yes.
They don't have a job anymore.
No.
So we've got the e-conveyancer.
Yes.
Right. And what is the comparison? Has there been a cost advantage to consumers by this change from physical to e-conveyancing? What is that benefit to consumers?
It's not an advantage. They've had to pay higher fees for settlement. As opposed to what a beg your pardon.
No, go.
As opposed to what a settlement clerk or settlement agent would be. Yes, those fees, in comparison to what the PEXA fees are higher.
And 2 additional fees are mentioned in your submission. And please note, I've asked everyone so far today to respond to your submission, which was late coming in, but nonetheless very useful. 2 additional fees: establishment and maintenance of the database, and additional fees payable to the responsible LNO.
Yes. So I think that's covered in the cost analysis benefits of interoperability. So as both Mr. Cohen and Mr. Joyce would stipulate, there will be a cost charge to, so whoever's controlling the end of the transaction, which is part of the financial settlement in interoperability, would be the responsible LNO. They initiate the financial transfer and send all the documentation through to the registry.
Which is PEXA at this point in time.
Currently PEXA, yes, you're correct. So they will be the RELNO. And then the PELNO, which would be simply in that situation, would pay PEXA a fee, which would then obviously be on charge through that transaction.
Okay. Can I ask if you have ever received any compensation of any kind for delays in settlement and loss of time for you?
No.
What's the fee that is paid by the conveyancers to PEXA to use their product?
So it's actually paid, so from our clients, a purchaser and a vendor will pay currently $140.58 on each side of the transfer. So that's onto their settlement statement.
And the banks pay.
It should be noted that the banks do pay a lesser fee. I think that, I don't recall who mentioned it this morning. It was you.
The same.
No.
And do some banks get a better deal than others?
I can't.
Because there's been speculation about Commonwealth Bank.
We don't know.
What is the fee the bank pays?
It's about $51.
Wow. That's
So
only
there's a very
third.
difference.
Yes.
That's quite different to the evidence they gave us this morning.
Okay.
So I think it should also be noted that in the transaction, the fees charged to the vendor or the purchaser are highlighted in the financial settlement statement in PEXA. However, we don't have any transparency over what the banks are charged in that transaction.
Okay. Senator Smith asked you about a range of apps. One of them is the PEXA Key app. You don't use that?
No.
No. You know the reason it exists is because of phishing with regard to emails and people losing their deposit, you know, hundreds of thousands of dollars in some circumstances. What platform do you generally advise in your sector to use to provide better protection?
We basically will speak to our client, and we will also get them to provide us with either a bank statement or an email confirming the account, but we will always verify over the phone. Keeping in mind that I have heard from practitioners in Victoria that have used PEXA Key, they found that their client had to download an app, save it onto their phone, but she said then it was always on there. She said it just was more highlighting that about PEXA more, and she felt as a small business operator was taking away her business and this whole PEXA thing, and she wasn't feeling comfortable with it because she said, why should PEXA be the one? Like the PEXA Key app is basic, it just says PEXA Key on there. It's not branded to the Conveyancer. Yes, it's a service that they offer. So practitioners have chosen not to use it. Some use it.
Okay. And the thing that's appealing from what I read about it is it gives a reimbursement of up to $2 million if money goes missing, if there is a if there's an incident where money is lost in the transaction. What protections exist outside of this PEXA Key app that is used in your sector?
Cyber security. There's a lot of people have the cyber insurance cover. Then there's the PI insurance. So there are ways to protect the consumer.
Okay, and are they apps?
No.
No,
They're insurances.
They're a different model.
Yeah.
Are there any other apps of that kind that you're aware of?
Not that I know of.
Okay. It struck me as we've been hearing evidence today that we're talking about the risks of a monopoly. I mean, some of the advantages of a monopoly it's very precious information. It's very important to people. As we've said, it's the biggest transaction all gathered in one place. You know, when it's circle the wagons, you know, keep it nice and tight and tidy. That's kind of the mind frame that would draw us to that practicality. And my understanding is that's how it was set up originally, to create a continuing monopoly with those sorts of protections. This hearing has been talking about competition, but we've only got to the point where it's a duopoly. Is that sufficient? Will that create enough competition to really start to affect prices in a positive way, to drive innovation, or does the market really need to be open to a minimum number of players to address the concerns that have been raised here?
I think there
Is that risk or advantage?
Look, I think there was a third player that was looking to come to market who recently pulled out this year.
Who was that?
That was LexTech. So they were looking to come to market. They
Yes.
were approved by ARNEC, I believe, Category 1. And working on their Category 2 approvals, and they've decided to pull out of the market. Maybe that's a question that could go back to them for the reason as to why they've done so. And I guess we could also look at the current duopoly conversation in Australia with Coles and Woolworths.
Right.
You know, where are we from that perspective? We've got challenges with, you know, their staff being underpaid, great returns to their shareholders. We as consumers are paying higher prices at the checkouts. So why would it be unrealistic to think that, you know, maybe just a duopoly is going to solve all our problems? I'm not entirely sure that's the case.
With regard to ARNEC, they'll be before us this afternoon, but everybody keeps talking about resourcing, and I think a few questions have been asked about the different kinds of resources they need. They traditionally had nothing to do with financial settlements of any kind at all.
No.
Yet many of the submissions, including yours, are arguing for a role for them in terms of the financial part of this transaction. Given the lack of confidence in ARNEC at the moment, is that really the entity that you think is the appropriate place for the challenges that you face to be addressed?
I think it's the only entity we currently have. I mean,
so make it fit in even if it doesn't?
Well, not necessarily. I think it could be looked at to, is that the right regulator to move forward? I think when electronic conveyancing first came to being, there was probably no consideration from the legislation that there would be a second LNO to market. You know, e-conveyancing was established initially as a government body to deliver a national settlement platform, and then it's evolved into a private enterprise, of which we now know is PEXA. So maybe initially in the first instance when COAG decided that we were going to do this, and then they put the task to the individual registrars around the country to deliver it, maybe it worked then. I don't think it works now.
Is this a case where the old way of the paper was a better way, in your view, than what we've currently got?
I wouldn't say that. I think PEXA is a great platform, and once again, you know, we're not here to bash PEXA. We do a lot of transactions every day, and they go through and it works effectively. But we are very concerned from a practitioner's perspective and a profession. What does that look like in 5, 10, 15 years' time, when we all hopefully retire? What is left for the next generation of professionals in this industry?
And what is your fear exactly?
That
PEXA takes everything over.
Correct.
And increases its monopoly.
Yes, correct.
Okay, thank you. Thanks, Chair.
Thank you, Senator O'Neill. Thank you very much. We'll let you go for appearing before us today. And I should say, if there were questions that you took on notice, the return for questions on notice is the 16th. From memory? Right. 16th of September. Thank you very much.
Thank you for your time.
I just might advise, because I don't know if the witnesses were here, I believe that your evidence, which I read in, was refuted by another witness, so they might need to respond to that. Yes. Thank you.
Right. Thank you.
We are now running half an hour behind. I'm acutely conscious of that. For the sake of senators that might be on the line and those that are at the table, I'm suggesting that we have the banks in front of us for 3/4 of an hour rather than an hour, and the ABA, and we break at 1:15 rather than 1 p.m. Okay, so I now welcome representatives from the Australian Banking Association, Commonwealth Bank, National Australia Bank, Westpac and ANZ.
So, ANZ's here in person, or the rest are on the teleconference?
Can I ask who's on the line?
Yes, you've got Chris Taylor and Craig Evans from the Australian Banking Association.
Hello, Mr. Taylor and Mr. Evans. Who else have we got there?
You've got Matt Dawson from National Australia Bank.
Hello, Mr. Dawson. Is there anyone else there?
Yes, here's Mark Uzo from Bank of Australia.
Sorry, you have a terrible line. Would you please speak up a little bit, Mr. Meneguzzo?
Yes, this is Marcos Meneguzzo from Commonwealth Bank of Australia.
Thank you very much. Is there anybody else there? No.
This is Ashley DeCruz from Westpac.
I'm sorry, could you just say that again? It's a very distant line.
Ashley DeCruz from Westpac.
Mr. DeCruz, thank you very much for joining us. And I'm assuming that I have Mr. O'Neill in front of us. Thank you very much from ANZ. Thank you all very much for attending the committee today. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, we've already stated everybody's full names and the capacity in which they appear. I'm going to invite you to make a very, very brief opening statement because we have an awful lot of representatives here today. I might start with the ABA, if that's all right. Mr. Taylor or Mr. Evans, if you would like to start with an opening statement.
Thank you, Chair, and members of the committee for the opportunity to appear today on behalf of the Australian Banking Association and on behalf of our members, some of whom are with me in this session. The ABA welcomes this inquiry and appreciates the opportunity to contribute to the committee's consideration of micro-competition opportunities. The banking industry is strongly supportive of e-conveyancing. Digital settlements have been a major innovation, reducing delays and delivering real benefits across the property ecosystem. At its simplest, e-conveyancing replaces paper files and couriers with secure digital processes that bring together the two major steps in a property transaction: the transfer of funds between a buyer and a seller, and the updating of property ownership and mortgages on state title land registers. What used to take days can now be completed in minutes. This innovation reduces fraud, improves compliance, increases the chances that Australians settle on time and move into their homes when expected. The move from paper to digital delivers hundreds of millions in productivity benefits to the economy each year. Our members have worked closely with state and territory governments to help expand digital transactions and increase national consistency. However, because land and property law is state-based, inconsistencies across jurisdictions continue to limit efficiency. The Northern Territory and Tasmania are still finalising their move away from paper-based and physical settlements. E-conveyancing represents a material opportunity for productivity improvements to their economies. There is also clear opportunity for the Commonwealth to play a stronger role in driving harmonisation. A nationally consistent framework would reduce complexity, improve efficiency, and ensure reforms deliver long-lasting benefits to Australians. At its heart, reform in e-conveyancing should be judged by its ability to maintain timely settlements, minimise risk, and provide certainty for home buyers and sellers. Since 2019, the ABA has actively participated in government process to introduce competition through interoperability. Our members have invested significant time and resources in workshops, industry panels, state inquiries, as well as providing ongoing feedback to ARNEC on the functional requirements that must be met in order for the program to succeed. But our support has always been conditional. We would only support interoperability if the issues we have consistently raised from the beginning are addressed, namely that the framework must be functionally equivalent to current processes, must not introduce new risks to on-time settlement, and must not degrade the customer experience. While there has been 6 years of engagement and investment, these core concerns remain unresolved, particularly around functionality, integration, and settlement reliability. These are not theoretical risks. The success of e-conveyancing has been built on deep integration and automation, which has underpinned Australia's world-leading settlement reliability. We therefore welcome ARNEC's decision to pause the program and initiate a review alongside a cost-benefit analysis to address these concerns. These processes provide a vital opportunity to determine whether interoperability can deliver on its promise and resolve the issues that we have consistently highlighted since 2019. Thank you, Chair.
Thank you. That was Mr. Taylor, I'm assuming, that was speaking. Can I just remind...
yes, that's correct.
Thank you. Can I remind those that are joining us via telephone to say their name before they speak, so for the sake of the Hansard transcript. Mr. O'Neill, as you are in here in person, I might go to you next.
Sure, thank you. Dan O'Neill, General Manager, Customer Service Operations at ANZ, and thank you for the opportunity to appear before you today. I have responsibility for ANZ's customer service operations for the retail and commercial bank, and that includes digital settlements. So ANZ has supported work to enable interoperability in e-conveyancing since it commenced in 2019. In that time, we have engaged constructively with government agencies and industry to help develop a solution. We support, and of course we welcome, competition between electronic settlement providers. We recognise its potential benefit to us, the industry, and more importantly to our customers. We've been clear that interoperability should not lessen the standards of service we provide to our customers or increase the risk of failed settlements. ARNEC's current review is an opportunity to develop a plan to achieve interoperability in a way that avoids these outcomes. We remain ready to assist with any such plan. We have a very positive working relationship with both Simply and PEXA. We've worked with Simply since 2019. In December of that year, ANZ and Simply participated in Australia's first four-party purchase settlement. We currently use Simply as the default electronic settlement provider for all transactions where there is no debt. We are also running a pilot to use Simply for bank-to-bank refinance settlements. So we look forward to continuing to engage with the relevant stakeholders on the path forward, and I thank you and welcome any questions when they're ready.
Thank you, Mr. O'Neill. Mr. Dawson, I might go to you next.
Certainly. Matt Dawson, Executive Home Ownership at National Australia Bank. Good afternoon, Chair and members of the committee, and thank you for the opportunity to participate in today's hearing. Buying or selling a home is one of life's biggest milestones. At NAB, we're committed to making that journey as simple, safe and stress-free as possible, from the very first conversation with our customers right through to settlement day. Since the introduction of e-conveyancing in 2013, we've seen major improvements in what was once a complex and sometimes frustrating process for buyers and sellers. We hold ourselves to a high standard when it comes to the experience that we deliver. In 2024, NAB supported over 180,000 settlements across PEXA, Simply and paper settlements. Nearly 96% of those were completed via PEXA. During that time, and for the majority of the last 3 years, NAB has ranked number one compared with peers for having transactions signed on time through the platform. We believe in a competitive market and have supported interoperability reforms from the outset, actively participating in this work since 2019. In 2023, NAB was one of 2 banks that piloted a series of interoperable transactions, allowing us to see the process and customer experience firsthand. While we support interoperability, we won't compromise on the overall experience for our customers. The interoperability work to date has not met the standards needed to maintain this experience and the significant improvements that the industry has made. NAB is ready to work with ARNEC and the broader industry to continue the conversation, provided the path forward protects the significant progress we've made for customers. We look forward to contributing to today's discussion and continuing to be part of this important conversation.
Thank you, Mr. Dawson. Mr. Meneguzzo.
Thank you, Chair. This is Marcos Meneguzzo, Executive General Manager of Commonwealth Bank. Thank you, Chair, for the opportunity to appear before the committee today. The Commonwealth Bank of Australia has been supportive of efforts to transition the property industry towards a digital settlement solution. Alongside state governments and the banks, we are actively involved in the development of PEXA to improve the manual nature of the property settlement system. We consider this to be a successful Australian innovation. Government and industry working together to create a digital settlements platform for the nation. Electronic conveyance has provided a great settlement certainty, transparency, and reliability for all parties involved in a property transaction. It has driven greater efficiency and improved outcomes for our customers. As Australia's largest mortgage lender, our focus is on ensuring that our customers can successfully settle on the day they expect, safely and efficiently. CBA has participated in ARNEC's interoperability program since inception, and we use both PEXA and Simply to complete standalone mortgage and discharge transactions. Consistent with the Australian Banking Association's opening remarks, our support for interoperability is on the basis that the system must be safe and sustainable, must not increase the risk of failed settlements, and should result in equal or higher standards of service, functionality, and certainty for both market participants and for our customers. We are engaging with ARNEC's functional requirement review and look forward to the outcome of that review. There are further opportunities to make the system more efficient. The state-based approach to conveyance has led to a fragmented national e-conveyance environment with significant differences in documentation requirements, verification processes, and electronic lodgement capabilities. Improving national consistency would allow for further process efficiencies and would be a win for our customers. Thank you.
Thank you, Mr. Meneguzzo. And Mr. De Cruz.
Thank you. Ashley De Cruz, from Executive Manager from Mortgage Operations at Westpac Group. Westpac thanks the Chair and committee members for the opportunity to appear before you today. Westpac supports the continued evolution of Australia's property sector toward a more digitally enabled settlement process. Electronic conveyancing has delivered meaningful improvements, enhancing reliability, transparency, and certainty for all parties involved in property transactions. These efficiencies benefit our customers and contribute positively to the broader economy. We are committed to a safe and well-functioning e-conveyancing environment. Over the course of the interoperability program, we've worked constructively with government and industry stakeholders to help shape its development. However, our support is grounded in the need for a system that is robust, secure, and capable of delivering consistent service standards. It is essential that any move towards interoperability can be achieved at a cost that is proportionate to the benefits. It does not compromise settlement integrity or introduce new risks for customers. At present, we hold significant concerns that the interoperability program will not deliver the intended outcomes.
Thank you, Mr. Oh, sorry, you haven't finished. Go ahead.
We believe this program should be considered within the broader context of ongoing efforts to lift productivity. Given this, and noting the time passed since interoperability was first announced, it may now be time to explore alternative approaches that promote competition while preserving the reliability and efficiency of property settlements for customers. We acknowledge ARNEC is exploring alternative models in its second cost-benefit analysis, and we look forward to participating in that process. Thank you.
Thank you, Mr. De Cruz. For the sake of time, I'm going to ask senators here to direct their questions to a specific witness rather than the panel, and also those that are joining us on the phone. If they could not be on speakerphone and talk directly into the phone, it will make it much easier for senators here to better hear your testimony. I'm going to kick off with a question to the ABA and probably Mr. Taylor. The ABA and its members, Mr. Taylor, could you tell us whether you are comfortable with the concept of a single point of failure, something that has come up numerous times from other witnesses today?
Thank you, Chair. We have listened to some of the other testimony that's been given today, and there seems to be a recurring theme around single points of failure and the role of CPS 230, which is a prudential standard that applies to banks to consider the risks from their material suppliers, of which an electronic conveyancing system would be one. CPS 230 is essentially about making sure financial institutions can manage operational risks properly. That requires them to have strong systems in place to identify their risks and to have appropriate plans if things go wrong, while ensuring that both their board and senior management have appropriate oversight on those risk management processes. It's not about how many operators are set up in the market. It's about being resilient and prepared no matter the setup. I might pass to my colleague Craig, who can provide a little bit more detail on this issue.
Thank you, Chris. So under CPS 230, an APRA-regulated entity must define, identify and maintain a register of its critical operations, take reasonable steps to minimise the likelihood and impact of disruptions to its critical operations, and maintain a credible business continuity plan that sets out how it would maintain its critical operations within tolerance levels through disruptions. So, and essentially what that would involve is ensuring that the maximal that for each critical operation, the bank must establish tolerance levels for the maximum period of time the entity would tolerate a disruption to the operation. So what it is actually about ensuring that they have contingencies in place if there's a disruption, not necessarily ensuring there are no disruptions. And I would also note that, you know, LNOs are not the only single point of failure here. There are other aspects within it, like land titles offices, RBA, ASX. There are several other operators that banks have to deal with that would act as single point of failure, but it's more about ensuring that we have systems in place to handle any of these disruptions that might occur.
Thank you, Mr. Evans. Your submission also suggested that alternative models might be better placed to serve both customers and your clients. So can I ask you about the infrastructure model or the enhanced pricing regulation and how those potential models might achieve that competition and consumer uplift compared to interoperability?
Thank you, Chair. As I mentioned in our opening statement, the support for interoperability has always been conditional on that system being safe, efficient and effective. Importantly, there are two key components to any property settlement. The first is the financial side, a buyer paying a seller for the property, which is then followed with the land title registration to perfect the transfer of that sale. And those two pieces are inherently important as part of that sale, both to buyers and sellers, obviously. Part of the feedback that has been provided by member banks since the review in 2019 is the importance of these two items to be considered together. While every state has a different approach and has been very focused on the registration of titles, that financial settlement piece is also a critical component. That is why we are very supportive of the current review that ARNEC has undertaken following a pause to take on board this feedback, to look at three key areas. Firstly, the functional requirement review. Now, this is going to consider broader models for interoperability, including the practitioner first model or the infrastructure model, as they're sometimes interchangeably called, and look at the key requirements that market participants, including conveyancers, lawyers, and banks, require in order to have a successful e-conveyancing system. Secondly, that review will also undertake a revised cost-benefit analysis. The original cost-benefit analysis, which really looked at the cost outcome likely to customers, and by customers I mean mainly the conveyancers who would then pass on those costs to home purchasers and sellers, really considered only the cost of accessing and using an e-conveyancing platform. This broader cost-benefit analysis will also consider the overall cost to the system and the cost of building interoperability in a more holistic way rather than simply looking at price. While that is one component of it, understanding the benefits or the opportunities of micro-competition requires understanding the full end-to-end cost. And finally, they are also considering the overall regulatory review and an uplift that might be required to any regulation as a result of those first two elements of the review. So this is a live process that ARNEC is running, Chair. We understand that they are likely to be delivering those outcomes in October, or certainly a little later this year. And we welcome that opportunity because I think it will address the viability, feasibility, and the cost of the various models that are being considered in respect of e-conveyancing.
Okay, thank you, Mr. Taylor. Senator Darmanin.
Senator O'Neill. Could I just ask each of you, Mr. Taylor, do you know what the cost per transaction for the banks is to use the PEXA product?
Senator, this is Craig Evans. We are not party to any of the individual contracts that take place between PEXA and individual institutions. So we do not have that.
Do you have oversight to know whether it's the same price or are there differentiations across the market?
That's a matter for individual institutions to answer. We do not see that sort of pricing.
Thank you. We've had evidence today from the conveyancers who said that the cost is around $51 per transaction. Can I just go to you, Mr. O'Neill, first? What does ANZ pay PEXA for per transaction?
It depends what type of transaction it is. So if it's a mortgage with financial settlements, it could be anywhere around $70. If it's a discharge, it could be anywhere around $50. So it depends on the transaction.
But that's the rough price range. Mr. Dawson from NAB, could you give me the figures for NAB's payments to PEXA?
Yes, certainly, Mr. Dawson. The figures referenced by Mr. O'Neill are the publicly available figures that I'm aware of, and for reference, these are not passed on to consumers by National Australia Bank.
And is that why they do not show up in the disbursement costs that were discussed by the conveyancers?
Correct.
Okay. And so just to be clear, Mr. O'Neill's evidence was $50 in a particular circumstance, up to $70 in a different circumstance. Can you confirm that that's the case?
Yes, there's a range of different transaction types, and each transaction type will have a different fee.
Are there any higher than $70?
Not to my knowledge.
Thank you. Mr. Mancuso, it's been put to us that CBA has a 24% share in PEXA, and there's a conflict of interest potentially in that. That could be a reason why there's no pursuit of competition against PEXA. Let's just start with how much you have to pay PEXA per transaction.
My understanding, Senator, is in the same range of the numbers that have been mentioned earlier in the call. I don't know how much all the banks are being paid, but I think early in the day, Mr. Phillip also mentioned that, Mr. Russell actually also mentioned that the fees are standard across the industry.
So if you could confirm and I'll get you all to check this and confirm in writing exactly what you pay with a differentiation indication across the range of services that you ask PEXA to do, from the least to the most complex, and everything in between. Mr. De Cruz, Westpac, how much do you pay per transaction to PEXA?
We pay the fee that is disclosed on the PEXA statement of fees for any transaction type. That's no different than what was mentioned by other banks,
right,
in terms of that fee range of either sometimes 50 or 70, depending on the type of transaction.
And are you aware of the fee that is paid by those who use it, who aren't banks, is nearly it's 3 times that amount?
I'm not aware off the top of my head of the fees that conveyancers pay. I'm solely aware of the fees that the banks pay for that, and has been noted by other banks. We don't pass that fee on directly to consumers.
Thank you. I want to go to a comment made by Mr. John Ahern, who said, from Infotrack, who said things were progressing well with ARNEC, and there were dates set for developments that Simply was happy with. And he said the actual pause occurred in the progress I'm referring to, the actual pause occurred when the banks withdrew from those meetings and agreements, discussions about services. There's been a lot of speculation today about why the banks withdrew from those ongoing meetings with ARNEC. Why did the banks withdraw? Mr. Taylor?
Sure. Thank you, Senator. I don't think it's correct to state that the banks withdrew support. As I mentioned in my opening statement, banks have been very clear and consistent from the beginning that their focus for successful interoperability requires ARNEC to consider not only the interests of Land Titles Office in successfully registering title, but also the financial components of a transaction. If you don't have a successful financial settlement, you do not have a need to make a land transfer. So this is a consistent piece of feedback that has been provided throughout this process from 2019. There is a constitutional law issue in terms of states having primary responsibility over matters of land title, but not necessarily having jurisdiction over financial transactions. And so ARNEC's initial concern was that they did not have the powers to consider the financial elements of a transaction. This is something which
that is a view that's widely held, that ARNEC do not have the power to oversee the financial dimensions of the transaction, and therefore there is a glaring blind spot.
So that was initially the position that they took as to why they could not consider the financial elements of a transaction, which of course, if you want a successful e-conveyancing transaction, you need both the ability to register the title and the ability to settle the transaction. But they are actually now looking at that as part of this 3-part review. And we think that is a significantly helpful development for a successful interoperability proposal.
And Senator, just quickly to add on to that, and banks are participating and the ABR are participating in the functional requirements review and in the cost-benefit analysis that is being conducted as well under that process. So banks are participating as part of the process.
So this inquiry is in the shadow of some significant work, it seems, so that will be of interest. But can I ask one final question? All of you use the sort of terms significant concerns about interoperability. What does that actually mean? And what do you make of PEXA's evidence to this committee that they have IP over very significant parts of that interoperability puzzle?
Well, Senator, just to begin
Sorry,
with your
who is
point
that?
about what the concern... Oh, sorry, this is Craig Evans from the ABA.
Thank you.
In terms of the concerns, I mean, one of the key factors that enables banks to complete many e-conveyancing transactions and settlements without delay is the degree at which bank platforms are tightly integrated with user interface features and triggers that have been designed by the incumbent. Banks have close system integration with these additional functionalities, and it greatly supports our ability to manage and prepare a large number of transactions in a timely manner. Our position is that interoperability must result in an equal or higher service standard to customers than what we are currently provided, and that interoperability must be the same or functionally equivalent to transactions available today. And if there was any failure to consider financial settlement, as we've talked about before, including the additional functionalities within the scope of the IOP reform, that would risk the current settlement rate. And we understand that part of the terms of reference of the current functional requirements review is to identify the full scope of functions which are required to achieve equivalence between electronic workspaces. And I'll throw to Mr. Taylor to talk about the IP issue.
Thank you, Senator. I think in relation to the intellectual property issue, I believe letters or correspondence has been tabled to the committee about the nature of those of that correspondence. We're not able to speak to the matter of intellectual property and whether or not that is either adequately protected or an appropriate claim. That is something that ARNIC is currently considering as part of its review. The only interaction that we have had as banks was as part of this review. We were asked that if there is intellectual property being conveyed to ARNIC as part of their review, that given that that property was owned by PEXA, that it was appropriate. Information is being provided by PEXA.
Sorry,
for the
Mr. Taylor,
review.
can I just get you to go back a little bit because you broke up and we couldn't hear what you were saying? Just about 10 sentences back. Not that you count them.
So as I've mentioned, I believe you have letters tabled.
We do.
With the committee in relation to the intellectual property claim. We are not able to assess the validity of PEXA's intellectual property claim. All that banks have been asked to do is that if they are participating in a review with ARNIC, which they are, and they have intellectual property that belongs to PEXA, that it is appropriate for PEXA to provide that intellectual property to ARNIC as part of their review. And what I was saying at the end, Senator, was we understand that that information is being provided by PEXA to ARNIC to enable them to consider particularly the functional requirements review that is currently being undertaken.
Okay. One question, final one, and you might need to take this on notice. There's been a lot of debate and discussion about injecting competition in. Clearly, PEXA's argument is they expected to have a monopoly. That's what they think they purchased, and they are seeking to continue that, and they argue that it's providing security. However, if we are pushing towards a competition model to improve outcomes for consumers and introduce further incentive for innovation, etc., and productivity gains, is a duopoly really sufficient? Or is there a minimum number of points of access, points of potential failure that the system requires to be truly robust?
I think that's a very broad question that you've asked, Senator. As I mentioned at the outset, our support for interoperability is conditional on it being safe, efficient and effective. We believe that necessitates not only can it be done, but can it be done in a cost-effective way which actually provides sufficient benefits to justify it being done. The second point you raised about single points of failure, as a society, we live with single points of failure every day. Banks have a higher standard at which they need to assess and manage the risks of those single points of failure, but that doesn't necessarily mean that those single points of failure need multiple redundancies. It simply means that they need to be appropriately managed. And for some of those single points of failure, there may be no replacement. And that is why there are regimes like the Security of Critical Infrastructure Act that apply to certain critical infrastructure to ensure that they are appropriately protecting themselves against the type of threats like cyber and other forms of malicious attack. That's probably all I have to say on that issue, Senator. I don't believe it in and of itself justifies moving to an interoperability regime, or that competition, simply because competition is good, justifies moving to an interoperability regime. It should be the outworking of a considered functional review, a considered cost-benefit review, and a considered regulatory review. We have noted in our submission that there are alternative models that might be considered, including further price control, an appropriate regulation that might drive and encourage incentives for innovation, but that should be the outworking of ARNEC's review, not necessarily something that we jump to without actually doing that fulsome work which ARNEC is currently undertaking.
On notice, could I ask each of you to respond to the Conveyancer's submission and their evidence today? And also on notice, if you have received any recompense for failure points in the service provided to your entities by PEXA or simply. Thanks. Thanks, Chair.
Senator Smith.
Thank you very much. To each of the individual banks, are you prepared to agree or comply with the outcomes of the functionality requirements process that's underway and the updated cost-benefit analysis work that ARNEC is undertaking?
Why don't we start with Mr. O'Neill, and then you can name your banks. Yep.
Yeah, sure. Very much so. Key for us is that, as mentioned before, it improves and doesn't increase the risk of the environment, improves the standards and services that we can provide, and provides a better customer experience. Then very supportive.
Westpac?
Mr. De Cruz?
Yes. We are prepared to do that. As Mr. O'Neill said, this is about whether this is robust and making sure that our customers are able to continue getting on-day settlement. That's the key for us.
Mr. Dawson?
Yeah, certainly. We support interoperability and have backed ARNEC's work from the start, both via the ABA and individually. And we remain supportive and want to continue to restart efforts, provided that path does not compromise on the outcomes to customers.
And Mr. Meneguso?
Yes, we are supportive. In fact, we just met with the consultants who are doing the review early in the month. We look forward to the results, and we understand that both community and regulators they expect us to look after our customers, so we share the same kind of not concerns, but we share the same standards are met, and we continue to settle on time, securely and safely.
That's you.
Am I correct to assume that each of the banks was intending to participate in the interoperability program that was suspended in June 2024 prior to receiving the letter from PEXA? Is that a correct assumption?
We participated, certainly from ANZ, prior to and post any letter from PEXA.
Westpac?
We participated in all of the meetings of the Interoperability Committee. I believe some of those occurred after any letters, and we continue to participate in those meetings.
Combank?
Yes, we participated, and we continue to support, and even after the suspension of the program, we actually completed the pilot with Simply that we had committed to.
And National Australia Bank?
Yes, we participated and will continue to do so.
So it sounds to me that the Australian banking industry supports interoperability with heavy caveats: robustness, customer safety, security. What I'm keen to understand is the granularity. So what is the robustness test actually? What is the customer safety test actually? So on notice, can each of the banks provide to me in granularity what those statements actually mean in granularity, in functionality.
And Chair, could I just add to that, an additional item on notice is around, I don't know which one of you mentioned it, but cost effectiveness, because I think I understood that some of this is also about the cost to you in terms of interoperability.
Correct. In Mr Evans' responses to some questions in regards to the APRA CPS 230 requirement, he spoke of contingencies being put in place. So on notice, can each of the banks provide to the committee what contingencies are or will be in place should there be a significant incident related to the PEXA platform? Now, given the sensitivity of this information, witnesses are free to make the information available to the committee in confidence. And the committee will meet those in confidence commitments from our perspective. And just to be clear, again on notice, if each of the banks could categorically state that as the APRA regulation or instrument requires at item 20, the board of each bank has consciously considered the application of the APRA CPS 230 in the context of the e-conveyancing platform provided by PEXA. Thank you.
Senator Darmanin.
Maybe just one on notice. It seems that certainly for, I think, CBA and ANZ in your opening statements, you both specifically referenced greater efficiency and outcomes for customers and standards of service all being improved. However, we've heard from previous witnesses that actually things have slipped in terms of timing of settlements, costs, and efficiency. So wondering if you can comment on how is it you've arrived at your assessments that efficiency, outcomes and standards of service for customers have improved in a bit more detail. That's it for me. In the interest of time, you can put it on notice.
All right, I think we might leave it there if that is the case. Thank you very much to ANZ, National Bank, Westpac and CBA and the Australian Bankers Association for appearing before the committee today. If there are questions that you have taken on notice, the return date for those questions on notice is Tuesday the 16th of September. We will let you go. The committee will now break for lunch. We will return at 1:50. Is everybody happy with that? At 1:50. Thank you very much. And I welcome Mr. James Endres and Dr. Rob Nichols, Mr. Marcus Bain and Mr. Richard Bootle of Law Lab. Before I go to you, to all the witnesses, can I just confirm also which senators we have on the line? Do we have Senator Sharma or Senator Canavan? Perhaps they will join us later.
Yep, I'm here. Sorry, Chair, I'm here. No, Canavan. Yeah,
okay.
Sorry.
Thank you, Senator Canavan. For the witnesses, I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you each please state your full names and the capacity in which you appear today? We might start with you, Mr. Endres.
So my name is James Andre, and I'm appearing in a personal capacity.
Andre, I'm terribly sorry I mispronounced your name, Mr. Andre. Dr. Nichols.
Okay. Dr. Rob Nichols, and I'm also appearing in a personal capacity.
Thank you very much. Mr. Bain.
My name's Marcus Bain, and I'm here on a personal as well, please.
And, oh gosh, Mr. Bootle.
Richard Bootle, appearing in my personal capacity and on behalf of Law Lab Conveyancers.
Thank you very much. Before we continue, I'm just going to, for the sake of entire transparency, let the committee know that Mr. Bootle and I once danced around a stage together at a musical in our university days. So, hello, Richard, how are you?
Very well, thank you, Jane.
Terrific, thank you.
I wasn't going to mention that. I'm sure it's not relevant, but
That's
thank
all right.
you.
I can assure you that as much as you're blushing on the other end of the line, I'm blushing here too.
Exactly, conflict if you stand on your feet, Senator.
I'm sure
someone hasn't been able to forget the experience.
All right.
She's a great dancer. What can I say?
And now that we've got that West Side Story moment out of the way, I invite you each to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions. Mr. Andre, why don't we start with you?
Thank you, Senator. Let me start by saying that I appreciate the opportunity to appear before this committee. I'm an economist with over 25 years' experience, working across many regulated industries, most notably telecommunications and transport. My experience includes advising regulated firms, government and regulatory agencies about when to regulate as well as how to regulate. And that also includes when not to regulate. As per the submission I co-authored with Dr. Nichols, the e-conveyancing industry displays evidence of what economists call market failure. Both the ACCC and the New South Wales Productivity and Equality Commission have both raised concerns about this observed market failure. The fact that there is at least one credible market entry into the e-conveyancing market, which is at the moment Simply, suggests that this market failure is not due to natural monopoly. Rather, it is because of a lack of interoperability. ARNEC's inability to deliver interoperability over the last 4 to 5 years is a reflection of the fact that it was not established nor properly resourced to oversee the development of interoperability and the associated technical standards needed to drive improved competition outcomes. My main reason for appearing here today is to emphasise the importance of promoting competition via the development of mandated interoperability. I also wish to emphasise that time is of the essence. Every day without interoperability benefits the incumbent at the expense of consumers and the new entrant. We have already seen one potential new entrant, LexTech, leave the market. We must not risk simply doing the same. Thank you.
Thank you, Mr. Andre. Dr. Nichols, do you have anything to add to that?
Yes. So, Senators, the reason I'm giving evidence today is that I've spent much of my career in technology regulation, competition law and digital markets. This includes as an advisor, a regulator and as an academic now at the University of Sydney. My current research focuses on digital platform regulation and competitive market structures. My practical experience includes serving as Australia's independent telecommunications adjudicator, resolving network access disputes. These are the foundations of one form of technical interoperability. I was also an ACCC General Manager regulating telecommunications, competition and interconnection requirements. Way back in 2019, I served as the independent chair of both the technical and regulatory groups examining e-conveyancing interoperability under the New South Wales Registrar General. That process brought together stakeholders that you've heard from today, from banks to conveyancers, state revenue to the Reserve Bank, and the ACCC to New South Wales IPART. Without interoperability, competition is impossible. PEXA's 90% market dominance isn't a natural monopoly, it's a regulatory failure. It's institutionalised monopoly pricing reflected in 56% EBITDA margins. It also means barriers blocking viable competitors like Simply and in the past Lextech. The cost-benefit analysis that we included in our submission shows interoperability delivers $3 of benefit for every dollar spent. It's an area that's ripe for competition and the associated productivity benefits. The stakes are the same as they always are when interconnection or interoperability are required. Deliver that interoperability or entrench monopoly rent. Australians have long collective experience in leading network regulation. At the heart of this is knowing that network effects become anti-competitive weapons without regulatory intervention. Thank you.
Thank you, Dr. Nichols. Mr. Bain. Mr. Bain? We might come back to Mr. Bain. Mr. Bootle, do you have an opening statement?
Thanks for the opportunity to dial in today, Chair. Law Lab is owned by my partner and I. We have 60 staff. We started as a country law firm that won federal government a tender to design and deliver the water purchase program for the Commonwealth Department of Water. We got in a car and drove to every local water authority across the MDB and learnt process and developed trade forms to acquire $3 billion in water for the Commonwealth Environment water holder. Following that, we decided to leverage software we developed and our staff expertise to move into land conveyancing, where we digitised every jurisdiction and transformed ourselves into a national and soon to be international property law firm which specialises in house and land conveyancing. We developed the first electronic land contracts in most jurisdictions and then had to fight every bank to accept them. Even though they said they accepted digital signatures, when it came to settlement, they tried to fail them. We have spent over $10 million on our e-conveyancing software, which includes a secure messaging function like the innovative PEXA key, except we did it 10 years earlier. When we entered the industry, the settlements industry was incredibly competitive with over 10,000 lawyers and conveyancers and 5 largest settlement agents, all who could settle land transactions. Now there is effectively a single hulking monopolist. Who did this to us? Was it a natural monopoly like railways in Victorian England? No. PEXA lobbied governments using the sort of 0.05% of property delays, sounding familiar from this morning, to claim an entire industry failure and to get a statutory mandate. That's why government has the responsibility to force PEXA to comply with the 2022 mandate to interoperate. I know it was the states that did this, but it is a national problem with national consequences, and I'm hoping for this committee's support.
Thank you, Mr. Bootle. Mr. Bain, do you have an opening statement?
I do, sorry about that. Thank you, Chair, and the members of the committee for the opportunity to speak today. I'm a conveyancer at Bain & Young Conveyancing, and I also work as a legal agent completing high volumes of settlements and e-lodgings. I come here to represent not only my own business, but hundreds of other small conveyancing practices across New South Wales. Our concern is straightforward. The current e-conveyancing system is dominated by a single player, PEXA. At present, there is no alternative platform available to practitioners. That means if PEXA goes down, property settlements across the state grind to a halt. Families are left stranded, practitioners are powerless to help them, and the financial and emotional toll can be enormous. This is a clear single point of failure in a system that underpins the property market. For small businesses like mine, the risks go even further. Without competition, PEXA will continue to expand its reach.
Over time, it will not just dominate the technology, but also edge out small conveyancing practices that form the backbone of this profession. The livelihoods of thousands of practitioners and the choice available to consumers will be placed in jeopardy. The reform under consideration are not abstract policy changes. They are about ensuring security, reliance, and fairness in a system that millions of Australians depend on. By enabling competition, government can give practitioners like me a genuine choice of providers. Competition will mean better service, lower risk, and the knowledge that if one system fails, the entire property market will not come to a standstill. The issue has been left unresolved for too long. The time for action is now, before it is too late and the monopoly becomes impossible to unwind. On behalf of my colleagues and countless small conveyancers across New South Wales, I urge this committee and the federal government to act decisively. Please do not let us down. Thank you.
Thank you, Mr. Bain. I'll just kick off with a couple of questions. Can I first ask you, Mr. Bootle, would you mention that you have an e-conveyancing platform as part of your practice? Does that mean that you are potentially a competitor to PEXA and Simply?
No, it's one of those things that PEXA is an e-settlements platform. It calls itself e-conveyancing, but it actually just does the settlement end. E-conveyancing, starts with contract prep and contract exchange, all sorts of things that actually don't involve PEXA. It's one of the great overreaches of PEXA, and it's the sort of thing that in their prospectus they clearly said that they were going to expand into adjacent products and service offerings in the broader property market. And calling yourself an e-conveyancing company, PEXA sort of already told the market what it wanted to do. And, I reiterate what Mr. Bain said about the concern that all conveyancers and all other people in the property industry have about a single monopolist and the ability to use monopoly rents to drop into adjacencies and actually, take out an entire industry.
Thank you for that clarification. Mr. Andre and Dr. Nichols, you have said that in your submission that ARNEC's new reviews will largely replicate previous technical and economic analyses. And yet it does seem that the ABA and the banks who spoke to us earlier implied that until ARNEC's review was completed in October this year, there's really little movement that can be done from a legislative or reform perspective. What would you say to that assertion?
So, Rob Nichols, one of the key things that I think is missing from that assertion is the history that's gone on since at least 2019 of examination of mechanisms for interoperability. So, yes, we're waiting for another ARNEC report, but that ARNEC report is building on a series of other reports that have gone on since at least 2019. So, yes, we have to wait, but we've been waiting a very long time looking specifically for interoperability solutions that will allow entry. James.
In addition to what Rob said, or Dr. Nick said, we made that statement before we knew the exact form of the functional review and the scenarios that the cost-benefit analysis was actually going to consider. Having said that, though, what we know from other industries, where you have a monopoly, where you have an entity with significant market power that is opened up to competition, consumers benefit. It increases. It not only lowers price, it improves service levels. It drives innovation in the long term, and that benefits the economy as a whole. So we know that competition is a good thing, and we know that interoperability, regardless of what form it takes, will drive competition. So, I question whether or not doing another cost-benefit analysis is likely to find a different result. Having said that, though, this cost-benefit analysis is considering a number of different scenarios compared to what the 2018 cost-benefit analysis did, and importantly, it is examining some of the scenarios like the practitioner first model, which may move forward some of the benefits of competition, because that is a retail-only form of competition, and that may bring forward the benefits of competition, which may be a good thing. So we're not saying that what ARNEC is doing is a bad thing or that they shouldn't do it. What we're saying is that they should move with haste.
Okay. Thank you, Mr. Andre. Senator Darmingham.
Thank you. I think my first question is probably to Mr. Andre and Dr. Nichols. Just in terms of your kind of professional background and experience, in your submission on page 4, the top paragraph highlights, I guess, the approach of the banks in raising concerns around the platform functionality and data standards. And you say that whilst this concern is not unreasonable, its significance is heightened by the fact that PEXA has not shared details of its platform functionality, data standards, blah, blah, blah. In your experience, to the extent that you've had in this regard in perhaps other environments, is this kind of usual sorts of behaviour in terms of if we're trying to get to some improvements in an industry and working together around problem solving, I guess, where you have different stakeholders coming together? Like how would we normally, what would you see in other scenarios around trying to work through complex issues like this?
Bob, do you want to take that first?
Yes, sure. Senators, I think part of it is actually making sure that both the sides of the interoperability have a clear understanding of what these issues are. And I'll give 3 separate examples, if I may. In the telecommunications industry, back in 1997, after we'd had our period of a mandated duopoly and moved into open competition, our businesses were going to interconnect into Telstra in a way that Telstra's network would not collapse in a heap, which was a Telstra line at the time, essentially required coming up with standards which set the way that interconnection would work. And those interconnection standards look very much like the forms of what are called application programming interfaces or APIs that we would use for interoperability. Similarly, in vertically integrated industries such as electricity, there's only one set of electrons going into one person's house, but retail contestability was nevertheless able to be implemented by looking at the whole of the system and working out where was a natural monopoly, where would there be problems of vertical integration, and solving for those. And perhaps more relevantly, the introduction of the consumer data right, which started in the banking sector, was initially resisted by the banks as providing too much complexity, providing potential insecurity. But actually, once the consumer data right aspects had been implemented, it allowed the banks to offer new and more valuable services to their own customers based on the information that they might be required to share under the consumer data right. So these are things, they're not trivial, but they're all able to be solved and have been solved in similar environments in Australia over the last 20 years.
And in this scenario then, if they're not difficult problems to solve, where should the responsibility lie to try and facilitate the solving of this problem that we have here? Is it in the, I can't remember what, the round table through ARNEC, elsewhere? Like how can we overcome the current stalemate, I think?
I think, Senator, we have two issues. One is, well, it could be ARNEC, but potentially you might want something which is a little bit more independent. It could be a committee established by ARNEC that has that level of independence that means that each of the registrars general that form part of ARNEC has the same motivation and encouragement to allow that interoperability. An alternative would be to say, no, this is purely a competition issue, and potentially ask advice from the ACCC to how is the best way of making this work. But we do have perhaps another complication, which is that federation issue, that actually the interoperability is on a per state basis, but the microeconomic and micro competition opportunity that flows from it is on a national basis.
Thank you. Now just a couple of questions to Mr. Bain and Mr. Bootle. Beyond cost, what sort of service improvements or innovations would you like to see from ELNOs?
Bob, do you want to go? No, he's not there. I guess what we've seen is there was a fair amount of innovation in the period before the mandates, PEXA mandates were produced, and then it basically has sort of stopped at that point. We can see the better integration with individual law firm software. We want to see better workflows, easier sign-ins. There's a whole lot of things that we take for granted when using other software that just still doesn't exist in PEXA. I suppose it's not even about us designing what the new innovation might be. It's just that we know from basic monopoly theory 101 is that there will be there's no need for innovation going forward with a monopolist. That what we get from competition across the board in all other markets is the light bulb moment that actually transforms that experience for both ourselves and our customers. And I think that's the real concern, is that sort of innovation will cease. And not just the fact that that costs are never going to drop in a monopoly. And lastly, that the monopoly rent is going to be used to invest in things like AML where PEXA will go higher up the value chain and get access to our clients and agents that refer to us at the moment and sort of take over that transaction.
Just to add to that as well.
Yep.
There's a lot of double handling at the moment with our sort of practice management softwares and going on to PEXA. So without that innovation, we're sort of just doing a lot more admin work and just doing it twice because our systems can't talk to PEXA, which just creates a lot of downtime and just a lot more work for us practitioners.
So I'm not sure if this is a follow-up or perhaps an additional question, but in terms of this double up that you're talking about, but how do compliance, cybersecurity and technical requirements for accessing ELNOs impact smaller firms like yours compared to large banks or national practices? For either of you, I guess.
Especially for... Oh, sorry. Do you want me to go?
Sorry, can I just ask each witness to make sure they say their name before they speak, just for the sake of the Hansard transcript? Thank you.
Sure, my name's Marcus. It's a lot of most of the a lot of sales, for example, with sort of account details, and that's the main sort of concern that we have to use as a practitioner. So to have it put it into our system and then put it in again into PEXA can then cause sort of errors at our end. So maybe if the systems could speak to each other, then we would make less errors admin-wise. I suppose that's the only thing I could think of as a practitioner on my end.
I'm happy to leave it there, Chair. Senator Smith.
Thank you very much. I think we're all agreed there's a problem. Perhaps PEXA and the banks might be an exception to that statement. What is the pathway forward? A regulator or a forum that has not been mentioned a lot is, of course, the Council of Financial Regulators, which has on it the treasurers of each jurisdiction. So what is the pathway forward? What is the path of easiest cooperation between the various parties, or the path of least resistance between the various parties? I think the incumbent, like PEXA, benefits when stakeholders like the banks say, oh yes, we do agree, but here is our caveated position. Oh yes, we support interoperability, but these are all the excuses, if you like, and they are excuses that are very familiar to the CDR debate, various other debates which you've highlighted. So given your extensive experience, how do we move the issue forward? Because delay and obfuscation helps the incumbent. As we've heard and as you have alluded to, there is an emerging risk of vertical integration. So what is the right way in which to move the issue forward?
If I may, it's James. I'll take that question first. I think we need to have clear accountabilities. So at the moment, ARNEC, given that it's done a wonderful job today, given what it's been, given its makeup, it's the Council of State and Territory Registrar Generals, and it wasn't set up with a clear mandate to deal with competition issues or a clear mandate to drive the technical processes required to achieve interoperability. An organisation needs to take on that accountability and be able to be appropriately resourced to execute on that mandate, and also have appropriate enforcement powers in order to ensure that there is cooperation. So my concern with having a council of regulators or a council of state and territory bodies is that they may not have a clear mandate, they may not be appropriately resourced, and so, I would look towards a greater role for, regulatory agencies such as the ACCC or the RBA, and that they have, a clear mandate and a clear accountability and a timeline by which they should be achieving the outcomes.
Now, just staying with... sorry, gentlemen. I'll let you continue. Yep.
Rob Nichols, just to add to James's point, I think that ultimately it requires a direction to make it so. And that direction could be simply, it is our microeconomic policy that there should be interoperability between LNOs, so that there is a trigger to allow the ACCC or the Reserve Bank or other financial regulators or financial regulators to be able to work on this as a problem. I think part of the issue is there is a need for leadership and a need for direction, and that direction doesn't have to be you must do it and you must do it this way. It's simply that this is an expectation.
It's Richard Boodle from Law Lab here. I would add to that, and maybe slight different emphasis, which is that you as a committee could allocate federal funding to support state-based delivery of interoperability between the LNOs and make it a condition of grant that they achieve that. And then I guess an alternate way, directing ASIC and APRA to work with the major banks on managing resilience risk. So basically make them come up with something, and hopefully that something is interoperability and an alternate to PEXA. And lastly, just request ACCC to examine PEXA's market conduct and impacts on competition. I think it just can't be overestimated how important ACCC work is, but to clarify that and to come up with some adverse findings if that's what they find.
A possible course of action might be for federal government ministers in their statements of expectations to relevant agencies like the ACCC, like APRA, for example. Statements of expectation get issued at the beginning of a parliament or when a new minister is put into a portfolio. So these statements of expectations could be provided by the federal government to APRA, to the ACCC, for example, not exclusively, there may be others. When the agency, ACCC or APRA, issues its statement of intent, which is a response to the statement of expectations, this might be a mechanism, this might be a mechanism to bring greater regulatory focus on the issue from the federal government's perspective, without it necessarily having to take responsibility for what is a state-based regime. That might be a suitable course of action. And of course, gentlemen, I'm not speaking to you. I'm speaking to those officials that might be listening to the hearings today and that might be coming forward later today as witnesses. But given your extensive experience in regulatory matters, would that be a possible pathway? Mr. Bain? Mr. Bain. I'll go to Mr. Andreas and Dr. Nichols, given that they're given their regulatory experience. Yeah.
So, Rob Nichols, I think that when I mentioned expectations, yes, the letter of expectations that is provided by the relevant minister to each of the regulators, and I think you could even broaden it out beyond ASIC, APRA and the ACCC to include AUSTRAC and potentially even the ACMA, that actually the provision of interoperable electronic lodgement network operator systems is an important part, and all decisions should be consistent with that policy objective. As you say, it's the response that comes back from the regulators that's really important on this, and a regulatory decision or comment from the ACCC is likely to have significant effect on the sector.
Thank you very much.
Senator O'Neill.
No questions from me, thank you.
Okay. Any questions from either Senator Sharma or Senator Canavan on the telephone? Shrieks.
No, I'm all good, Chair.
Oh, thank you. Thank you, Senator Canavan. All right. Thank you very much to those witnesses, Mr. Andreas, Dr. Nichols, Mr. Bain and Mr. Bootle. If you've taken questions on notice, the return date for those questions is close of business Tuesday the 16th of September 2025. I'm going to ask that you disconnect from the teleconference, although should you wish to continue to listen to the hearing, you can do so through the Parliament's website. Thank you very much for appearing before the committee today. And
thank you for the opportunity.
It's a pleasure.
Thank you. Thank you.
And I now welcome representatives from the Australian Register's National Electronic Conveyancing Council. Oh, hang on, just wait just a couple of moments. Mr. Cameral's on the phone. Terrific. Thank you very much. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please both state your full names and the capacity in which you appear today?
My name is Sushila.
My name is...
We might start in the, we'll just, sorry, we'll start in the room.
My name is Sushila Vijendran. I'm here in the capacity as the Deputy Chair of ARNIC.
Can you just repeat your surname for me so that I can make sure I pronounce it properly?
Vijendran.
Vijendran, thank you very much. Ms. Vijendran, and on the telephone?
Good afternoon all. Matthew Cameron is my name, and I'm appearing in my capacity as Chair of ARNIC.
Thank you very much, Mr. Cameron and Ms. Vijendran. Do you have an opening statement for the committee?
I believe Mr. Cameron
We do, thanks. Yes, thank you, Matthew Cameron. So, firstly, ARNIC thanks the committee for the opportunity to appear at this public hearing to provide a brief summary of its submission and to answer questions from the committee members. By way of brief background, ARNIC is the Australian Registrar's National Electronic Conveyancing Council and is made up of the land titles registries of each Australian state and territory. The Commonwealth is not represented on ARNIC as it does not operate or regulate a land registry. ARNIC is constituted under an intergovernmental agreement among the states and territories and was established to implement and manage the regulatory environment for e-conveyancing throughout Australia. ARNIC is not a legal entity, but rather a council, and as such, ARNIC's decisions must be implemented through the registrar of each jurisdiction. ARNIC is keen to establish a framework for competition in conveyancing as it is likely to deliver benefits including choice, price competition, innovation, better customer service and resilience where there is no single point of failure should one electronic network operator fail, and provides incentives to invest in resilient offerings as a point of differentiation. ARNIC's members have clear regulatory authority and expertise in the conveyancing processes in relation to the preparation and lodgement components of conveyancing transactions. However, ARNIC members have specific and limited powers to regulate and do not have the requisite experience in relation to the financial aspects of e-conveyancing transactions. Indeed, the financial aspects of e-conveyancing transactions fall under the regulation of multiple Commonwealth regulators, including the RBA and ASIC. There is currently no single regulator with clear remit to oversee an end-to-end e-conveyancing transaction and with clear authority to effectively regulate all participants in the e-conveyancing ecosystem. Similarly, if regulation of the end-to-end e-conveyancing transaction rests with several regulators, their roles and remit are not clearly defined, and there's been no overall analysis to ensure that all activities within the e-conveyancing that need to be regulated are regulated, and if so, by who. To conclude these opening statements, I would reiterate on behalf of ARNIC in its submission to the committee that the committee should consider who the right regulators are across the e-conveyancing process, reviewing the regulation of key participants in the e-conveyancing process. Any pro-competition reforms need cooperation from participants such as financial institutions, conveyancers and lawyers. The involvement of other regulatory bodies, including competition and financial regulators, should be considered to achieve that cooperation. The committee should also consider what is the best model for competition oversight of LNOs to facilitate competition through the entire e-conveyancing ecosystem. Thought needs to be given to how much regulation can be achieved through the cooperation of multiple regulators. The committee should also consider any alternatives to introduce the competition in the e-conveyancing market. Thank you, committee members. That is the opening on behalf of ARNIC.
Thank you, Mr. Cameron. I'm going to kick off. Almost every witness today has said that they support competition in the sector. And most have said that they support the concept of interoperability. But interoperability seems to mean very different things to each different witness. So I would like to ask ARNIC's opinion of what the goals of interoperability are from their perspective. First of all, from your perspective, I should say. First of all, if lower prices are one of the goals, what sort of lower prices are we talking about? What should we expect from interoperability? What are the prices for electronic lodgement for a purchaser of a home today? And what should they be if interoperability works?
I'll take that one.
Yes, Ms. Vigendran.
Thank you, Senator. I think the various analysis and cost-benefit analysis in particular in the past have considered that particular question, and the expectation is something in the region of less than $10 per transaction if interoperability was implemented, is my understanding. There is a cost-benefit analysis, a refreshed cost-benefit analysis exercise underway, and we're expecting to get better insight and more up-to-date information as to how much of a benefit, including pricing, we will see from an interoperable market as compared to other forms of competition as well.
And when you do your cost-benefit analysis, I'm assuming you'll be very specific about who the costs fall on and who the benefits go to as well?
Ultimately, the costs will be borne by the purchaser vendor of land. These are costs that have been always passed through to purchasers and vendors, to the extent that they also benefit from perhaps greater innovation in the market, in electronic conveyancing, speedier, more efficient, with greater certainty, as we heard throughout the day around on-day and on-time settlement. Certainly we see benefits in that as well, but ultimately we would expect the benefits to flow through to the community.
I suppose the reason I ask that is because the costs for implementing interoperability do tend to fall to one part of the sector, and the benefits of interoperability or lack thereof also fall to another part of the sector, and not all of those costs or benefits directly flow to the consumer. There can be subsidiary costs and subsidiary benefits that might flow, for instance, to an organisation that has vertical integration, or to a bank that doesn't have to implement new systems, or whatever it might be.
Yes.
That might not necessarily be, at the end of the day, in the consumer's hot little hand. So your cost-benefit analysis will take that into account?
I believe it will. I think there are overall productivity benefits as well, and efficiency in markets considerations that are being taken into account.
Well, that was my next question. So if customer satisfaction or choice is one of the goals, you have minimum operational requirements already, system performance requirements, management performance requirements. They're all written into the modal operating rules, that's correct?
Largely correct, Senator. I think it's only New South Wales that has a customer metric. I don't think the operating requirements have a similar one.
So I suppose the question is, are those standards not serving customers right now?
Given PEXA's feedback that they maintain quite a high level of customer satisfaction, you'd argue how far they could possibly go. That said, we certainly have heard the views of the Australian Institute of Conveyancers and the law institutes and the Law Council as well, that there could be improvement. And, you know, customer surveys are limited, are narrow in their view. There are probably a broader range of customer metrics that we could possibly look at as a measure of customer satisfaction.
So if innovation is one of the goals of your interoperability review, or one of the goals of interoperability, how do you envisage innovation will be achieved for interoperable electronic lodgement network operators if an innovative ELNO like PEXA has to share its innovation with its competitors and gain competitors' agreement to enable innovation for interoperability?
I think Senator Smith did draw out a very interesting point, and perhaps one that ARNEC hadn't carefully considered in the past, I'll admit, as to the extent to which innovation has been a carrying over from paper into digital, and what further innovations there can be beyond that transition piece. It's not entirely clear. I can't say that ARNEC professes to know what innovations it expects from the ELNOs. ARNEC's remit, as Mr. Cameron highlighted, is about lodgement and registration of instruments in the various registers of land. From a registry perspective, While I understand conveyancers have had challenges in the transition from paper to digital, it's been an enormously valuable transition from the registry perspective, and also for customers of the registry as a result. People used to wait months. They'd settle, yes, on the day and probably on time, and then months later, those actual transactions would be lodged for registration, and then weeks before actual registration has taken place. With electronic conveyancing, all the information comes in digitally. We're able to process digitally. We're able to register digitally instantaneously. So there's day savings, there's month savings in terms of innovation across the market.
If resilience of the system is one of the goals of interoperability, how is resilience improved if, and your own paper on the subject says this, if one ELNO is unavailable, no other ELNO could take on settlement and lodgement of the affected ELNO?
If there were multiple fully functional ELNOs in the market, completely agree that it would be challenging. When Optus went down, people didn't switch over to Vodafone overnight, but they could probably within 24 hours, 48 hours, if the outage of Optus lasted for more than a certain period. Similarly, you could conceive of a world in which PEXA goes down. It would take several days for the practitioners to transition over to another ELNO, yes, but it would take you would be able to go to another ELNO, noting the delay in time between that switchover.
Thank you. Senator Darmanin.
Sorry, if I could just add before you moved on from that, just to confirm, and it's Matthew Cameron again, that the retention of a sole ELNO market creates a single point of failure. And I think to your question, Senator, having that multiplicity of ELNOs creates redundancy. And as Ms. Gendron said, if one ELNO goes down, subscribers can switch, even if there is a lag time of hours or days for that to occur. But in a system where you have multiple fully interoperable ELNOs, that gives you that resilience. It also creates competitive pressure, which would be more likely to result in a more secure and resilient offering, as subscribers would likely select the more secure and resilient system. And perhaps that also goes to the question in relation to innovation, innovation within the safety and security of systems and information held in each electronic lodgement network operator.
Thank you. Thank you, Mr. Cameron. Senator Darmanin.
You've made some remarks already about powers of regulation, and we've heard from earlier witnesses around variance between states. So, for example, I think New South Wales gives you the best ability to provide some form of enforcement, I guess. So just if you could talk a bit more broadly about, in terms of your consideration of adequate powers or not, capabilities and resources that you have and or need to regulate compliance, and where would these sit in your view? If in an ideal world, what do you need and where would they reside?
So that's correct, Senator. New South Wales does have quite robust enforcement provisions. There are amendments to the electronic conveyancing national law in progress at the moment to give further powers to all jurisdictions to be able to use bigger sticks, I suppose, around enforceable undertakings and remedial actions and fines and penalties and other actions of that nature. They would be limited to breaches of the operating requirements, which are themselves limited to the matters that are within the purview of each of the state's registrars. To be able to regulate the end-to-end electronic conveyancing ecosystem, which begins practically, you could say at real estate agent level, all the way to lodgement and registration, requires, as others have said, a number of regulators. ASIC for consumer protection and financial compliance, RBA for financial settlement systems, ACCC for market conduct and competition. We've also got the individual revenue officers and their tax processes, but also the professional bodies as well, the legal services boards, and the conveyancing licensing bodies as well across the states. So it is a very multi-pronged process that touches and concerns lots of different bodies, legislative scope, but not necessarily just the registrars. So what we need, Senator, is certainly greater involvement from the Commonwealth, from the agencies mentioned. We have had good engagement to date with the Council of Financial Regulators, but I suspect statement of expectations, Senator Smith, would go a long way to getting momentum in this space and getting greater involvement. And it's, and I also wanted to emphasise that we're in a particular point in time, and when the states developed and COAG developed electronic conveyancing in its very beginning, I suspect we did not, or governments did not expect it to blossom and grow and evolve in the way it did. And it will blossom, grow and evolve in a continuous manner. So it really needs a continuous input, and it's not just interoperability. Interoperability is almost the tip of the iceberg, and it will be a continuous change, a continuous role for all of these bodies to monitor, regulate, enforce and influence in the years to come.
In terms of where we're at right now, and I think you will have heard the previous witnesses, they, in their submission, so this is Mr. Andre and Dr. Nichols, they identified a couple of conclusions that their interoperability process that you've been overseeing has been delayed because other stakeholders have opposed reform, and not because you don't have the resources to drive reforms, and also that there's little chance of making substantial change while PEXA continues to refuse to share its data standards and system functionality. Just wondering if you could comment on those observations and what you see as the driver of the current project before us.
So we have a number of reviews on foot, and it's come to a bit of a head, particularly around the IP issues and the hesitation around sharing. And after some significant negotiation, that material, I believe, has been delivered to the project teams from PEXA and from the banks with PEXA's agreement. So I think we are getting good progress on that front. We will get, I think, at the end of this review period, more information and as much information as we can obtain to make a sensible judgment decision as to how to proceed. I'd say that I suppose ARNEC understands that PEXA is a commercial entity and has its own obligations to its shareholders, but we also consider them to be a highly regulated entity and have a require a social license to operate and provide services to the Australian community. So we would expect them to be forthcoming in that regard as regulators.
Okay, so do I take it from that again, we've heard various accounts of the process that we've got to up until now in terms of full participation, not full participation, information being shared or not shared. But it sounds like from what you've said is that actually following some process, you have actually got more information that you previously had around data from banks and PEXA to enable you to make a good go at the cost-benefit work, I think, that's coming next. With that,
I think the work's being directed towards the functional requirements. That's what's going to the really granular detail that's going to inform the feasibility, and also the the points at which there are touch points with regulators as well. But yes, that'll inform the cost-benefit analysis that's happening in parallel.
Yep. And we've heard that the cost-benefit will be finalised around October. When exactly in October is that, do you expect? And can you give us any sneak peek into how that's going and what sorts of things coming out at this point?
I will say that the timeframes are very tight at the moment. There is a considerable amount of work that the consultants have to do. There isn't a huge amount of information for them to go on. We know quite a lot about interoperability and Direct Connect. We know some about practitioner first or access. We don't know a huge amount about the other models that are being looked at. So there will be variances, I suppose, in some assumptions and rubberiness, I suppose, when they come to a conclusion. And we'll have to use our best judgment based on what the report tells us.
That seems a bit of an issue in terms of coming to
a conclusion.
Proper conclusion. How do you close the gaps about what you don't know? Like, otherwise we're going to be in the same situation, aren't we?
I think we need to be able to have a look at this in greater detail, and I don't think it's actually been done before in any form of detail. So for completeness and for us to be able to make a meaningful recommendation, we're certainly focusing on Direct Connect and the monopoly regulation costs and benefits as well. That will be the main focus, but also, and this is under sort of further consideration as well, as to how we'll get there, because we are literally in the thick of it at the moment.
Thank you. Senator Smith.
Yes. ARNEC is doing 3 reviews.
Yes.
Why is it that the 3rd review, the uplift of the regulatory framework, is not expected to report until the end of 2026, if I understand the reporting of the inquiry, when everyone is saying we have a regulatory failure?
Thank you, Senator Smith. There is an enormous amount of work in the regulatory review. It is because it's covering such a vast expanse of exposure points, I suppose. It is quite a large piece of work. And to an extent, this will also require engagement with the Commonwealth agencies as well to inform some of that work, or for that work to feed back to them. We don't want to hold off on a decision on Direct Connect or interoperability or other models in waiting for the regulatory review. We fully appreciate Simply's position in the current market and needing a decision and some sort of movement forward. So we're working towards that aim and ensuring we have at least a competitor in the market and not holding that up with what could be quite a long process of regulatory review.
How would you characterise PEXA's engagement with the review of the functionality requirements for interoperability? And how would you characterise PEXA's engagement in the work that's being done to update the cost-benefit analysis?
This is still fairly fresh, Senator. We've had a few delays in the cost-benefit analysis. As PEXA indicated, they received the terms of reference in July and are still working through it. They do have some questions and would like further detail. For the functional requirements review, as explained to Senator Demanen, that there has been negotiations on foot on the disclosure of information. So not exactly flowing with information at the beginning, but we are getting through that process and extracting what we need for the reviews.
So on a ledger with obstructionist on one side and highly cooperative on the other, where would you point the dial?
I'd go something in the middle. I'll sit on that fence.
That's a regulatory answer.
She already is. It's been a very diplomatic piece of evidence.
Because I think a key element in this, if I may, is, so let's be crystal clear. Delay is a commercial outcome for some market participants. For others, incumbent systems are cost effective for them in terms of and I'm thinking of the banks here. So people spinning the wheel, my language, but people spinning the wheel, correspondence going backwards and forwards, more questions, is a commercial strategy. It is a commercial strategy. So I'm keen to understand, and I ask these questions up front to PEXA and to Simply and to the banks, will they accept the outcomes of the functionality requirements review and also the updated cost-benefit analysis? They say, oh, well, it depends on what it says. Well, actually, if you've not really contributed in a good faith way to these review mechanisms, then it's very, very easy for you to say, well, actually, we're going to stand still. We're going to move slowly. We're actually, because a lot of emphasis has been put on these two reviews in particular as a way of trying to drive these issues forward. So again, your answer might be the same, but again, I ask, if you had to put the dial, is it an unfair question to be asking you as the regulator?
It's certainly a challenging question, Senator Smith. We are working with all stakeholders to get to an outcome, certainly. We understand the pressures and the considerations of all the parties. We are also keenly aiming for a decision as soon as possible. To an extent, whatever the outcome is and whatever the decision of each of the registrars in each of the states is, what the banks and PEXA and Simply views maybe are worthwhile considerations, but they are not determinants of the decision. Those are matters reserved for the legislative, for the authority that has the power to make that decision. It's implied in that is an ability to compel parties over which we have no authority, such as the banks, to be able to comply with those recommendations. That is the regulatory gap, if you will, that needs to be filled to be able to enable whatever the recommendation is that comes out of those reports.
Or regulatory imagination might be required in terms of finding ways and levers to fix or fill regulatory gaps. You talked positively about the engagement with the Council of Financial Regulators. Could you just expand on that a little bit more?
I believe we meet, Senator, on a quarterly basis at this point, and I think that's a relatively new engagement over the last 12 to 18 months. Mr. Cameron can correct me on that one. He's been around longer. But that is progressing. I think it was progressing a bit slowly, and I think there's been more indication of engagement from members in recent meetings. I think one of the challenges for that particular council is they're dealing with millions and millions of transactions and billions in money flowing between parties. With electronic conveyancing, with conveyancing in general, while 4 million transactions doesn't seem like a lot in the scheme of things, as many of the witnesses have presented and asserted, this is the most important transaction many people will ever have in their life, and having it go like clockwork is of critical importance. So emphasising that with that council has been part of our agenda, and making sure they understand the import of it. Scale is small, but impact is much greater.
Thank you.
Sorry, just to step in and confirm Ms. Vijendra's comments that we do meet with the CFR on a quarterly basis and have been doing so for at least the last 12 months where I've been a member of ARNEC, and that engagement between the Commonwealth regulators and ARNEC is a fruitful discussion on each occasion, with a real focus at the last meeting on where collectively the regulatory powers lie in order to ensure that there is end-to-end coverage of the electronic lodgement system from the point of both the land register but also from financial settlements perspective. So reflecting on it, I think there has been a journey between the state and territory regulators and the Commonwealth regulators to a shared point of understanding as to the need for that clear and demonstrable end-to-end regulation of the settlements, both in terms of the registry and the financial settlement. And senators, I think, to just slightly move on a tangent, that there are a number of different positive views through the submissions that you have before you, which includes recommendations that ARNEC be given further powers under Commonwealth legislation, or that there is that clear and demonstrable step into the space by the existing Commonwealth regulators. From the perspective of ARNEC, I think we are keen to understand or recommend that the committee does make findings and recommendations as to the appropriate model, but where you do have those existing Commonwealth regulators, it may be a less challenging change than to standing up further Commonwealth legislation to empower what are that collective of state and territory regulators with their sole focus at present in terms of their legislative remit on the transactions on land in terms of title.
Thank you. I think, Mrs. Vijendra, your characterisation of the system as being in evolution, my word, I think is an important one, because it allows, so it suggests that the absence of federal regulators early on was not a fault or an oversight, but it does allow for federal regulators to be more engaged and more involved now. So once upon a time, it could have been defensible, may have been defensible, that federal bodies said, not our problem, we have no jurisdiction. That may have been acceptable in the past, but as the system has evolved and strengths and weaknesses of the system have become more apparent, the ability for federal regulators or agencies to say, not our problem, is less acceptable. Would you agree with that characterisation?
I'd agree with that, Senator Smith. Yes, absolutely.
Last point, Mr. Kamarul, in at the very, very end of your submission, you highlight a sense of urgency. So we have heard from conveyancers of the emerging risk of vertical integration. So that is an emerging risk. And then in your submission at paragraph 105, you talk about competition issues will only get more complex to resolve as time goes on. So this is the right time for these matters to be resolved and a clear pathway provided. Are people putting too much emphasis on the outcome of the functionality requirements for interoperability review? And are they putting too much emphasis on the outcomes, some stakeholders, are they putting too much emphasis on the outcomes of the updated cost-benefit analysis?
That's very interesting.
Thank you, Senator.
Sorry, go, Matthew.
Well, we might hear from both of you. We might hear from both of you, if that's okay.
Well, I'll let Mr. Vijendra go first. He has the floor.
Thank you, Mr. Kamarul. Thank you, Senator Smith. That's a very useful insight, because I think the CBA, the cost-benefit analysis, and the functional review requirements are a discrete question There is a longer term question around the regulatory framework that needs to be addressed with multiple parties. So I completely agree. And the more complex and more integrated the incumbent becomes with various steps in the ecosystem, the more difficult it is to unwind things, as I think others have stated. But also the horse might have escaped by that time. And we'd like to certainly emphasise getting that regulatory gap issue resolved as soon as possible. I will also just touch on the vertical integration. There are what we consider separation requirements in the operating rules. Largely they are complied with. We haven't had significant vertical integration issues. I think prior to the introduction of those separation clauses, there was an issue around PEXA registering a conveyancing firm, and very quickly deregistered it. But also since then we've had an enhancement to the regulatory framework to make that a little clearer as well. I understand as the AIC also made a submission in relation to the AML CTF features that PEXA is exploring. We're certainly looking at that from a separation lens and ensuring that there isn't any cross-fertilisation of information functions, systems, resources and staff in carrying out, in allowing PEXA to develop that solution for practitioners. I'll hand to Mr. Cameron now.
Thank you, Ms. Vijendran, and you've really mainly covered the field there, so there's probably not much more that I can add. But I think, to summarise, I think there is significant weight that is being placed on both the functional requirements review and the cost-benefit analysis by stakeholders. And as Ms. Vijendran says, that is one part of the picture, and there are the technical and market-related issues on one side of the picture, but the other side, if you would put it through a Venn diagram, really is in relation to that regulatory piece that is being discussed today and is the subject of much consideration. So we need to get both right. So I think, back to your question, Senator, to say there is too much weight, and sorry, I'm paraphrasing, being given to the outcomes of those reviews, they certainly are very important in the process of delivering an effective market that has competition in it to the extent that provides the benefits that we've discussed throughout these hearings, but also that clear need for the regulatory framework to be clearly articulated and for the gaps to be filled is the other key component moving this forward at this time. And as you put it, this is the right time. The sooner we are able to address these issues, the less difficult it will be, noting that continued market dominance does make it harder for other network operators to enter into the market.
Thank you, Senator O'Neill.
Thank you very much. Thanks for your evidence, Ms. Vijendran. You do have the air of a diplomat, and you've spoken so beautifully about what's going on here. But I have grave concerns that there will be conversations in a pub somewhere tonight about, my money went missing. How did that happen? That is a fundamental problem, that there's gaps in here. People don't know what's going on, right? So my first question is, how much money does ARNEC have? How much do you operate on? What's your budget?
Thanks for the question, Senator O'Neill. I might have to take that question on notice for the exact budget. I'll be able to tell you the Victorian proportion of that budget, but not the entire one. My best sort of estimation is it's in the realm of something like under $4 million, something between $3 and $4 million.
For Victoria?
No, for
the whole country.
Yeah,
okay,
the country.
all right. So $4 million for the entire country. There are land title registrars from every state and territory, how many are on this council?
All of them. Each jurisdiction,
Just one
territory
person?
has one person, a member on that council.
Even the ones where e-conveyancing isn't operating yet, so the Northern
Yes,
Territory
that's
and
correct.
Tasmania. Okay.
Yes.
So that means we've got 7 people for the whole country on a budget of $4 million with no Commonwealth entity associated with you, looking over, supposedly oversighting millions and millions of transactions, to use your language, and billions of dollars. It just doesn't sound like good practice.
That's a very useful insight, Senator O'Neill. I will also say thus far, in the 150-year history of all of our titles offices across the country, this is our bread and butter. We oversee.
Well, the bit that you do is yes, right. The bit that you do with the titles is absolutely core business, deep knowledge, long practice.
That's right. Yes.
But since we've shifted to this e-conveyancing model, about which conveyancers had quite a bit to say in terms of we were promised about what we've got, it hasn't improved how many transactions we can have in a day. It hasn't really improved their sense of productivity. But we know that they are now talking to us about delays in transactions.
Yep.
We've got an entity that has been asserted as making $1 million a day. $1 million a day, and you've got $4 million across a whole year with 7 people trying to keep that train in check. There's reports that, you're doing a lot of work and you're trying to hold the show together, but, just clarify for me that you've developed models of operating requirements and model participation rules. Is that correct?
That's correct, Senator.
But ARNEC has no formal legal, regulatory compliance or enforcement powers to ensure that those requirements are met.
Not the entire ecosystem. So where the operating requirements specify a certain obligation, we have oversight into those. Anything that sits outside the operating requirements is beyond the scope of it's not visible to us. We have no authority over it. And just to clarify, Senator, while there are 8 members on the council, each registrar also has a team. They have teams behind them who do a lot of the technical work.
Okay. So the team behind you, we call that the secretariat. Would that be fair?
Yes, there is a secretariat.
How many
are
on the secretariat?
Secretariat of 2, getting to 3.
2 people.
2 plus
and
1
then
person.
You've got people in the office who are actually doing the registration of the titles and managing that, but they can be called in to do additional work.
So there are various policy people, legal lawyers, registry specialists who work within each of the registries, supporting the work of the registrars. On average, there'll be for the smaller jurisdictions, at least 2 supporting each registrar. For the larger jurisdictions, that can be certainly 4 to 6 people supporting that jurisdiction. So it's not 8 people exactly, it's 8 people plus all of the support frameworks, yes. And the departments, the individual departments that they all are housed in as well. So if there's a need to get...
I want to be comforted, Ms Vigendran.
Yes.
And I have no doubt about how fantastic all the registrars are at looking after the land title part.
Yep.
It's just all the other moving parts seem to be essentially unobserved, and that there is a sort of a comfort blanket lying over it in the terms of model operating requirements about which ARNEC has no formal capacity to have any legal effect.
So ARNEC, I agree, ARNEC doesn't have any legal standing to enforce those operating requirements. It goes to the jurisdictions for enforcement.
So let's go to the jurisdictions. Let's go to New South Wales. I'm a senator from New South Wales. I understand that there's been some additional powers granted in New South Wales, and there's a few things happening there. Tell me what's happening in New South Wales, because that is the lighthouse at the moment.
It is, but
it seems a bit of a dim light to me.
It's in the distance. There is certainly robust enforcement provisions in New South Wales.
And how have they been activated?
I might leave that for the evidence of the New South Wales Registrar General for her to respond to, which I'm sure she will. But also just noting that the Electronic Conveyancing National Law is getting updated and amended to allow all of the jurisdictions to be able to take enforcement powers under the operating requirements and under that law. So that is an evolving space. And one that we're all very invested in ensuring that each of us has enforcement powers.
So, Mr. Cameron, can you assist me with any information about enforcement action by New South Wales?
Thank you, Senator. As Mr. Gendron said, I think that is most adequately responded to by the Registrar General of New South Wales, who I understand will be appearing in the next section of the committee hearing.
Okay. Can I thank you for that, and clearly it would be good to get an answer on those things. Can I go to what on earth happened around the end of 2023 and into 2024, where we've got PEXA, IP issues, more pressure coming into the system from Simply, potentially a third entrant coming in. State and Territory ministers meet on the 11th of June, and we end up with this statement. State and Territory ministers noted recent issues that have been raised by the banking industry in relation to the Interoperability program. Some of these are beyond the remit of states and territories to address effectively. While reiterating their support for competition in the marketplace, state and territory ministers acknowledge the progress of the program faces significant challenges. Without these issues being resolved by the relevant parties, the ministers will raise these with the Commonwealth Government and regulators. As a result, on the 20th of September, ARNEC announced the pause of the design, build and test working groups for the interoperability program and stood down the interoperability project team. Now, it's been put to us that the banks were intimidated by communications, legal communications from PEXA, and basically they said, oh, it's about IP, too much risk for us, we're pulling out. Others have said no. The scale of the problem became absolutely known, and just to make sure that there wasn't a problem, we're pulling back, we're stopping, we're going to do this more carefully. All the scheduled dates for further advancement have been stopped. I have no idea, like my colleague had a wonderful term, trying to pin jelly to a wall, and that's what it feels like at the moment, because I have no sense of a clear truth from anything that I've heard today. What happened when all that went down? What really happened?
What really happened? Senator O'Neill, I'll only be able to tell you what I've been advised of, as I wasn't involved at the time. My understanding was that I think at the very beginning, while the problem statement to be addressed through the interoperability program was broad, it was assumed that it would encompass many things. The more work that was done, the more was revealed around the complexity of the integrations that PEXA had with banks and the complexity of the connections between the ELNOs that would have been required. I think that turning point happened at a point where there was correspondence from PEXA to the banks, and the Australian Banking Association then, I believe, wrote to ARNEC and expressed significant concerns about how the program could progress with those assertions in place that we heard from the ABA.
So hold on, just in plain speak.
Plain speak.
Pretend that we're at the pub, right? Just we're having this conversation. Because this affects Australians, right, in a big, big way. And they need to understand what we're talking about. And sometimes the language is so beautiful, it just doesn't get to the raw, or if I can put it, guts of what's going on. So this system's operating across the country. Conversation, in, out, views, etc. Then it hits a point where everybody goes, whoa, this is big. We need to stop. I'm kind of thinking, how on earth could it be that it took until 20th of September 24 before people went, this is big, we need to sort it out in a different way? Well, I can't understand that there wasn't foresight of that right across the sector.
Senator, I don't think there was full appreciation of just how integrated PEXA had become with the banks over the course of the last 6 years, 5 years.
Exactly the point you make in your second last paragraph that if these things are not dealt with quickly, then they get embedded and entrenched, and we actually have a living example of that, and that is your experience through the interoperability program. Sorry, Senator O'Neill.
But that's all right. But the assumption embedded there is that a monopoly is a bad thing, and I don't know that that's actually been proven today either, because I think the banks actually said that they manage critical points of risk all of the time, and we have APRA overseeing that with the banks, and this is just another one of the critical points of risk that they have to oversee. So I don't know whether I'm Arthur or Martha at the end of this day, to tell you the truth, after all the conflicting stories.
I'm not, Senator O'Neill, if I may, I'm not so sure the bank's interests are different to PEXA's interests. Now, unfortunately, the Hansard doesn't capture facial expressions, Ms. Bajendra, but so could you just, in prose, explain your facial expressions? Because I just said I'm not so sure that the PEXA's interests are different or separate from the banks, or the banks separate and different from PEXA.
Senator, I won't go to the interconnectedness, I suppose, of interests between PEXA and the banks. What ARNEC does appreciate is that change for banks is it takes a significant amount of time, takes a significant amount of resources, presents them with additional risks that they would rather not undertake. Even generally, when dealing with them,
they've got comfortable market shares. Why would they?
Perhaps. Even when dealing with them on a registry basis, any change to their practice processes requires minimum of 6 months for the smallest of changes, and at least 12 months on average. So we appreciate on a practical level that it takes quite a lot of effort for them to change their systems. Interoperability will, and having a second LNO that they might also have to integrate with, will certainly trigger a change to their systems and a significant capital investment.
Just on notice, Ms. Bajendra, if I may, can you table for the committee the ABA's letter to ARNEC? Secondly, did ARNEC seek to test the ABA's response by going individually to each bank?
I'll take that question on notice.
And during the course of today, much of which you have heard, we've tested how much intellectual property there really is in PEXA's system. And it was the access to or the disclosure of that intellectual property which was the grounds on which the banks withdrew. So I'm keen to test those things. If you can, perhaps on notice, just elaborate on some of those lines of inquiry. Thank you, Senator O'Neill.
It's okay. Never let it said we can't work together in the national interest, Senator Smith. I just want to go to your submission, page 9 in submission 14. And there's one word that really troubles me, and it's under the item 51.4, better customer service. And it's competition between LNOs may lead to better customer service. We've also heard evidence from others that there could be an increase in costs with a change before we see any advantages. This isn't the only way that pressure on price could be put in. By regulation, there could be a forced reduction in the charges that are applied to vendors and purchasers by regulation. So is this just a lot of effort and a lot of money for a discussion about competition that may or may not deliver the outcomes that we want? And is a duopoly really that much better than a monopoly, or is there more risk?
I think our next assessment at this point, Senator, is that whether there's a monopoly or duopoly, there will still need to be strong regulation of the market.
By whom?
That is the open question, certainly.
Well, not from many others. They're putting you in it all day.
I appreciate the trust and regard people might have in ARNEC. ARNEC's remit is narrow and limited to
and so is your
the lodgement
budget.
register.
Small.
And so is that as well. I completely agree, Senator. It is critical for the Commonwealth agencies to come to the table and share some of the responsibilities for regulation. I think we observe all sorts of duopolies in real life, and they're just as challenging as a monopoly to regulate. I will also say that in the cost-benefit analysis, the monopoly regulation scenario is one of the options to be considered, as against the other models. So it will come out in that analysis as to whether it is worth the tremendous amount of effort that's already been put in.
I'll ask the next witnesses about the state legislative powers and what they need to sort of get more teeth soon. Thank you.
Senator Sharma had a question. He's joining us by telephone. Senator Sharma, are you there?
Yeah, I am, Senator Kim. Can I go ahead?
Yep.
Yeah, good. Just a couple of quick questions because I'm conscious of time. Firstly, the changes that were made to the electronic conveyancing national law in New South Wales in 2022, they mandate interoperability with LNOs, is that correct? Changes to the law?
Yes, Senator, that's correct.
Okay, and do they put a timeline on which LNOs should be interoperable, or is it when the law was given a sense?
Senator, in the interoperability project, there was a timeline for 2 varieties, I believe, of interoperable transactions. Before those transactions could take place, actually maybe one transaction took place. I'm testing my memory, apologies, Senator Sharma. There was a pause before the second could take place, but Mr. Cameron might be able to correct me on that one. Or I could, perhaps we take that question on notice and come back to you in writing.
Absolutely, accords with my understanding as well, Mr. Gendron, but happy to also take it.
Thank you.
So, I mean, I'm just curious, is the law as it stands in New South Wales being complied with currently or not?
As I
Because
understand,
there's not interoperability between
that's
the law
right.
mandates that it should be.
Just to clarify, actually, the electronic conveyancing national law mandates interoperability, so it applies to all jurisdictions, not just New South Wales. New South Wales has specific enforcement provisions in place. As it stands, because the interoperability program's been on pause, each of the jurisdictions have issued a waiver to both the operators, such that they're not in breach of the national law and the operating requirements.
I see. And are those waivers of a duration, or are they indefinite?
I believe they're an annual waiver, but I can come back with more detail on that one.
Okay, and who, if you could...
Yes, they are annual, my understanding.
Who issues that waiver?
Each of the registrars in each of the jurisdictions.
So yes, a waiver from each state and territory registrar for those jurisdictions in which electronic conveyancing is occurring. And just to clarify that the Northern Territory has gone live, so that is all jurisdictions in Australia.
Okay, thank you. And then just secondly and finally, the functional requirements review and the cost-benefit analysis, so those 2 pieces of work you're doing now, which I understand are expected to conclude next month. What are the sort of scope of possible outcomes you envisage from those without preempting their findings? I mean, what are the sort of maximalist and minimalist scenarios?
Thank you, Senator. We expect the functional requirements to provide a very good idea of exactly how interoperability, what changes are required to give effect to interoperability. The outcomes of that functional requirements will also go to the cost-benefit question, because the cost of implementing will be considered in the analysis. From the cost, so the functional analysis will inform the cost-benefit. The cost-benefit analysis will tell us if there is sufficient benefit to stakeholders in investing in the various models as against each other and as against a monopoly market. So at the end of that analysis, we hope to be able to make a decision as to whether we continue with interoperability Direct Connect or make a decision about whether we prioritise practitioner first as a stepping stone to full interoperability, or whether a monopoly market provides sufficient benefit to outweigh the cost of all of the other models, which is basically where we would like to be able to make an informed decision about how to proceed with the key principles, i.e. benefit to the community and benefits to stakeholders.
Okay. And if a decision was made, or depending on the decision that's made to proceed, how would it be operationalised? I mean, do you need legislative changes at state or federal level, statements of expectations to regulators, some sort of industry code? I mean, what are you envisaging as the operational instruments there?
It'll depend on the model. So, for instance, if Direct Connect ends up being the recommended model, we will need some form of enforcement. Well, government will need some form of some ability to be able to compel stakeholders, including banks, including any other participants, to comply and work towards an interoperable outcome. So they're certainly, even with if Direct Connect is the model, there will need to be some form of Commonwealth participation to compel parties to participate. If compulsion's required, it is theoretically possible, I suppose, for the banks to voluntarily participate, for PEXA to voluntarily participate, but
haven't got that vibe today.
No.
If we're just talking about the vibe.
Just the vibe. Perhaps not, Senator O'Neill. But yes.
Okay. Senator Sharma, can I just follow up on a couple of your questions?
Yeah, of course. I'm Senator Gibson.
Thank you. Can I just be very clear about the next steps? Do you need to do the cost-benefit analysis first before you then do the functional requirements? Because you have the 6 models there in your submission, which I was really surprised about. You said you don't actually know much about the 6 models, but we must know about a couple of them at least.
Senator, we've not done as much work with the other models as has been done for Direct Connect. Right. You know, there's quite a lot of rich data that we've uncovered over the last 5 years. And it's a very different scenario for the other models because we haven't done and dived in as much into those other models.
Right.
I might have forgotten the first part of it.
So the cost-benefit analysis of each model needs to be done first, then the functional requirements?
In an ideal world, the cost-benefit analysis would have come first.
Yep.
However,
I think it would make it easier.
We did not want to delay an outcome for stakeholders, very, very keenly aware that time is of the essence. And there were benefits to having a functional requirement being able to inform the cost-benefit analysis as well. So there was possibly no ideal order.
Concurrently?
But so they are being done concurrently, yes.
Right. Okay. Do you think that the functional requirements, just the amount of work that will need to be done to understand the functional requirements, will limit your selection of which model might actually be the best one?
At the current timelines, the functional requirements is well ahead, or a fair amount ahead of the cost-benefit analysis. So I think we've actually got further ahead than we thought we would in informing the cost-benefit analysis. So that can flow through from one into the other at this point.
Okay. And just finally, I'm acutely aware that we seem to be missing a pretty important voice in the room today, which is from the mid-tier banks and also the customer-owned banks sector as well. What's your interaction with those sectors?
We engage largely at the registry level with I believe it's called, I can't remember the acronym for it, but there is a council of banks or financial institutions that we engage with. I suspect we don't necessarily engage with them at the RNEC level. Mr. Cameron can correct me. Largely our engagement has been through the Australian Banking Association, which I understand covers the entire gamut, other than I think a small sector, potentially of community-owned banks, but I'm not certain on that one.
Okay, terrific. Are there any more questions for this witness?
That is through the ABA.
Oh, it's through the ABA.
Through the ABA, yes.
Are there any more questions for these witnesses? I'm conscious we probably need to move on. That was very helpful. Thank you very much, Ms. Bajendran, and thank you very much, Mr. Cameron. I'm sure that there will be questions on notice that you took today. We would ask that responses be returned by the close of business on Tuesday, the 16th of September, and we look forward to the outcome of RNEC's review processes as well. I would ask Mr. Cameron if you would now please disconnect from the teleconference. Obviously, you can continue to listen through to the hearing through the parliamentary website should you choose to do so. Thank you very much for joining us. And I now welcome representatives from Titles Queensland, New South Wales Office of the Registrar General and the Land Titles Office of Tasmania. Thank you very much for joining us at the committee today. I invite you, for the Hansard record, would you first of all please state your full names and the capacity in which you appear? We might start at this end of the table, Ms. Cameron.
Danusha Cameron, New South Wales Registrar General.
Thank you.
Neil Wachowski, Chief Operating Officer and Legal Officer for Titles Queensland.
And do we have someone on the telephone as well?
Yes, Craig Purcell, Deputy Recorder of Titles, Tasmania.
Thank you, Mr. Purcell. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. I invite you each to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions. Ms. Cameron, we might start with you again.
Thank you so much. Thank you, Chair and committee members, for the opportunity to present the views of New South Wales on this really important issue. So e-conveyancing we do see as a national success story. It's central to the most significant transactions that most people make, buying and selling their home. And a strong land titles and e-conveyancing system is an essential foundation to our economy in New South Wales and nationally. In New South Wales, almost 100% of e-conveyancing is electronic through an ELNO. So New South Wales supports effective and sustainable competition in the ELNO market. We seek effective competition in New South Wales, and stakeholders have emphasised that competition reforms should be implemented on a national basis. And so land titles registrars have worked in their jurisdictions and beyond for national competition. So without effective competition, we're concerned that the market will revert to a monopoly. This will, as has been mentioned, will still require effective regulatory scrutiny to ensure that the incumbent ELNO's market power is not exploited at the expense of buyers and sellers of property. But we are very concerned that the benefits of competition, such as greater choice and innovation, will be forgone. It is really difficult to regulate for innovation. New South Wales has consistently advocated for interoperability as the most effective and sustainable way to introduce competition into this market. This position is grounded in extensive consultation over a number of years, economic analysis and the experience of other networked industries, particularly in digital sectors. The reform, as we've discussed, has encountered challenges, and in particular it's been difficult for the RNEC program to analyse and settle appropriate arrangements between ELNOs and banks. The specific issue arose in relation to the scope of the data standard for interoperability. And Dr Nichols mentioned the importance of data standard in his evidence about competition for telcos. Looking ahead, we don't imagine scope would be the only issue. We anticipate there'd be other matters between ELNOs and banks which would need to be settled as part of implementing the reform. We welcome the ANIC reviews. I'm one of the co-sponsors on those and believe they'll contribute to more informed analysis about this issue. But as ANIC has noted, registrars have specific and limited powers to regulate, and we do not have the experience in relation to financial aspects of conveyancing transactions. The regulatory framework for e-conveyancing is asymmetric. So a conveyancing transaction involves, as you know, lodgement at the Land Registry and settlement with the banks. We have oversight of the Land Registry and the ELNO in that relationship, but there is not equivalent oversight of the relationship between ELNOs and banks. And there's aspects that focus on payments or financial settlement, but it's actually broader than that. It's all the relationship between ELNOs and banks. So the two challenges that confront us are linked. To deliver the interoperability reform to enable competition nationally would effectively require myself or another New South Wales official or from another state or territory to interpose themselves between ELNOs and banks to develop and maintain a data standard. That was the specific problem that confronted the reform in the first half of 2024. So, as I said, the challenges are linked. We seek effective competition across all states and territories, and we need oversight of ELNO bank arrangements to deliver this competition reform. These are both issues of national import and extend beyond land titles. So New South Wales believes there'd be strong benefits for greater Commonwealth involvement in relation to both those aspects, the role of banks in the reform and to market design and structure for what is a national reform. So we welcome the committee's consideration of these issues. As I mentioned, e-conveyancing is a world-leading reform. It's transformed how real property transactions are completed in New South Wales and Australia, and it is essential that reform continues to evolve to deliver lasting benefits for consumers and all who rely on our secure and reliable land title system. Thank you.
Thank you, Ms Cameron. Mr Witowski.
Thank you, Senators. On behalf of Titles Queensland, we welcome the opportunity to present to the committee on this matter today. So Titles Queensland is a relatively new entity that manages the land titles and water allocation registries on behalf of the State of Queensland in the capacity as operator, delegate and agent. So we've only been formed since 2021, so we are the new kids on the block. So in regards to e-conveyancing in Queensland, similar to other states, approximately 85% of Queensland's property dealings are lodged electronically through PEXA and Simply. And as the Senators may appreciate, the buying and selling of property and settling through digital channels now underpins the property sector in Queensland and Australia and is of increasing importance to it, as everyone else has sort of been advising. Now, from a Queensland perspective, returning to the previous paper-based process is possible, but is inefficient and would have major impacts on the property, legal, banking and related sectors, making effective regulation critical in this space. Now, while the evolution of PEXA and e-conveyancing more broadly is an Australian success story which we stand behind, the market is effectively operating with a single monopoly incumbent, PEXA. So, consistent with the position of the state, Titles Queensland believes that competition in the e-conveyancing market will support improved service offerings, lower prices, increased choice for consumers and drive innovation for a better customer experience. Now, a competitive market that supports multiple operators will also create resilience at an industry level by providing redundancy if one operator leaves the market or suffers an extended outage. Now, the example of the telecommunications market and its transformation from a government-owned monopoly demonstrates the benefits to consumers of healthy competition among multiple providers. Now, as multiple submissions to this inquiry highlighted, the e-conveyancing process involves both land titles lodgement and financial settlement, and there is currently no single regulator with a clear remit to oversee an end-to-end e-conveyancing transaction and with clear authority to regulate all participants in the e-conveyancing system. Land titles registrars do not have the required remit over the banking sector that effective national regulation would represent. So therefore, greater involvement and coordination between state and Commonwealth agencies is critical, and while discussions with the Council of Financial Regulators and ARNEC has commenced, from a Titles Queensland perspective, more formal coordination should be considered. So in summary, Titles Queensland does support the ARNEC submission and the consideration being given to 1, an appropriate end-to-end regulation of e-conveyancing by a single or coordinated regulator at a national level, and 2, the appropriate Commonwealth competition oversight of ELNOs to create resilience and competitive outcomes. So Titles Queensland believes it is better to regulate an industry or market than regulate a monopoly. That is why Titles Queensland, on behalf of the State of Queensland, supports ARNEC's interoperability program and the current reviews being undertaken to ensure this reform meets its original purpose and is not out of date before it's completed. So we welcome the Senate's consideration to this matter.
Thank you very much. Mr. Purcell.
Thank you. Good afternoon, Senators. I'm very pleased to be provided with the opportunity to speak on behalf of Tasmania, who has been an active member of ARNEC since its inception and has been involved since the COAG Microeconomic Reform Program of 2008 included the concept of a single national electronic conveyancing system. I am proud to also say that we've been active in national electronic conveyancing since August 2024 and that we are now receiving lodgements through a single ILNO at the moment, being PEXA. As has been confirmed in various ministerial statements issued by the Interoperability Ministerial Forum, Tasmania has supported and continues to support competition in the electronic conveyancing market. More specifically, Tasmania supports interoperability as a means of facilitating a competitive environment. Tasmania is an active member of the Australian Registrar's National Electronic Conveyancing Council and supports ARNEC's published positions on interoperability, including the recent pause and ARNEC's submission to this inquiry. It is incumbent upon the Tasmanian government to realise the benefits of participating in a national electronic conveyancing system and the promotion of competition through multiple ILNOs. Thank you.
Thank you, Mr. Purcell. I might kick off the questions here. Obviously, I'm very interested in the fact that each of you have made individual submissions to this inquiry, and that's additional to the submission that was provided by ARNEC. Can you just very briefly, each of you, tell me why you didn't rely on ARNEC's submission alone? Ms. Cameron, we'll start with you.
Thank you, Senator. So we absolutely endorse the ARNEC submission. I note it was much longer than our short one-pager, but because New South Wales was involved in the reform right from the start, it really started with Minister Dominello in 2018 and then expanded out to the rest of the states and territories. We wanted to the opportunity to note that role. Thank you.
And from a Titles Queensland perspective, almost exactly the same perspective, we were keen to emphasise our support for ARNEC, but also provide our own perspective and views to the Senate as well, and be available to answer any questions.
Thank you. Mr. Purcell?
Similar to the answers provided by my colleagues, we wanted to emphasise Tasmania's support of interoperability and recognising the work that's been done to date, that further work's required and we need the assistance of the Commonwealth government agencies. Thank you.
Thank you, Mr. Purcell. I wanted to ask Ms. Cameron, obviously New South Wales has an interim enforcement regime up and running now, but so far no financial penalties have been imposed for non-compliance. Is that right?
That's correct. So we have an enforcement regime that applies to ILNOs. So we continually assess ILNO's compliance and regulatory and then enforcement action that can be taken. To date, we have taken regulatory action by issuing a direction to ILNOs to engage in ARNEC's functional requirements review. We were monitoring their participation closely, and we're glad that we didn't have to take any enforcement action to respond to that.
I'm not suggesting that there was a reason to take enforcement action, but I'm wondering, is the fact that enforcement action isn't used more commonly a sign that the system is working well, or is it a sign that it's not beneficial to penalise for non-compliance when compliance seems to be pretty difficult in the current regime?
Yeah, so we would prefer to not. We would prefer that everyone complies as a starting point, and after that, we need to be thoughtful about how and when we use the powers. When there have been contested moments and the issues around intellectual property almost 18 months ago now were one of those, we considered options available to us and could have taken action, but chose not to because we didn't see that the action didn't address the main issue. We thought that the intellectual property, as Senator Smith drew out, we thought it was very thin, if any, the actual intellectual property claims. PEXA had not substantiated those, and so we didn't take action then, and instead the real issue was the structural imbalance and oversight of the banks, and so that's why we didn't take any enforcement action then.
One of the criticisms of having only one provider in the system is that if there's outages, there is no sort of alternative rails that are ready to leap onto should this critical infrastructure be unavailable. PEXA's testimony, though, is that any outages that have occurred in recent times, only a small percentage of those have been their outages. In fact, the land titles officers have sometimes had outages of their own. Can you just give me an indication from each of your states how many of those outages that have been referred to, particularly by Simply, I think it was about 93 or something, 95 perhaps, how many of them have been caused by or have been outages that have originated from your particular land titles officers?
Thank you. In terms of the land titles office, actually, I think the answer's none, but I might just take that on notice and come back if that's incorrect. The majority that we're aware of in New South Wales are from financial institutions and potentially our State Revenue Office, but again, I need to check that on.
So banks and state revenue officers as opposed to land titles registers.
I think I've got the details here. It's mainly the banks or the ILNOs. I would just need to check if there was any that related to the State Revenue Office.
Okay. Thank you. Mr. Kwiatkowski?
Yeah, from a Titles Queensland perspective, that's my understanding, the same for Queensland. Right. But I'll take that question on notice and confirm the facts definitively. There may have been one or two minor incidences from our registry, but I believe that they're minor if any do exist, so I'll report back.
Okay. Thank you. Mr. Purcell?
Zero in Tasmania.
Thank you. All right. Can I just ask before I pass on to colleagues, terrific to have New South Wales and Queensland and Tasmania represented. Do you have a sense of why the other states, WA, Victoria, South Australia, haven't also stepped up, and I suppose that the territories as well, have not submitted or wanted to appear today? I know I'm asking you to speak on others' behalf, but is there a feeling? Are there gangs? Are there different types of registry officers? Does one state gang up another state? How does this work?
Maroon jersey.
Sharks and Jets.
We do. But
no, I'd say ARNEC is very collegiate, actually, and so I wouldn't describe it I don't perceive anything of what you're describing there. I think it was just our jurisdictions felt we had something particular to say, and the others were happy to support the ARNEC submission.
And that'd be my perception as well, that all the various jurisdictions are keen to support the ARNEC submission. So it was a very collaborative effort between all the registrars drafting that document and obviously submitting it. I think in our federated model, every jurisdiction does have its own particular perspective, but not to the detriment of a collegiate approach. I think a credit to ARNEC, the fact we've got so far is a testament to how they've managed to collaborate in a federated model. That's not to say from a Titles Queensland perspective, we don't believe there's a lot more work to do, a lot more resourcing and investment required across Australia in this space. But I think credit where credit's due.
Thank you. Mr. Purcell, do you have anything to add to that?
Nothing to add, no, thank you.
Thank you. Senator Darmanin.
I wonder, my questions probably are for Queensland and Tasmania who are here. When I look at, in terms of New South Wales, you've got some enforcement powers, whereas Queensland and Tasmania do not. There's also the Legislative Council Select Committee that's recently been established to look at exactly the same issues I think that we're looking at here, with a hearing scheduled for the 5th of November. So obviously, you know, there is a difference in approach in various states, and so I guess firstly from Queensland and Tasmania who are here, you know, you've identified further requirements that can be addressing some of the concerns at a federal level. But I'm interested in why the states haven't followed suit of what's happening in New South Wales at the very least, as a first step to bridge some of the gaps. If you could talk through that.
I can maybe commence. From a Titles Queensland perspective, we are collaborating with our fellow ARNEC colleagues on new enforcement powers that have that national remit. To achieve that national remit does often require a level of compromise and discussion and collaboration, and really to nail what's required, you've got to get effectively all those 8 jurisdictions to all agree on the wording and what that looks like. New South Wales, our understanding, has decided to pursue its alternative piece of legislation. From a Titles Queensland perspective, we actually don't disagree with the New South Wales model and the quantum attached to their enforcement powers. From a Queensland perspective, we are keen to have further enforcement powers and to actually have a stronger regulatory remit. So we're not opposed to New South Wales charge here, but we're currently pursuing the collaborative ARNEC approach.
And Tasmania?
From Tasmania's point of view, we've only recently actively joined electronic conveyancing, being August 2024. So our level of maturity is far different from New South Wales. And remembering that the Australian Registrar's National Electronic Conveyancing Council is a number of regulators, we cannot bind, and we try not to bind other jurisdictions to decisions and wait for ARNEC to move. New South Wales, I believe, saw a need to introduce that legislation far quicker than the legislation that's been worked on, as Neil has identified at a national level. And as we know, 8 jurisdictions sitting around a table trying to agree to legislation is taking a little bit longer than anticipated, because we want to make sure that we future-proof this as well. And part of that is making sure that interoperability is adequately covered. And this is probably one of the rare opportunities that we get to try and catch up with the regulatory framework where it needs to be going into the future. So agree that New South Wales has a different level of maturity, and ours is different.
Thank you. And so for then New South Wales, Ms. Cameron, what will be the, do you know, I mean, I guess you can't kind of foresee what the outcomes of your own state select committee recommendations might be, but in terms of, I guess, the work on the national, I don't know what term we use, but the national work that's going on, have you thought about what impacts that will have on what you already have on foot and what is happening in New South Wales, and kind of taking Mr. Witkowski's point around a national position may involve compromise? What's the New South Wales view on, having moved early, what might happen and where you will go next?
Yes, and just to set some context, as you know, the National Electronic Conveyancing Law is an applied legal scheme based in New South Wales, so the updates for the enforcement regime will need to go through the New South Wales Parliament that approved the regime back in 2022, or different parliament actually, and so we're very aware of that. The main difference between the New South Wales regime and the national regime that's being developed is the addition of enforcement powers in relation to subscribers. So at the moment, our New South Wales regime only applies to LNOs, but the ARNEC one applies to both LNOs and subscribers. We would very much, want to make sure that our regimes are consistent, and would need to do the legislative arrangements to make sure that those align. There are different views on some aspects, and as I think Neil and Craig have both alluded, reaching agreement among 8 jurisdictions around the table on each element of it can take some time. So, yeah, we will continue to work through that process.
Okay. We have heard, to some degree, I think, in response to some of the questions from Senator O'Neill around ARNEC challenges in terms of resourcing. Just wondering, to any of you who might answer this, whether you've thought about this challenge of resourcing of ARNEC. As part of the intergovernmental agreement, have you looked at has there been any discussions about different options about how ARNEC might be funded, cost recovery models, or, how you assist them to become more effective in terms of a national approach?
Yes, so it's a problem we've been working on for some time, a number of years. We're very grateful to Titles Queensland, actually, who has really picked up the bulk of the work around our procurement and our resourcing. So the arrangement is Titles Queensland engages people who then work on behalf of ARNEC. So that's helped us to build up a bigger team of ARNEC Central. But we're very aware that we don't have the bandwidth to deal with the issues that confront us, even within the remit that is ARNEC. As was mentioned earlier, the regulatory review will be a really significant piece of work, but it will take a lot of time, and part of that, I think, is the resourcing challenge. So it's something we continue to look at, looking at different models, different structures, and that's work that's ongoing. Yeah.
And I'd probably add to that, Senator, in the sense that in being, I suppose, the new kids on the block, Titles Queensland could look at the ARNEC structures and the resources and funding, and almost it's easy to see it outside or being new players to the team. And at an early stage in our analysis, we did realise that there's more resourcing and support, the structure needed. So it's definitely been a firm push from Titles Queensland to try and support ARNEC, to try and help with those strategic decisions around what structures ARNEC should take and evolve to in the future. How does it adequately resource itself? How does it adequately engage with Commonwealth entities to actually raise the flag as required? Even how does it adequately engage with its own Treasury departments in each state and territory to sort of raise the importance of this sector to the property sector in Australia? So it's definitely been a firm push from Titles Queensland in conjunction with ARNEC trying to address those issues. And I think to the Senator O'Neill's prior just question marks around how resourced our teams. From a Titles Queensland perspective, we have, I think, about 10 dedicated staff working on it in our regulation team, focused on what this looks like and how we can support it. We've also got that ARNEC Central team that's really trying to supercharge the consolidation of ARNEC activities. And we are quite committed to actually an ARNEC 2.0 and what that looks like. It's obviously still being debated what that does exactly look like, but these are the active considerations that ARNEC's trying to understand how to be that effective regulator and how to operate at that national level. Because while we all represent our states and we approach things from that state-based perspective, we appreciate that we're operating in a national environment. And PEXA and Simply, they do want those national solutions, not just the state-based solutions. So we're all cognizant of that fact while trying to protect our own state interests as well.
Can I just ask, how's your funding allocation each year determined? Is it a clip on the number of transactions, or is it?
So Titles Queensland is probably a bit more unique than the other, I suppose, regulators, in the sense that we manage our own finances from our own revenue sources. So we've got from the transaction volumes. So there's the fees that are paid for the transactions, and every dealing has a transaction fee attached to it. And I imagine every state has the exact same sort of model.
Is that the same for you in New South Wales, Ms Cameron?
We have a separate structure. So our land titles registry is now held by a concession, a private operator, and so they receive the income from search volumes. So we're just funded from consolidated funds, and then each jurisdiction then contributes to ARNEC according to the proportion of dealings they do in that year. So New South Wales is 28, 29%. Victoria is slightly higher, I think, in some years. And so we look at the total volume of dealings, and ARNEC sets its budget as to what we need to achieve for that year.
I think the ARNEC budget is now 5 million. I think it's 4.9, around 5 million is the ARNEC, I guess, consolidated budget. And then there's also each jurisdiction has its own, I guess, staffing profile, in-kind support, legal advice that it obtains and kind of feeds into the ARNEC pool. So it is one of those. I appreciate why it was a tough question for the ARNEC team to sort of answer, in the sense that there is that central ARNEC budget, but then each jurisdiction has its own teams and in-kind support they provide.
So maybe a mud map with, funding allocations for all of that. But if you're going to set your budget for the work that you need to do, does your budget need to be 10 million or 15 million acquired from all of the states through a special requisition for you to do this work?
If it is, sorry, Janisha.
But my assessment is actually the biggest challenge for us is having the right expertise around the table, and then we would be able to set the right budget and use that money well. I think the biggest challenges for us at the moment are understanding, how do we do competition reforms, and even within our world, the separation rules within the model operating requirements. That's a competition protection, and we've done a review on that, but we need to do a whole lot more work on that. And so, to me, it's more around having the right expertise to know how to set the parameters, ask the right questions, and then setting.
Well, you can't see what you can't see, right? And there seems to be incredible points of blindness in the way this structure exists.
There's a significant gap in relation to the Ilmo Bank arrangements. Yeah.
And if it assists the Centre as well, from a Titles Queensland perspective, both Titles Queensland and New South Wales engaged a review into interoperability and basically talk to all stakeholders on an individual basis to understand their concerns, talk to the LNOs directly, and every LNO did engage quite strongly in the process. And one of the findings of our investigation was, to your point, around the governance, the resourcing, even the structures of the interoperability program. So it is almost that we did a detailed analysis and a detailed review, and any rebirthing of a interoperability program does need to look different than it did before, does need to be resourced with the right expertise in play. That does need to include that banking sector side of the equation. So that's sort of the outcome of that analysis.
If I may, so when we hear the word resourcing, it could be interchangeable with the word upskilling. So it may well be that in other regulators across the country there are suitable skills, experience dealing with significant market players like banks and others that could be provided to this particular project that would be able to support it without it just being a simple transfer of funding necessarily. You'd agree with that?
Yes, definitely. And I think overlaid on resource and funding are questions of jurisdiction. And so I think even within ARNEC there are different views on the extent to which registrar and titles registrars should become involved in ILNO bank arrangements. So some take a more interventionist view, and some take a very no, we shouldn't get involved view. And so when you're trying to run a complex reform, trying to solve each question through a council of 8 registrars is difficult. And so when we, again, to Dr. Nichols' example of a data standard for the telco, that was the ACCC was the regulator there, and that's one entity, whereas we have 8 jurisdictions that we need to kind of work through for every issue. So that's another aspect.
So in suggesting, as you have for stronger Commonwealth involvement, Ms Cameron, in suggesting, as you have Mr Wiskowski, for more financial cooperation to be considered, and Mr Purcell, considering, as you've said, the need for assistance from Commonwealth agencies, is it right that if there is greater Commonwealth involvement, those states that have a less interventionist perspective might be willing to give up that less interventionist perspective in exchange for greater Commonwealth involvement? Or will those philosophical policy divides continue to exist even if there was greater Commonwealth intervention?
My sense is that, to Senator O'Neill's comment, there are gaps that are perceived, and there's a question within registrars of how much we push into those gaps. But if regulators in the Commonwealth who understand this area so much better than we do were able to come in and fill that gap, I think that would work well for everyone.
And it does go to the age-old answer of we almost can't speak on behalf of the other jurisdictions. Which is part of the problem at times.
So I understand. So New South Wales, Queensland, and Tasmania, how have your superiors how have your political masters communicated to the Commonwealth your willingness and desire for greater Commonwealth involvement? I don't want to use the word intervention, greater Commonwealth involvement. How has that been communicated? Treasurers in your jurisdictions have written to the Commonwealth Treasurer. How has that been communicated? You might want to take that on
I might take that on notice. Yeah, thank you.
That would be... Now, Ms Cameron, you mentioned that the IP claim that had been made by PEXA was thin, to use your word. Is that the IP claim that is the subject of the letter from Kate Camilleri to the banks, in regard which precipitated their withdrawal from the interoperability program?
I haven't read that letter, Senator, but when we looked at, while we didn't have the benefit of knowing the integrations between PEXA and the banks, when we invited PEXA to explain their IP, substantiate their IP claims, and they never did so in detail. They never substantiated the claims. From the outside looking in, we didn't think the IP claims created an insurmountable barrier to interoperability, because our data standard is about data moving back and forth. So we needed to know the data items and when the timing and sequence for those, but then what each ELNO does with that data is, yes, up to that ELNO. And so the data standard was designed to enable each ELNO to preserve its IP, its appropriate IP and confidentiality, while at the same time enabling this reform. And so the functional requirements review now is actually, so that was our perception back last year. The functional requirements review now is going into that in much more detail under confidentiality arrangements and with the reviewers between PEXA and the bank. So those discussions are kind of happening at the moment. But our sense was that the IP claims could be addressed. And we're not an insurmountable barrier. Yeah.
Thank you.
Craig Purcell from Tasmania.
Sorry, Mr. Purcell, I missed that.
Just wanted to add on to Ms Cameron's comments. There has been a misunderstanding amongst stakeholders that Simply would become PEXA 2, in that they would have the same set of functionality being provided through Simply with the same look and feel as that through PEXA. That is actually the antithesis of innovation and competition. What we're wanting them to do is to enter the market and be able to interact between systems, but still have the flexibility and the ability to provide specific functionality and services to their customers, their clients. We're not advocating that they have to have the same look and feel, the same colouring, the same levels of access or anything like that. And there is some apprehension out there that that's what we were looking for, and that's not the case. Thank you.
Thank you, Mr. Purcell.
Senator O'Neill?
Just from a New South Wales perspective, if I think about the oversight of ASIC work that we've done, over the years it's been, through PJC, it's been discussions about being a regulator, being an enforcement agency, being a regulator, being an enforcement agency, sort of depending on the zeitgeist of the moment. The sort of passive language of being a regulator is about, it just seems about information flows and observing. Enforcement is far more active. Can I ask questions about enforcement capacity and your practice around that? And I'm not quite sure how long you've been with the entity, Ms Cameron. That might give us a bit of an insight into how long you've been watching this happen.
Yes, so I took this role in 2022, but before that I was with OIG since 2017, so let's have some background. In this, so we have our enforcement legislation. We have published an enforcement policy on our website for ELNOs and subscribers. We are our approach is to seek to set the regulations at the right level and assess whether ILNOs are complying with those. And so, for example, in addition to the legislation and the operating requirements, which we've already spoken about, we have licence conditions in New South Wales. And so we have, and those are ones we do separate to ARNEC, and each jurisdiction has an equivalent. So we have set those in New South Wales, we publish them on our website, we refresh them. So we're in the process of refreshing them now. And so it's through that uplift in regulation that we seek to improve what ILNOs are doing. In terms of taking enforcement action...
Can I just come back to you with that as an observation from my own profession of teaching, that a syllabus document can contain things, but their enactment.
Yes.
You know, there's the plan.
Yeah.
Then there's the operationalising.
Yeah.
And then there's the learning, and there's a big gap sometimes between creating a document and putting it there with a set of expectations, and without you can have a carrot. And it's going to be in the interest of sustainability of the whole sector. All of those things are in there. But without a stick, a lot of people just go, oh, lovely, thanks very much, I know where it is, see you later.
Yeah, yeah.
Is that what's happening?
It's not how I would characterise it. So at the moment, with each of the ILNOs, my team has monthly governance meetings with them, and they go through in detail things like outages. Why did the outage happen? How did we know what was the source of it? And even if it was at the bank, how is that going to be addressed? I meet with the senior leadership every month as well to address issues. We work through things on a New South Wales basis that we're concerned about, but we also need to maintain the ARNEC dimension as well. And many issues cross borders. And so where an issue arises, we perform our own New South Wales assessment of it, and then we also collaborate with colleagues in ARNEC to see how they assess it. So it's...
How many ILNOs do you interact with?
Just the two of them.
What about the third one that was proposed?
LexTech. So they were granted an operating licence, I think, in some jurisdictions, but they didn't approach us in New South Wales for an operating licence.
And we've had up-close and personal interaction with the potential duopoly that are advancing their case today. You've had a much longer engagement with them. In your interactions with them and with the requests that you make of them, can you make a comparison between the technology investments and the manifestation of that between PEXA and Simply? Do you see enough to give us a comparison?
So PEXA began in 2010, 2011. That's when it started building. And so that's the genesis of its technology, whereas Simply started building in maybe 2018. And so our perception is that Simply's technology is being built more recently, and PEXA's technology is older than Simply's. Our current...
So old can be fantastic if it's more established, more tried and trusted. New can be wonderful if it's innovative and solving different parts of the problems that the sector faces. Are they both of similar quality, and do they both look like they've invested similar amounts of money? Like, are they really genuinely comparable? Like, no, who else is going to be able to tell us this information?
I think one way we'll find out more about the investment. So our IPART, our Independent Pricing Regulatory Tribunal, is currently doing an assessment into ILNO pricing at the moment.
Yep.
And we expect them to go really deeply into ILNO's investment, both that they've invested to date and into the future. So that work is underway, and then feeds into analysis of price setting. In terms of the only other comparison I have is our experience of the interoperability reform and the ease with which each ILNO is able to absorb changes to their system that they needed to make to integrate with the other ILNO through the APIs. And our perception is that Simply found that easier than PEXA did, who had a more complex system to manage.
Okay. In terms of outages, simply hasn't been able to operate at a level to give you a volume comparison. But if you were to bring it back to a 1% sample and a 1% sample for a comparability test, how would you go with outages, failure points, etc., at the same comparability level in terms of number of interactions?
I mean, there have definitely been. Again, I'll take on notice how many outages in each. The challenge with providing that comparison is the differences are so huge. Like, it's less than 1% to over 99%. So even one outage at Simply would have to have many more outages at PEXA to be comparable. So I don't think I can provide a useful comparison.
So what could New South Wales do to make it more possible for compliance with your directions as a regulator?
At the moment, the direction we've given, the specific direction we've given was for the functional requirements review, and we understand both LNOs are complying with that. So we monitor that through the program that's overseeing that review. We're doing a lot more work around reporting of incidents and outages, and so there's better clarity around what needs to be reported, what impacts performance levels, and we're currently uplifting our licence conditions to require better reporting from LNOs, including clearer root cause analysis, those types of things.
And if they don't comply, you're caught in the tricky situation of not being able to take their licence away from them, because otherwise the whole show would fall apart. What sort of fines are you looking at, and are they covered by legislation or regulation?
Yeah.
What scale do they exist at?
So the first step we do is, under our enforcement regime, there's a remedial direction, or LNOs can give an enforceable undertaking, so that's the first step. And the remedial direction, if it were an outage, would be around fixing what's gone wrong. Are we comfortable with the remedial action they've taken, and also to make sure it doesn't reoccur?
So if it happened yesterday, when would you be talking to? If that happened yesterday, would you be talking to them yesterday or today or tomorrow, or are we talking months in between the outage and the response from the regulator?
So they need to give us a post-incident report. And
in what time frame?
I think it's one of the things we're changing in our licence conditions at the moment, I think. And we then assess what they're doing to fix it. And then if we're not, and to date, the rationales have been valid, as we've spoken with our tech experts, the way they're fixing the issues. But if they didn't take the appropriate action, then we could issue direction under our enforcement legislation, and if there was a breach of that, then we would go to the Supreme Court, and there'd be financial penalties. So that's the kind of sequence of events for our enforcement regime.
Okay, and who covers the cost of going to the Supreme Court?
We have a litigation team as part of my team.
So that the public purse pays for the litigation?
Yeah, it would be part of the litigation function we have as part of the Torrens Assurance Fund.
And what is the scale of penalty?
It's up to $10 million. I should have this memorised. It's, there's a
per transaction? Or? If you want to take
that on notice,
just expose a little bit about, so we can get the sense of what is the cost of doing business.
Yeah.
Ignoring the regulator is the cost of doing. I just have to pay $10 million every now and then, but we don't think any of them. You haven't actually charged PEXA anything. You haven't.
We need to go to court, and the court imposes a penalty.
Has that occurred?
No.
So there's no precedent of this process actually being enacted.
That's true.
So we've got no costs around it. So at the moment, it doesn't operate, so it can't be a deterrent for bad behaviour, except by threat.
Yes.
And do you think the threat is so good, appropriate, that that's led to proper behaviour by the sector, or is the sector just saying, well, they can't do anything anyway and they do what they want?
That's not our perception of what's happening.
Okay. How would you characterise it?
We monitor their compliance with their obligations under the licence conditions and the operating requirements. If there's a breach, we assess that in New South Wales. If it has national reach, then we assess it as part of ARNEC, and then we take the appropriate regulatory action.
Which looks like what? And maybe you can provide us with some correspondence that fleshes that out, and that might give us a sense of the timelines of that action as well.
Yeah, I'm happy to take that on notice.
Thank you very much. Maybe the same thing for ARNEC. Thank you, Chair.
Thank you, Senator O'Neill. Senator Canavan has a question.
Thank you, Chair. Just one quick one from me. I have heard allegations that PEXA's dominant role in the marketplace gives it access to data that otherwise yourselves, the registries, would have. Do you end up in any way competing against PEXA in data, like in control of data, or the information, the value of the information that you would otherwise receive from property transactions?
Is that to me?
I'd like to direct that question to Senator Canavan.
It's not directed to anyone, whoever might feel that they're most capable of answering.
As a Queenslander, why don't we start with you then?
Yeah. So from a Queensland perspective, I think every LNO is only permitted to sort of use the data for the purposes of their workspace and the purposes of running their system. If an LNO wishes to use the data that they receive from a jurisdiction for any other purpose, we would characterise that as a value-added product, and they'd need to seek our permission they need to seek permission of their respective jurisdiction to do something different with that data. So that's how we would characterise it from a Titles Queensland perspective.
Craig Purcell from Tassie. Just in relation to the data that's entered by subscribers to the LNOs, that data is their data up until the point that it gets lodged with us for registration purposes. That isn't data that we, the Land Titles Office, owns until it's registered with us. And as mentioned before during the ARNEC session, but we do have separation provisions in the model operating requirements aimed specifically at ensuring that they do not use that information to their advantage because of the unique position that they have. So we do have some system of regulation of their ability to use information that they get provided with either from the Land Titles Office or through them being an LNO.
Are there any more questions, Mr.
Thank you, Chair. No, thank you. So just coming off mute, but thank you.
All right. Thank you very much to all of those who have presented here from the titles offices in Queensland, Tasmania and New South Wales. We will let you go. There were some questions, though, I think that were to be taken on notice. So the return of those questions, the answers to those questions is expected by Tuesday the 16th. Sorry. Yes, Tuesday the 16th of September. We will let you go, and that includes you, Mr. Purcell. Would you please come off the line? You can continue listening to the hearing, but you have to do that by the parliamentary website. Thank you very much.
Thank you.
And I now call upon our last witnesses today, representatives from the Australian Competition and Consumer Commission, representatives from the Department of the Treasury, the Competition Division, and also the Australian Prudential Regulation Authority. Thank you very much to all of you for appearing before the committee today. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you, and for the Hansard record, I'm going to ask you to please state your full names and the capacity in which you appear today. I might, rather than doing it across the table, I might do it by department. So can I first ask those of you that are appearing on behalf of the Australian Competition and Consumer Commission to identify yourselves?
Thank you, Chair. Nicole Ross, Executive General Manager of the ACCC's Infrastructure Division.
Thank you very much, Ms. Ross.
Matthew Schroeder, General Manager of Infrastructure and Transport.
Thank you very much, Mr. Schroeder. Is there anybody else on this list that is from the ACCC? No, thank you. All right, those that are appearing from the Department of Treasury Competition Division who are joining us on the line, would you please identify yourselves for the committee?
Yes, it's Anna Barker, Acting Assistant Secretary of the National Competition Policy Branch in the Competition and Consumer Division.
Thank you very much, Ms. Barker. And finally, from APRA.
Good afternoon, Chair. Ian Beckett, General Manager Policy in APRA.
Thank you very much, Mr. Beckett.
Ben Mowat.
Sorry.
Ben Mowat, General Manager.
Thank you.
Strategy and Governance.
Thank you.
And lastly, Alison Bliss, General Manager of Non-Financial Risk.
Thank you very much to all of you that are appearing today. I'm going to ask you two favours. The first is whether you could take yourselves off speakerphone if possible and make sure that you have your phone very close to your mouth so that we can hear and understand you in the room and for the Hansard transcript. And I'm also now going to ask you to whether you would like to make an opening statement, and at the conclusion of any of the remarks, of your remarks, I'll invite members of the committee to ask questions. We might start with the ACCC.
Thank you, Chair. We're happy to move straight to questions.
Thank you. Ms. Barker, do you have an opening statement on behalf of Treasury?
No, happy to go with questions, thanks.
Thank you. And Mr. Beckett, Mr. Mowat and Ms. Bliss, do you have anything, an opening statement on behalf of APRA?
No opening statement, Chair. Happy to go to questions.
Okay, thank you very much. I might kick off. Can I just ask Treasury first and foremost, Ms. Barker, what's the government's engagement been on this particular issue? And has the government, I should ask, provided you with any instructions about how to engage with this inquiry?
Thank you, Senator. So the Commonwealth does have regular engagement with RNEC members through quarterly cross-agency e-conveyancing meetings. That is the RBA, APRA, ASIC, the ACCC and ourselves. And we are working together to consider the role of the Commonwealth to address issues in this sector. We're also, in my role in the National Competition Policy Branch, we do work with the states and territories on competition matters and matters that could be progressed through national competition policy. So through that, we engage regularly with our state and territory counterparts to look at issues that are of mutual interest. So they're the two main ways in which we've engaged on this issue.
Thank you. The submission from Infotrack, which you might have seen, states that around the time of June 2024, Minister Lee indicated that the federal government would only step in once RNAC had used all of its available powers. So I'm wondering whether Treasury has a view as to whether that has now occurred. Has RNAC used all its available powers?
Thank you. So, as you know, as has been discussed today, RNEC is undertaking a number of reviews, and the view is that these are very important reviews to understand the best way forward in terms of policy options available to try and deal with competition issues in this sector. So our view is that it's very important for those reviews to play out, to understand what the issues are and the costs and benefits of those issues and the way forward from there.
Okay. So noting some of the my colleague Senator Smith said that delays in this issue are actually a commercial advantage for some of the players. Has Treasury tried to preempt that in some way, shape, or form? Has Treasury got a view of what federal intervention might look like?
I mean, we've been considering different options that have been put forward by the market in the way that others have, but we don't have a particular view on the way forward in light of the processes currently underway.
Okay. I might go to Senator Darmanin and then we'll come back to Senator Smith. Senator Darmanin.
Thanks. Just to follow on around the National Competition Policy Framework, I wonder, I note that you're looking at the work that ARNEC's doing at the moment before, I guess, coming to further conclusions. Just more broadly, I wondered if you could talk about how and by whom are reforms prioritised and what kind of factors you'll consider when you're looking at the national competition policy framework. Just to give us a sense about where this might fit within the broader context.
Yes. So the latest lot of national competition policy reforms have been progressing since we first started talking with the states as part of the competition task force that started in August 23. And through 24, we looked at different types of reforms that could be progressed with states and territories with support from the Commonwealth. And largely that support is in the form of payments upon implementation of reforms. So that was worked up into an agreement through last year. And through that process, we did undertake a scan of potential reforms that could be undertaken under national competition policy. And I guess the suitability of the reforms are issues where it's a state and territory issue specifically, where they have the policy levers, where it's a type of reform where the policy effort is for the states and territories, but there's a benefit to the Commonwealth in terms of growing GDP and improving competition. And that was the scanning that was undertaken through last year and continues to be undertaken. First looking at what sort of reforms are out there, but also undertaking work, commissioning, the Treasurer's commissioned the Productivity Commission to undertake quantitative work to inform those decisions, specifically looking at the benefits that could come from the types of reforms being proposed. So e-conveyancing was one of the ones that was looked at in the context of the PC report through 2024. And obviously different things factor in, but one of the things is the types of benefits that would come from these reforms. Whether there's clarity, I guess where we wanted to start was where there was more reform clarity as to the way forward so that we could get some early wins with the states in implementing reforms under NCP. So they were the types of factors that went into that consideration last year. It's an ongoing process, so there will be further reforms added to national competition policy, and we're still undertaking that work with the states and territories through this year.
Thank you. A question for the ACCC. To the extent that you've looked at this question, can you talk about the differences and the, I guess, relevant pros and cons between interoperability, access models, and price regulation and I guess with examples might be helpful.
Sure. I mean, firstly, the ideal would have been to have created a competitive structure before you privatise PEXA into that structure that would have had competition safeguards and interoperability. The first best would be to have interoperability because that promotes competition. We've seen that with telecommunications, but it stands to reason. If you privatise a monopoly or a near monopoly without the regulation, it becomes very difficult to unscramble the eggs afterwards. So I'd say that's the first point. Where you are now, as you would expect us to say at the ACCC, the ideal would be to have competition, but whether you can have substantive competition or not is a question. If you end up with either a monopoly or a de facto monopoly, then the monopoly should be regulated. There's issues around costs. There's issues around the amount of innovation that will be undertaken. There's issues that have been spoken about recently around information and issues around vertical integration as well. When you have a monopoly in one part of the industry and you can use that monopoly to leverage markets upstream and downstream from your monopoly. So if it is the case that we are going to end up with a monopoly, then absolutely that monopoly should be regulated. But the first best would be to have competition and interoperability through competition. Yeah. The ACCC has been involved in this for a decade, let's say. And we've been consistent in our approach and our support for competition, and we believe that interoperability was the way that we could get that competition.
Okay, so a decade down the track, and cognizant of, I think, a numerous set of witnesses who've said that the longer there is not a resolution to this issue, the more difficult it is, I guess, for the more difficult it will be to break a monopoly. You know, what is your assessment about the opportunities to, like, are we flogging a dead horse on the question of accepting there is a monopoly or not, given, you know, the other options that have been put, or the kind of interim step around, it was this morning, the access model to begin with as a first step and then moving down the track. Like, it feels like there needs to be some action taken at some point soon. But like, what is your assessment, having looked at this for 10 years now? You can say in an ideal world what it should be, but given where we are, what's your view?
Well, you are talking about over time as well. So you're right that the longer it goes on with the near monopoly, the more difficult it is to have competition there, because potential competitors will see that there's no hope and will be spending money and lose money and end up leaving the market. And we have seen reduced interest by some of the potential competitors because of the delays. Again, though, I don't know that we're in a position to be the authority on whether it's too late to have that competition or not.
Just a clarifying question before we just jump off that. Yeah. Is a duopoly that much better than monopoly? How many people or how many entities for the size of the market do you think it warrants?
Yep. So if you're talking about what would be the best for consumers, a duopoly is better than a monopoly. Multiple providers would be better still. I don't know that there's huge amounts of economies of scale in the provision of e-conveyancing. If, a railway network has natural monopoly characteristics, you wouldn't want to be having 4 different railway lines parallel with each other operating. That's not really the market that this is. So I don't think that there's major diseconomies of having multiple providers. So it would be better to have multiple providers if that can be done.
I would add that certainly we recognise that given where we are at this point in time, the steps that need to be taken are not simple, that it will be difficult, and you've heard from other witnesses about some of the challenges in looking at the regulatory regime.
But also, it also seems that, perhaps there's a picture being painted by some at least that there is a deliberate strategy to delay in order to protect a monopoly. But that is not an inevitable outcome, is what not necessarily the case.
I mean, I couldn't speak to what the motives are behind what's been going on. I think, the dominant player would have an incentive to delay, as we said, because that embeds their position. But I wouldn't be able to comment on the motive.
Just maybe a question for APRA. We've heard about some of the challenges, particularly around the interoperability infrastructure, particularly around finance in this particular example, and that's the kind of key sticking point. Have you seen successful examples elsewhere in the banking sector where some of these challenges have been overcome? And if so, you know, what are the markers of success to achieve what we're trying to get to here that we might be able to learn from?
So I'm not sure that we've seen any similar examples. I mean, we, as APRA, our statutory mandate is to regulate banks, insurers and superannuation funds, and our focus is really on protecting depositors, policyholders, members and maintaining financial stability. So that's the focus of our regulatory effort. We don't regulate financial infrastructure. I mean, that's a role for ASIC and the RBA, and we don't regulate non-financial infrastructure. Our main interest in these types of institutions flows from the fact that banks rely upon them to carry out their business. And so we put various obligations on the entities that we regulate to ensure that their third-party service providers are able to provide a reliable service so that people we directly regulate can maintain continuity of service.
Okay. Last question from me, just in terms of the applicability of CPS 230 in this sector, and are there any observations or engagements that you've had that would suggest particular concern that this inquiry should know about, or, you know, kind of more broadly, risks around e-conveyancing risks for us here in Australia?
So CPS 230 came into law for banks on 1 July this year, and we expect or we acknowledge that PEXA will be a key service provider to banks through that regulation. What we would say is that it is one of many key service providers to banks, and that's quite a broad range, including electricity suppliers, IT providers, cybersecurity providers, telecommunications providers, and that we look at third-party providers through a lens of risk. So we're a risk-based regulator. So in terms of whether we would be worrying about this particular service provider, we'll look to indicators of risk, such as reporting of breaches to APRA that's required under CPS 230. And what I can confirm for the committee is that since CPS 230 came into play on 1 July, we have not received any incident reports relating to PEXA or relating to property settlements. So that would indicate to us that our focus would be best spent on areas of greater risk, such as cyber risk and technology providers.
Is there what's the threshold for the reporting of those risks?
So there needs to be an incident that takes that particular operation of the bank outside of their tolerance levels, and those tolerance levels are set by the board in accordance with the risk appetite of the board.
Okay, so it's possible if we're talking about what might be conceived as quite minor risks to the board of a bank around a delay of a couple of hours or a day in terms of a property settlement, but quite major risks for an individual buying their house and all of the kind of arrangements that go around that. They might not actually meet the thresholds that would necessarily be caught by what you're looking at.
Yeah, and that would be because of the focus that we have on financial stability and, you know, the prudential nature of that bank.
Yeah, okay. Okay, thank you. Thanks, Chair.
Senator Smith.
Thank you very much, and thank you for your participation today. We are here because we're dealing with a difficult problem. We're not here because we're dealing with an easy problem. So is the ACCC concerned about the emerging risk that we've heard today from vertical integration?
We are always concerned about vertically integrated monopolies, because they have the ability and incentive to utilise their monopoly position in one sector to unfairly compete in other sectors. So as a general principle, that's
right.
The case.
So in regards to this particular sector, prior to today, was the emerging risk of vertical integration by PEXA on the ACCC's radar? So
we have discussed it internally. I think, as you heard from the RNEC contributors before us speaking, there are some, and the Queensland representative was talking about some of the restraints they have around the use of the information. That gives some comfort that they wouldn't be able to utilise their monopoly position. But yes, I would say
that's you have been able to establish some comfort based on what you've heard today, or some comfort because of the investigation or inquiries that you have made prior to today?
Some comfort because there are restrictions at the state level on the use of the information.
To the Treasury, you talked about a scanning exercise. Am I correct or incorrect to assume that e-conveyancing matters are on a list of reform initiatives being considered as part of the National Competition Policy Review process and mechanism?
Thank you for the question, Senator. Yeah, as you would see from the PC's report last year, it was one of the reforms that has been considered in the mix, and is still, there's no particular public process for taking things off and on the list, but that is one of the things that was modelled through last year as one of the potential options through NCP.
Has the National Competition Process mechanism formally met with PEXA or Simply or RNEC to examine these e-conveyancing issues in greater depth?
So we don't usually meet as a group with stakeholders, with all the states and territories, but the Competition Task Force has met with Simply in the past to understand the issues. So that's been several times, and we've obviously discussed these issues with state and territory treasuries. We have not met with PEXA.
That seems rather strange that you wouldn't be meeting with the incumbent. Why haven't you met with the incumbent?
Well, we've met with the ones with issues with the current situation to understand what those issues are. But we've been waiting for the current RNEC processes to play out to understand what the possible route forwards are for different reform options.
That's not the answer to my question. Why have you not met with PEXA? Have you been instructed not to meet with PEXA?
No, PEXA hasn't requested a meeting.
No, of course PEXA won't request a meeting from the National Competition Policy Review.
Yeah.
I mean, it's a shame you're not in the room because there are a lot of smiles around at the moment. Of course PEXA's not going to ask to meet. They are the incumbent operator.
Yes. Yes. We have not met with PEXA.
You talked about the RBA, APRA, ACCC and Treasury meeting regularly to consider the issue. How regularly has it met? What's the Can you just elaborate a bit more on?
That's a quarterly meeting.
It's a quarterly meeting. And how has, and specifically in regards to e-conveyancing or in regards to financial regulation more generally?
Sorry, the quarterly meeting is on e-conveyancing with ARNEC.
On e-conveyancing. So how many quarterly meetings have happened?
I would have to take that on notice.
And which stakeholders has this group of four, this gang of four, which stakeholders has this group met with? Obviously, Simply.
I would have to take that on notice, but
has it met with?
I don't think we.
Has it met with PEXA?
You mean collectively together?
Yes, collectively
or
together.
Separately?
Collectively together. Yep.
I'll take that on notice.
Okay. You mentioned that you were waiting for the ARNEC review processes to conclude. There are 3 ARNEC review processes. There's the functionality report, there's the cost-benefit analysis, but then there's the uplift in the regulatory reform initiatives. How is Treasury, the RBA, APRA, ACCC engaged in the third of those inquiries, which is the regulatory uplift work?
My understanding is that's dependent on the completion of the first 2.
So you're not engaged at the moment on the regulatory impact work?
I don't believe it has commenced, but I would have to check with others, and maybe others on the call could also answer for their organisations.
Is there any information you can provide to the committee on the regulatory uplift?
My understanding, Senator, is the reviews are underway.
We don't have a formal role.
We don't have a formal role, but we do engage where appropriate and requested.
Who makes the request?
Would come at the staff level. I would expect that we would hear from ARNEC.
Yourself, okay. We heard from Tasmania, New South Wales and Queensland in various forms their request for stronger Commonwealth involvement. The ACCC's aware of that request?
We are aware of the request. The ACCC does not have a formal role in respect of e-conveyancing. We do, as Mr Schroeder has indicated, we have been involved and provided advice from time to time to parties and state and territory governments as they look to progress the work.
So how has the Treasury responded to the views or the requests of New South Wales, Queensland and Tasmania for greater Commonwealth involvement?
As I said, we are engaging with ARNEC through those regular meetings, and we are engaging in the process of the reviews. So we have been engaging.
2 things have become very clear to this Senate committee during the course of today. One is a sense of urgency. The other is the emerging risk of vertical integration as a result of a lack of regulatory action or intervention. Do officials, so the Treasury, the ACCC, APRA, agree that not addressing these issues with some urgency will lead to further entrenchment of PEXA's monopoly market position?
Who is that question to, Senator?
The ACCC, APRA and the Treasury.
Okay. From our perspective, I guess it's a trade-off. You want to get the rules right. I think, yes, as time goes on, the near monopolist becomes more established, and as we mentioned earlier, that can be a concern, but you also do want to get the rules right. ARNEC as the regulator needs the resources and a credible threat of regulatory action. So you need to have gradations of penalties, and it needs to be a realistic threat. I think it's important that they get the structure right and the rules right and be able to take those sort of actions. So it is a trade-off in terms of wanting to move quickly, but also wanting to get the right rules that are appropriate for the market as it is now, and have a credible threat of regulatory, or if you want to say enforcement action.
And that was actually, that statement you've just made was pretty much the final statement in Ms. Ross's letter in regards to the ACCC provided some broad advice in regards to this e-convey. I don't unfortunately have it on my screen. I did have it for much of today. I think it was perhaps 2019 that letter was provided, or Mr. Schroeder?
It would have been from me in that case.
Okay. Okay. There was an ACCC letter that particularly, you're familiar with the one that I
was the contact person on that letter.
Okay. Thanks very much, Mr.
2019.
Schroeder. So we have ARNEC itself, but its composite parts, Tasmania, Queensland, New South Wales, asking for assistance, upskilling, additional resources. We have everyone recognising that there's a challenge of inaction, and that challenge of inaction is the entrenching the incumbent's position, and a consequence of that is the emerging risks of vertical integration. So why is it that the Commonwealth seems to have a hands-off approach? I'm a federalist. I am not a senator who regularly relies upon or calls upon Commonwealth intervention in matters. Sorry?
You're a Western Australian senator.
Correct. I like to empower states, decentralisation, devolution, etc. So it is unusual for me to come to a conclusion that says here is a very, very necessary, urgent opportunity for Commonwealth assistance. I don't want to use the word intervention. But everyone in the Commonwealth seems to be taking a hands-off approach, but the consequence is self-evident to everyone. Entrenching a monopoly, entrenching an incumbent operator, future vertical integration. I just don't understand what's going on. I mean, what is not being said here?
So I wouldn't categorise it as no assistance. The letter that we provided, or the report that we provided in 2019, was giving advice. We don't have...
Is that the Sims letter? Because Mr.
Yes.
Mr. Sims read a letter as well. That's right. I don't have it in front of me. The former ACCC chair.
Yes. So we don't have a regulatory role here. We have tried to provide advocacy support around what a good regime would be based on our experience. The states created PEXA.
Correct, yeah.
The states have responsibility for conveyancing and for property under the Constitution.
Correct, yeah.
So they're the appropriate level to be regulating this. We have provided advice to them, but ultimately the regulator, ARNEC, needs to have the resources and, as you're saying, the capability to undertake this. But that's not a decision for the ACCC.
Okay, so Mr. Schroeder, if the ACCC was asked by one of its political masters, right, or its political master, right, what is its view about the necessity or the requirement to have a greater role? Would it be the ACCC's view, as you have said, this really is a matter for ARNEC itself and the various states, and the answer to this is upskilling it rather than formal Commonwealth intervention?
These are starting to sound like policy questions.
Let's pretend they're not.
Well, I would say, again, property and conveyancing is the responsibility of the states.
I think I hear what you're saying. How soon do you think, let's assume no action, no intervention, no substantive progress, how soon do you think that the risk of vertical integration becomes obvious?
The risk of vertical integration? I mean, I think you have a risk of vertical integration. That
when do we see it? When do we see a substantive impact? When do we see it realised? 12 months, 24 months?
It would be speculation. I wouldn't be able to say.
But it's a risk.
Well, as I mentioned earlier, having a monopoly, one of your concerns would be that they would utilise that monopoly power to access markets using their monopoly power into other related markets, and we've seen this with other industries.
Just turning finally to APRA and the APRA CPS 230, does APRA audit that particular regulation?
So APRA is undertaking a program over the next 3 years of prudential reviews to look at compliance with CPS 230. And that begins in a couple of months' time.
And how does it roll out that particular program over 3 years? How does it prioritise which entities get dealt with in the first year, the second year, the third year, for example?
So it's a risk-based approach, and in the first year we are focused on the larger, so significant financial institutions in our regulatory block.
Would that include the 4 banks, ANZ, National Australia Bank, Westpac and Commonwealth Bank?
That will, yes.
In the first year?
That's correct.
In the first 6 months?
In the first 12 months.
Item 32 of that regulation says an APRA-regulated entity must ensure that operational risk incidents and near misses are identified, escalated, recorded and addressed in a timely manner. An APRA-regulated entity must take incidents and near misses into account in its assessment of its operational risk profile and control effectiveness in a timely manner. Does APRA go out to regulated entities in advance of a formal review or audit to ensure that that particular requirement, identified, escalation, recorded, is actually done, or will that only be considered as part of the 3-year review, of which you've said the 4 major banks will be reviewed in the first year?
So we will look at that during the reviews that will take place in the first year.
Thank you. Thank you.
I'm just going to follow on from a couple of Senator Smith's questions. May I start with APRA? Does APRA have any concerns with regards to the bank's ability to comply with CPU 230 or 230, as has been suggested today?
So I think based on our engagement with banks so far on CPS 230, we don't have any material indications of concerns around complying with 230, we will obviously, as indicated, be able to come to review as we undertake these prudential reviews over the course of the next 12 months.
Okay. And just to the ACCC, and following on again from Senator Smith's questions, I'll be a little bit more explicit. In simply supplementary submission to the inquiry, it stated that PEXA had sent legal letters to the New South Wales government and that the major banks had been threatening legal action in operability, that PEXA had sent legal letters to the New South Wales government and the major banks, and that it had threatened legal action in the interoperability reform if the interoperability reforms were to be pursued, and that this particular action continues to be assessed by the ACCC. Is that correct?
We have had a series of concerns raised with us in respect of anti-competitive conduct, Senator. I don't think we've been asked to look at that specific matter other than in the question of whether it's breaching Part 4.
Right. So what's the nature of the assessment that's being done by the ACCC?
So we've had a number of concerns raised with us in respect of anti-competitive conduct in e-conveyancing markets. We have completed a range of assessments of those concerns. We have not identified a contravention of the Competition and Consumer Act in respect of those. We generally don't provide a significant amount of detail or commentary around confidential investigations, but I can advise that in respect of a number, we did not identify a contravention when we looked.
Can I ask something which comes to the crux of this inquiry, which is a monopoly inherently a bad thing?
A monopoly typically has an incentive to price higher than it would in a competitive market and generally supply less than you would see in a competitive market. So in that sense, you can expect less consumer benefit in that environment than you would see in a competitive market.
Does a monopoly inevitably misuse market power?
It certainly has the incentive and ability to.
If appropriately regulated, can a monopoly be prevented from misusing market power?
I wouldn't say as an absolute, but you can certainly reduce the likelihood and the possibility and the scope of the misuse of that power.
Okay. Let me just be really clear. Is the ACCC conducting any formal investigations into PEXA right now, either for, you said not necessarily for the activity that I've mentioned before, but for any other misuse of market power?
Senator, I would take that on notice. As I say, we generally don't provide information around confidential investigation, so I would want to consult with my enforcement colleagues before providing that information.
All right. That was my last question. No more? All right. I can't believe we're going to finish almost on time. In fact, on time. That's quite extraordinary. Senator Sharma has dropped off the line, Senator Canavan has dropped off the line, and Senator O'Neill has left the building. So I think you are off the hook. Thank you very much to all of you for appearing today. If you took questions on notice, and I think that all three of the departments there or regulators did, we ask that those responses are provided to the committee by close of business on Tuesday the 16th of September. Thank you very much for joining us, those via teleconference. You can drop off should you choose. And that concludes today's hearing. I thank all witnesses who have appeared, to Hansard and to Broadcasting for their assistance. And again, to any witnesses that are listening in, any questions on notice are due by close of business Tuesday 16th of September. The committee stands adjourned. Thank you very much.